Good morning, or should I say hear ye for day 24 of the Karen Reed retrial. It is Friday, it's May 29th, and we are getting into the defense case. But first, the attorneys are going to argue that motion to dismiss that we see at the end of every prosecution case, or we do unless the defendant's pro per forgets that that's a thing. These are generally denied because all of the evidence is taken in the light most favorable to the prosecution because they're not moving for it. And the standard there is, could any reasonable jury on the evidence find the things as charged, find the crimes as charged? And the court, again, will look at the fact that one witness, if believed, can establish any one fact. And if those facts have been established by a witness, if the jury believes that witness, then can this case go forward? So you really only see these granted when there is no evidence to a particular fact. And in this case, we do have witnesses. Again, a lot of you are like, yeah, but I don't rely on that witness. I know you don't have to. For the purpose of this motion, all of the could it be this swings in favor of the prosecution. But we're still going to hear the attorneys argue. We're going to get to hear how they see the evidence at this point. And I'm curious to see how the prosecution articulates their case, because we know how the defense articulates their case. I think the defense has been very clear in how they articulate the case. The Commonwealth has not been as clear, and it's changed a bit. I think the defense, though their defense has shifted, it's pared down. The prosecution case has swung more. So we're going to go see that, and then we're going to get into the defense case in chief, because today is the day for the defense case in chief, and we're going to see the defense calling their tech expert who's new to this trial first. So that's the first thing we're going to do. So, law nerds, are you ready? It's time to go to court. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. Also, they went to sidebar immediately. So we're not even really behind real time much, because they went to sidebar immediately. Did I not say it was May 30th? I thought I said it was May 30th. Did I say 29th? I might have. And if I did, it's May 30th. Apologies for everyone who's like, are we back a day? I don't even know anymore. We've been in trial for 6 weeks. I don't even know. So they went immediately to sidebar forever. So we skipped the sidebar, and we're just coming right in to Jackson arguing for the defense on the motion. So let's go.
Thank you, Your Honor. We filed this morning a motion for required finding of not guilty under Massachusetts Rule of Criminal Procedure 25A. I think that's before the court. My comments will be relative.
So, a required finding of not guilty, motion to dismiss, call it what you want, depending on jurisdiction. This is what it's called in this jurisdiction. It is a motion for the court to say no juror on these facts could find these charges. That is what the motion is for.
Relatively brief, but it's important, and the points that I'm going to make in the next couple of seconds or next couple of minutes are equally important.
Next couple of seconds. I think it's going to be longer than that, Jackson.
The Commonwealth
seconds
simply
matter.
Not proven, even in a light most favorable to them, that there was a collision on January 29th, 2022 at 34 Fairview in Canton, Massachusetts. There was no collision proven to have occurred. There was no eyewitness presented. There was no video evidence, no audio evidence, no evidence in the form
there was an expert,
of
and the expert
physical evidence at the scene by searches that were done by officers on the morning of January 29th, 2022.
If they believe the expert,
the Commonwealth, through suspect experts based on circumstantial technical data,
I don't disagree, but
only sought to prove a backing event, and that's important. They sought to prove that at 34 Fairview, the SUV went backward. They did not prove, and every single one of their experts was asked this question, they did not prove that there was actually a collision associated with that backing event. The Commonwealth experts said at best that the car went in reverse, and it was suspect whether it went in reverse at 34 Fairview or some other place, time, or date.
They really did skip over
Commonwealth
that
also
quite a
put on an
lot.
expert
They just
who
kind of
said
went, yeah, that was at 34
that she
Fairview.
found no injuries, none, mind you, indicative of a vehicle strike on John O'Keefe's body. And she, Dr. Irini Scortibello, was arguably their most important witness. The Commonwealth cannot and
They
did not
disagree with that.
say or prove a collision at a particular time, a collision at a particular place, a collision with a particular person, or
tried.
that a collision even occurred on January 29th, 2022 at or around or at or after 12:30 in the morning. Their own expert, I think it was yesterday, if not the day before yesterday, was asked on examination by Mr. Alessi, can you tell
Not
us the
Alessi.
particulars of the collision, pardon me, as you suggested
There were too
in
many
your
factors.
testimony? And his answer was, there's simply not enough evidence. He was asked specifically, why didn't
many
you try to
unknowns.
recreate the circumstances, the force impact? That's what you do, sir. You're a biomechanic expert. Recreate it for us. And he said, there's not enough evidence.
Ashley, open a window.
There
It's
is evidence,
lovely this
however, that
morning.
Brian Higgins and
So
Brian Albert
good.
were sparring at 34 Fairview. There is evidence, however, that was just minutes, not hours, not days, minutes before John O'Keefe ultimately met his fate
I don't
at
think we have
34 Fairview.
evidence of that in this case.
There is evidence that Brian Higgins was love-struck, that he was jealous, that he was aggressively coaxing John O'Keefe out of the waterfall, that he was passively aggressively coaxing Miss Reed to engage with him rather than John O'Keefe. Again, there was not a single eyewitness to a collision. There was not even a single eyewitness to a backing event at 34 Fairview. The court will recall Jennifer McCabe testified that she basically watched the SUV the entirety of the time it was in front of the
That's not exactly what she
location
said.
at 34 Fairview with Miss Reed in the driver's seat. She saw it pull up once. She saw it pull up twice. She saw it pull up a third time. And then she saw it was gone. And at no time, did she ever see the car go in reverse. She certainly didn't see the SUV go in reverse at a high speed. And she darn sure didn't see the car go in reverse at a high speed and strike a pedestrian.
Darn sure is restrained. She definitely didn't see that.
Her focus was defined enough to see thin tire tracks in a dusting of snow, thin enough,
That's a really good
I think
argument.
the phrase was, to track a cat.
Cat track.
That's how detailed she was in her observations, yet she did not see John O'Keefe hit by an SUV. She did not see John O'Keefe's body
I think
in
it's
the
a great
snow,
argument.
in the yard, laying prostrate, a 216-pound, 6'1" man
Dressed in dark
in the
clothes.
snow, directly in front of the SUV. She was tracking the entire time.
If you can see the tire tracks,
There are
how do
two
you
other
not
witnesses,
see John O'Keefe?
Ryan
It's
Nagel,
a good
Heather Maxson.
argument.
They both noted that John O'Keefe, not that they didn't see him, Your Honor, that John O'Keefe was not in the vehicle when they were behind him. The dome light was on. They could see inside the interior of the vehicle. Miss Reed was sitting there with her hands at 10 and 2, and the passenger seat, notably and markedly, was empty. He was not outside the vehicle. He wasn't standing. He wasn't sitting. He wasn't lying down. There's only one place he could be: inside the curtilage of the home, inside the house, or inside the garage. Not one witness that was inside the house, not one passerby, not one neighbor, not one plow driver ever saw John O'Keefe's body laying prostrate in the snow that morning. Not one. Not until Karen Reed found Mr. O'Keefe at about 6:03. And again, the Commonwealth's chief medical expert, Dr. Scortibello, their medical examiner, who's the only person that the court heard from or will ever hear from who actually investigated John O'Keefe's physical body, the only person to have physical access to John O'Keefe, testified he did not have any injuries consistent with being struck by a vehicle. But she did indicate that the injuries, as did the firefighters, the first responders, indicate that he had injuries consistent with a physical altercation.
That's not exactly what he said.
And certainly,
and that's not exactly what she said.
As to
she did
counts
say that
1 and 3,
injury to the back of the head could be consistent.
no
with
evidence has been presented or proffered whatsoever by the Commonwealth that Karen Reed intended to run over and harm
that is a strong
John
argument
O'Keefe
as well.
in any way, shape, form, or
Where
fashion.
is
Hearken to the video
the malice aforethought
at
element.
C.F. McCarthy's. Hearken to the video at the waterfall. Every witness confirmed what our eyes could see. That night, John O'Keefe, Karen Reed were loving, caring, affectionate. There's absolutely no evidence that Karen Reed had an intent to harm John O'Keefe, or that she that after the fact, that she intended to leave him for dead, because there was no fact to be after.
Knew.
There was no collision in the first place.
You can't prove she
Commonwealth's
knew
case,
and then chose to leave.
certainly on counts 1 and 3, taken separate from count 2, because of the mens rea associated with counts 1 and 3.
Yeah, count
fails
2 is a
miserably.
whole different pickle.
The Commonwealth, at the end of the day, has presented their best case. They've done their best. Some would say they've done their worst. And their case has failed. No reasonable jury, hearkening back to the standard under Rule 25, no reasonable jury could find Karen Reed guilty of count 1, count 2, or count 3. But taking count 1 and 3 aside, those are separate counts because of the mens rea required and the high burden that's required, even taken in the light most favorable to the Commonwealth. What evidence have they proven that Karen Reed intended to kill or harm John O'Keefe, or that she intended to leave him for dead in the snow? The answer is none, 0.
The mens rea argument is a strong argument.
Could find Karen Reed guilty. This case never should have been brought in the first place. There are reasons that I won't go into here. The court knows those reasons, or knows our position on those reasons. This was a vindictive prosecution, and I believe that the court is duty-bound pursuant to the precepts of Rule 25A, as well as the principles of justice, to dismiss all 3 counts. And certainly, taking count 1 and count 3 aside, the court is duty-bound to dismiss those 2 counts.
I'm curious to see how the prosecution argues the other counts. And for those of you asking, yes, the court could remove some of the counts, not all. That is less uncommon than removing all of the counts. The court could drop some of the counts, and it's the aggressive fucking paper flipping. The court could remove some of the counts, but not all. That is not uncommon. Getting rid of the whole case is uncommon. Paring down the counts is not uncommon. We're going to see it probably happen in the Diddy case if the prosecution doesn't remove counts, if all the victims don't testify and there's a count to each of them. But I don't remember if there's a count individually to each of them. What they were talking about in the counts 1 and 3 being different than count 2 is the mens rea, the intent, the intentional acts. How has the Commonwealth proved what Karen Reed was thinking? What evidence would allow a jury to conclude that she intended to kill John O'Keefe as to count 1 and knew she had injured John O'Keefe with her vehicle and intended to leave him there? So that's with counts 1 and 3. Count 2 is a whole different beast. It has multiple lesser includeds. It does not require the same intent. And it is going to be a more difficult case and a more difficult count for the defense. I'm interested to see what the prosecution argues with regard to the mens rea. I imagine it's going to be I hit him, voicemails, interviews. That would be my guess. But let's see. With the 3-piece suit on the first day of the defense's case from Hank Brennan.
Light most favorable to...
And the light most favorable to the it's like the standard's the same everywhere. It is.
In a light most favorable to the Commonwealth, the first issue the court should look to is intoxication. a reasonable fact finder would find that the defendant was in fact intoxicated. Based on the serum conversion
Serum?
and based on Karen Reed's statements herself,
I don't
you've
disagree with
heard
that.
many admissions by the defendant about her level of intoxication, which far surpass.
Are you just going to go through the elements? That would be lovely. Just go through the
She
elements.
consumed alcohol in a way that would affect her ability to operate safely. Those are just two of the cornerstone pieces of intoxication, which are clear, light, most favorable to the Commonwealth, a reasonable fact finder could find beyond a reasonable doubt. The evidence of collision is abundant. I do not want to go through an entire closing argument or
Please do.
rhetoric, but suffice to say there are taillight fragments from the defendant's own Lexus, from her shattered right taillight, that are found in Mr. O'Keefe's clothes. Mr. O'Keefe is left at the very spot where she expects to find him, according to her statements, where her car does a backing maneuver at least 24 miles per hour. He is left with injuries on his arm consistent with the damage to her Lexus right rear taillight. The scientific data is substantial. Telestream data, Apple Healthcare data, battery temperature data. And again, Ms. Reed's statements herself about clipping,
Statements.
hitting. The evidence of a collision in this case is overwhelming. It is a public way. Lieutenant Gallagher told us about
An element.
Fairview as being a public way. And so as to the operating under the influence of alcohol manslaughter,
Count
the
two.
conduct of driving in that forward and backing maneuver after being intoxicated meets clearly the standard for OUI manslaughter.
That's what he's going to argue.
Regarding
with count
second-degree
two.
murder,
I was wondering what act they were going to argue. The backing up 85 feet at up to 24 miles an hour. I'm surprised you didn't talk about the 75% depression on the pedal. That's what they're going to argue for the count two, which I've been wondering because they didn't talk about it at all last time. All right, let's continue.
as highlighted in my opening statement, the defendant engaged in intentional conduct that was her maneuver of driving forward, stopping, and then driving back to Mr. O'Keefe on January 29, 2022. Under the conditions at night after being intoxicated, that conduct was intentional, and any reasonable person could find that her conduct that night created a plain and strong likelihood of death. There is no predicate of intending to kill or even intending to hit. There is clearly a plain and strong likelihood of death driving a 6,000-pound SUV forward and then back. In addition to state of mind, again, the defendant tells us herself. Through firefighter Becker, they're arguing, they're upset.
Right.
We see the text messages, evidence of attempted breakup, and we hear the words of Karen Reed when she leaves numerous voicemails that night, and you can hear her voice. There are statements, I do not want to go through a summary of all of them, but statements from the defendant herself where she acknowledges an injury to Mr. O'Keefe. She's the last one with him, where to find him, and her hypothesis about hitting and clipping him.
You guys have some great
As
questions.
to
I'm
leaving
holding
the
them.
scene,
I'm holding them.
again, the defendant tells us that when she leaves, he doesn't look mortally wounded. She leaves him, makes dozens and dozens of calls, but never goes back to help him and leaves him to die. And we heard from Dr. Wolf about the life-saving procedures that could have been initiated. The chance of survival was never given to John O'Keefe. All of those facts suffice under Lattimore, a light most favorable to the government, that a reasonable fact finder would find beyond a reasonable doubt, or could find beyond a reasonable doubt, each and every element of each and every one of these charges.
All right, thank you. So the motion is denied as to all three indictments. On the other topic that we were discussing at sidebar, I don't need to hear argument on that right now, Ms. Giannetti. I'd prefer to get started. I would like you and Mr. Brennan to talk to see about proposal. Right. So are we ready to bring the jury in? I did not ask you at sidebar. Are you ready for this witness, Mr. Brennan? Mr.
I'm ready.
Okay, so.
Thank you.
All right, so we'll bring the jury in. That will take 5 minutes, Paul. All right, so we'll take the recess.
All rise, please.
And it's time to bring the jury.
Bring the jury.
All of you are like, that's a real fast answer. Yeah, it's a real fast answer. Why? Because the judge has been taking notes the entire trial and has the evidence to the counts in the light most favorable to the Commonwealth. Most of the time, those motion to dismiss answers are as fast as that. So they are going to be bringing in the jury. There were a few questions that I grabbed there because there were great questions in the chat. We'll get to some more later. Christy said no intent. How is that first degree? It's not. They did not charge a first degree murder. They charged a second degree murder. So when we went through the charges, which has been a minute now since we went through the charges, but we have the second degree is what requires intent. I think they have a very long road on the second degree. I think it is way overcharged, but you know that from how I've talked about it. Raya Sun said, Emily, do you think he is more focused on count two? I think he will in closing. I think Brennan will focus more on count two in closing and then talk about the I hit him in the voicemails to see if he sways anybody towards count one, which is the second degree murder. I think he'll focus on count two. And then if there's jurors who are convinced of count one, they could compromise to count two. But I'm not surprised at the court's ruling. I said that yesterday that the court was going to deny this. I think the defense has stronger arguments. They're going to be arguments made in closing because the intent is, I think, a difficult one. But when you take everything in the light most favorable, if you take every statement of Karen Reed in the light most favorable to the prosecution, if you take every statement of first responders, every statement of everyone, every statement on the voicemails, if you take all of them the way the prosecution wants you to see them, which is the standard for that motion, then that's how you get to that being denied. So that is not a surprise in this case, though I think there are strong arguments, as I've said, for the defense. We will see where we go because I think count two is a problem for the defense. We'll see if that shifts. J. Michael RN said, positive thoughts today, taking the boards. Best of luck. And also, you've got this. Just deep breaths. For those of you asking what my shirt said, I saw a lot of you say, what does my shirt say today? I don't give a damn about my bad reputation. It's my shirt from seeing Joan Jett. I had to. Because why not? Emily, you have a bad reputation? Yeah, I get called a nerd a lot. I don't think it's a really bad reputation though. We'll at some point talk about my experiences in junior high. We'll talk about that later, but that's a whole different thing. But I love it. I loved seeing Joan Jett. I loved it. I was just, we had to do. I don't give a damn about my bad reputation today. I'm going to have to wash the absolutely not shirt. I feel like it's going to come up more. So as we continue, I need to hear more about this, Miles.
Yay. All persons have any business before the Honorable Beverly Cannone, Justice of the Norfolk Superior Court, and for the country of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
I mean, Joan Jett is a fucking icon. Her voice sounds amazing. It was great to see her. For all of you that have met Joan Jett and said she's fabulous, I love hearing it. I love hearing it. Look, man, I definitely relate. We didn't have women's water polo when I was in high school. We did after I graduated because there were too many women inundating the men's team when the younger generation came in and the coaches were like, shit, we need a women's team. But I relate. I was like, I don't give a fuck. I'll fine. You don't have a women's team? Okay. Let's go. Was that helpful at all of 5'6"? No. Did I do it anyway? Yes.
I do have to ask
Love
you those
Joan
three
Jett.
questions. Were you all able to follow my
Love it.
instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively.
Did we
You
mind
also
picking a male-dominated
followed
field
instructions
in law?
and
No,
doing any
it's
independent
fine.
Research or investigation into this case. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? As you know, yesterday the Commonwealth rested, and as you know, the defendant has absolutely no burden of proof in this case. Does not have to put on a case, but I hear that you are. So, first witness, please, Mr. Jackson.
But I hear that they're gonna. Yeah, they're gonna. I saw a number of you ask, look, how is this going to take a week and a half to 2 weeks? The defense has a ton of witnesses on their witness list. They're not going to call everyone on their witness list, just like the Commonwealth did not call everyone on theirs.
Thank you, Your Honor.
We're going to get into a new witness for the defense, according to what Karen Reed said after court yesterday. It's their tech expert.
I would ask that Matthew DiSogra join us.
Okay.
Disorder. I'm not going to be able to stop. The way that closed captioning called disorder, I think, not DiSogra, but disorder is not disrespect. It's just in the pretrial motions, the court was like, disorno? What? DiSogra, disorder. We'll see. So I'm here for it. This is a new witness. Courtney Witherspoon in the chat said it's not DiSorno. A lot of you did. I'm sorry, Mr. DiSorno. We'll go with disorder instead. All right, we are on defense witness 1, day 24. We had 38 witnesses for the Commonwealth, less we will have for the defense. I like the suit. He's kind of matching with
All right, Mr. Jackson, whenever you're ready.
Thank you,
The
Mr.
blue
DiSogra. Could
with,
you please
the
state your full
prosecutor.
name and spell your last name for the jurors, please?
Sure. Matthew DiSogra, last name DiSogra.
What do you do for a living,
DiSogra.
sir?
I am
Thank you. DiSogra. Thank you. Disorder. Chat. Already? Y'all, this witness has been on the stand for 4 seconds. The other witness broke you. The last witness broke you. The last witness broke the chat. And for that, dishonor on the last witness for breaking the chat.
I'm a licensed professional engineer. I practice in the field of accident reconstruction. And within that field, I specialize
Tech.
in analysis, interpretation, and accessing all types of vehicle data.
How are you currently employed?
I'm employed by Delta V Forensic Engineering, which is an engineering firm that specializes in accident reconstruction, all parts of accident reconstruction.
Tell us a little bit more about Delta V. What is it? What kind of company is it? But other than that specialty, what else does it do?
So accident reconstruction is a broad field. There are a lot of subspecialties within that. So
Look, I appreciate that they are going to challenge the last experts from the Commonwealth right off the bat before they get into the rest of the case. And then I would imagine bring ARCA at the end for the biomedical and biomechanical engineering, because the timeline is what the defense wants to focus on, right?
accident reconstruction is everything from the initial investigation phases of a crash all the way through testimony, like here today. Some of the specialties within that could be things like biomechanics, could be human factors, and my specialty is data, vehicle data and event data recorders.
Staying on that topic, what is your current title or position with Delta V?
I am the Director of Engineering for our EDR services line.
What does
Sir?
EDR services mean?
So
Sir, please don't talk about spreading loads. The chat will lose their fucking mind. We can only do so much, sir.
event data recorders. So EDR is a general term we can use to talk about all types of data from all types of vehicles.
And how would you describe your role as the Director of Engineering for EDR services for Delta V?
I wear a couple of different hats. First and foremost, I'm still a practicing engineer. I still conduct investigations. I still perform analyses, and I testify. On top of that, in the director role, I oversee a group. It's not just me doing this kind of work. I have 3 other engineers that work with me, all specializing in EDRs. So I oversee that group and focus on kind of the day-to-day operations as well as the direction we're going. You know, with things like autonomous vehicles coming, the role of data is growing. So
Yep, the role of data is growing a lot.
Future in a lot of those ways.
You are not wrong, sir.
As a consulting engineer, you've indicated what your specialization is. Do you specialize in motor vehicle accident reconstruction as well as vehicle system analyses?
I began my career at Delta V doing traditional accident reconstruction in the broadest sense. And as I have progressed, I have sort of narrowed myself down and now specialize in that. But I still consider myself an expert in accident reconstruction because ultimately,
No, please finish.
Ultimately, anytime we're doing EDR or data analysis, it is part of an accident reconstruction.
You talked about event data recorders. Do you
just opening my
also
window, y'all.
engage in the specialty of advanced data recovery
day.
methods? In other words, methods of pulling the data. It's one thing to have it sitting in a car. It's another thing to pull it out and make it useful, correct?
That's right. There are a lot of different ways data can be accessed, all the way from just plugging into a port on a working vehicle, all the way through when a vehicle is catastrophically damaged and even the modules themselves are damaged, accessing the data at the chip level. So no matter what condition a vehicle or the remnants of a vehicle are in, generally we can still get the data from that.
Do you have any specific knowledge about Toyota data?
I do.
Describe that for us.
Beyond Toyota being a common vehicle in general, so we run into that data quite frequently. Just this year, we published a paper specifically studying some of the behaviors of the additional data recorder that's in Toyota vehicles.
Does Toyota make another
helpful.
sub-brand, for lack of a better phrase?
Lexus, I believe you're.
So Lexus is a Toyota brand. Broadly.
Correct.
Okay.
Apparently, they can shoot
What
off
is
into
info-
space. We want them to shoot off into space. We didn't know that. We didn't know that.
Entertainment. It's kind of a combination of a couple of words, information and entertainment. What is infotainment data as it relates to vehicles, modern vehicles?
So it's a generic term, which more or less means the thing that's in the middle of the dashboard with the screen on it. A lot of manufacturers implement that a little bit differently, so they all look different, but it's a general term we use in the industry to describe that system.
And what about, I'm going to change gears a little bit, what about your experience with regard to
That's a fair
GPS as it relates to
Noodles
vehicles on the
NCO
road,
said
on the common
Supras probably
roadways
can.
of the country?
The car that my kid wants the most in the world is a Supra. And I'm like, sir, you are 17. Not today. Not today.
GPS is a pretty fundamental part of vehicle data as a whole at this point, and we run into it in a lot of different places. We see
I wanna hear
GPS
all
data
about
from
Karen's
infotainment
GPS
systems,
data.
and we're
If
analyzing
they
that
have it,
data.
I wanna hear
Most
all
of that's
about it.
GPS based. I do a lot of heavy truck work, and almost every heavy truck has some kind of GPS system in it for the fleets to track them. So we're analyzing that as part of data. And then the last area would be when we conduct testing, any kind of research, we're generally going to put our own GPS systems on vehicles so we can study that data. So analyzing GPS is a regular part of my job.
GPS, global, I'm going by memory, global positioning satellites?
Global positioning system.
System, got it. GPS is a mechanism to figure out where on Earth a certain item might be, whether it's this pin or an 18-wheel tractor trailer, correct?
That's correct.
Is there any difference inherently in the GPS mechanism that's installed in an infotainment center in a Toyota/Lexus, versus a heavy truck or a heavy vehicle that's on the road?
The core technology behind how it works is fundamentally the same.
What
I
is
maintain
instrumented
that whoever makes it simplest for the jury has a much easier road to convincing the jury. And Brennan did I think, a very good job this trial of keeping his direct questions simpler and more linear. But there were still parts of the Commonwealth's case that was, I think, way too confusing and not broken down and explained well. This witness and Jackson explain very well without trying to overwhelm the jury with like, look at how smart I am and how much I know. It is, I know this well enough to break it down and help you know it too. It is a difference.
Testing as it relates to Toyotas and VCH testing and things of that nature. Can you explain that for the jurors?
Sure. What instrumented testing means is, let's say we want to study, let's say, how accurate some data is that comes out of one of these vehicles. So we need an independent source of that information. So what we'll do is we'll equip a vehicle with one of these GPS data acquisition systems. Basically, we can drive the vehicle around and we know exactly where it is, how fast it's going, all these parameters. We can do some maneuvers with the vehicle, and we can download the data that the vehicle stored, and now we can compare the two and say, okay, well, if we have really high confidence in our system, how accurate is the vehicle system? Because the reality is there's always some small errors in these vehicle systems. And in a lot of cases, what's important is quantifying that error.
So you're obviously familiar with GPS systems and many different platforms.
That's correct.
Okay. How many cases have you been a part of in terms of investigating and or analyzing infotainment center or infotainment system data?
Infotainment specifically, probably around 30.
And are you also familiar with engaging in some sort of analysis that's referred to as clock alignment?
They did not ask him about his education.
Clock alignment would mean that anytime we have a timestamp in any set of data, a singular clock value, there's a good likelihood that that's not 100% accurate. So clock alignment would mean finding an independent source of time to compare that to, preferably one that's more reliable, and then making the necessary adjustments so that time can be considered real time.
How many cases have you been involved in that deal with clock alignment specifically?
Thousands, over 1,000. That's a regular part of data analysis. Any data set that has a timestamp, it's normal. It's part of the analysis. It's really the first step is let's get that clock aligned. So it's something I'm doing regularly.
And how long have you worked for Delta V?
It'll be my 13-year anniversary next month, actually.
Okay. These things that you just described that we've talked about for the last few minutes, these are all duties that you perform within the rubric of your employment as the director of engineering at Delta V, correct?
Correct.
Now let's shift gears real quick and talk about your education, training, and background that qualifies you to perform these duties that you just...
Again, and I'm not surprised because Jackson and I worked in the same place, and this is the way a lot of the attorneys that I know do it. Tell the jury why this witness is here first, and then give the background, because then they have orientation for it. Why are you here? The jury's sitting there going, okay, clock alignment, GPS, great. Engineering, accident reconstruction, fantastic. Now we know why you're here. Now tell me about why you're qualified to do the thing that you're going to tell us about. I prefer it a lot better because otherwise the jury's in a vacuum going, okay, but why are you here though? What are you going to tell us about? I like the context.
Talked about. Go ahead. The road is open and it's yours.
Certainly. So I began my academic career. I got an undergraduate degree in mechanical engineering from the University of North Carolina at Charlotte. I then went on and got a master's degree also in mechanical engineering from the same school. And then when I came out of school, I immediately started working for Delta V Forensic Engineering. In order to get a professional engineer license, I then needed to acquire 4 additional years of work directly under the supervision of another licensed engineer. So then I completed that phase of work. And then in order to maintain my license, I have to complete continuing education every year in the field that I practice.
We have to do continuing education
A
too.
Bachelor of Science, correct?
Correct, Bachelor of Science.
Did you mention the year that you got your Bachelor of Science?
That's not
2011.
Charleston
And
then,
you
right?
have a master's
Correct.
in engineering.
That is correct.
And when did you secure that degree?
2013.
You just mentioned engaging in continuing education. What is continuing education in terms
Chad
of the
is mapping
engineering
at how
field
old
or
this
the
witness is. I
reconstruction
see
field,
you.
in
I'm
your
not telling you
world?
not to.
So in the state that I'm licensed, North
Chad.
Carolina.
I'm teasing. Some of you in chat can explain the Charlotte-Charleston situation. I was joking.
They define that really as any activity you're participating in that's keeping you abreast with the field, keeping you up to date with what's going on. So taking formal classes counts for continuing education, but also some of the other work that I do, like publishing research in
Articles.
peer-reviewed journals, also counts as continuing
I
education.
think if you're a lawyer,
Do you,
paralegal, or in the legal field,
regularly
self-study with EDB
attend
counts.
Symposiums or symposia, I guess is the right
Yes.
word. Have you attended symposia
All right, Chad, is it symposium or symposia? Let me know.
related to EDR research and training?
Yes.
How about advanced applications of heavy vehicle EDR data?
Correct. Yeah, I attend. There's a couple of regular conferences in our industry specifically tailored to EDRs as a whole for passenger vehicles and heavy trucks. I'm a regular attendee of those. I'm also a regular speaker at most of those. And I'm usually presenting some of the new research that we have for that year.
So not only do you attend, you actually teach.
Correct.
Have you attended data? I'm sorry, have you attended data? Have you attended events that deal with data, event data recording systems, and event data recording system extraction?
Yes.
What about vehicle crash reconstruction?
Yes.
What about electronic control module imaging?
Yes.
What about
Maddie,
electronic control model
self-study hours.
analysis?
Yes.
Applying automotive EDR data to traffic reconstruction.
Yes.
These are samples of the type of continuing education that you routinely engage in, correct?
All that's accurate.
You talked about additional licenses and professional registrations. You're a licensed professional engineer, correct?
That's correct.
In North Carolina?
10 out of
Correct.
10.
You're also a certified IPC specialist?
Yes.
What is an IPC specialist?
IPC is an organization that offers certifications in basically soldering. I could say it in more technical ways, but it boils down to soldering. So
I like
as it
that you
relates to
don't
what I
say it
do
in more technical
when we are
ways.
recovering data
Chip
from
on,
damaged
chip off.
EDRs at the chip level, that involves some really precise soldering work. And so IPC offers courses in how to do that at basically the highest level. And then they offer certifications for that.
The chat would
Are
like
you
to
a
know more
member
about
of the
how
Society-
handy you are. The chat would like to know more about that.
Of Automotive Engineers.
I am active member.
When you say an active member, is that a nationally recognized society for academic engineers?
Yes.
I just want to know all the accident reconstructionists,
The teaching roles that you've held.
just for my own curiosity, like what cars do y'all drive? Like for the accident reconstruction expert, are y'all in Subarus? Like what cars do y'all drive? I just want to know. Not to be a stalker, but like what cars are all of the accident reconstructionists driving? Because they see all of the shit. I just want to know.
held within organizations. Have you been an instructor
Angela said Volvos.
concerning accessing and interpreting heavy vehicle
A lot of you
data
said
event
Volvos.
recorders?
I am currently an instructor of that course, which is offered through the Society of Automotive Engineers.
As a matter of fact, next week, are you going someplace to teach?
I am. I will be in Wisconsin next week teaching that very course.
Are you a member of any subcommittees within that organization, within the organization
Chat.
of society of
Do not start signing up for professional organizational meetings that are not yours.
the Society for Automotive Engineers?
I'm teasing.
I am a voting member in the J2728 subcommittee, which is a
Voting
subcommittee
member's a
for
big
event
deal.
data recorders on trucks and buses.
Are you also a member of the National Association of Professional Reconstruction Specialists?
I am.
Does that require a certain level of education?
It does, and it requires, as far as I know, when I joined, sort of proof that you are active within the field of accident reconstruction.
That was my next question. It requires you to stay current on accident reconstruction issues, correct?
Correct.
Have you also authored peer-reviewed articles on within your field and
Yes.
subfield? Is it fair to say that you've authored or co-authored a number of peer-reviewed papers in the field of accident reconstruction specifically, as well as EDR data retrieval?
That's correct.
Have any of your peer-reviewed articles that you've either authored or co-authored specifically focused on Toyota vehicles?
Chat, you're making me
Yes.
laugh.
Can you name one, please?
Specifically, this year, published a paper where we studied the effects of collision-induced power loss on the way data is recorded in Toyota systems. And that would include Lexus systems. Fundamentally,
That's
they're the
actually
same
really
components,
interesting
it's
and
just
a
a
good
different
point.
brand on top.
In January 2025, did you co-author a publication entitled Simulation of Vehicle Speed Sensor Data for Use in Heavy Vehicle Event Data Recording Testing?
Mr. Jackson, you're going to have to repeat that.
Of course. Sorry. In January 2025, did you co-author a publication entitled simulation of vehicle speed sensor data for use in heavy vehicle event data recorder testing.
Yes, I was the lead author on that paper.
When you're dealing with retrieving data from a vehicle, an EDR, an event data recorder,
Volvos are winning in the
Toyota
chat,
paper,
by the way, on
whatever it
safety.
might be, and that's a term of art, Toyota paper, correct?
Sure.
Does it matter if the vehicle is a heavy vehicle, a small vehicle, a passenger vehicle, a moped, or a skateboard if they happen to have a infotainment center on it?
There are differences, of course, between the data that comes out of passenger vehicles and the data that comes out of heavy trucks, but there are also a lot of fundamental similarities to those. Like, for example, they all record vehicle speed. They all have accelerator pedals. They all have brake pedals. So a lot of the core data we're analyzing is very similar.
In January 2020, did you co-author a publication entitled Chip and Board Level Digital Forensics of Cummins Heavy Vehicle Data Event Recorders?
Yes, I did.
Okay. And what was the fundamental, without getting into the granular details, the fundamental aspect of that paper?
So, in that research, we introduced a new technique for getting data out of damaged modules. So, you know, they're either burned,
That's cool.
they've been submerged in the water, they're crushed physically from impact. We demonstrated a new method to be able to get data less invasively, but still at the chip level. And we also demonstrated that we could translate that data from the chips outside of the software that was provided. So you could use the software and get the data that way. We demonstrated we could basically do it ourselves if we wanted to.
Did you make a Cannone? Because
Mr.
I'm
DiSogra,
curious
have
if you made a
been qualified
Cannone.
in other courts to testify as an expert in the area.
But it sounds like you get to like throw cars off of bridges and stuff. So
data,
that's kind of
retrieval.
cool.
Yes,
How many times?
once
When was that?
in New York.
You were deemed qualified.
So a newer expert, Cross, is going to be interesting because I don't doubt that he's knowledgeable, but he is a newer expert into the testimony realm. Clearly has the background and training, which I love, but it's going to be interesting to see how Cross goes. I am now fascinated because this is newer for him to be testifying. I mean, if you're going to pick a case where you're like, I'm available for expert work, this one, if it goes well, is going to be helpful. So we'll see.
As an expert in that court, in this
I
field,
wonder how
which
they
you're talking about
found
today.
this
Specifically with as it relates to data, yes.
I want to talk a little bit about what you were asked to do in this case.
I also love that the chipset is something that he particularly focuses on. So this is the chipset, and I'm looking forward to the battle of the experts with the chip and how you get the data off, because that was a rude pause. Sorry, sir. He is here essentially to counteract Burgess. So his testimony is going directly to the same thing Burgess did.
We asked to undertake a review
Which
of
is
certain work
fascinating.
performed by a person by the name of Shannon Burgess with Aperture LLC.
Emily, you could have
Yes.
just
Are you
let them.
familiar with
you could've
Aperture?
just waited.
Yes.
Before you were asked to undertake that review, were you familiar with Aperture?
Yes.
Were you familiar specifically with Shannon Burgess?
Yes.
What did I say?
Were you asked to
Oh, I
engage
did.
in any original analysis?
Thank you, chat. I'm not wrong, though. You see how easy I didn't even catch myself. It wasn't intended.
In this case?
All of my analysis is fundamentally based on all of the data and the numbers provided in the Aperture reports. So more or less the answer to your question is no.
So you were
I'm going
asked,
to back up and let him answer about Burgess again.
Yes.
were you asked to engage in any original analysis in this case?
All of my analysis is fundamentally based on all of the data and the numbers provided in the Aperture reports. So more or less the answer to your question is no.
So you were asked specifically to give the court and the jurors clarity on data that Shannon Burgess had analyzed and provided a report about, correct?
Correct.
And that dealt with data obtained from Miss Reed's
Here's this
SUV,
report. Do you
Karen
agree?
Reed's SUV, correct?
Correct.
Did you, in fact, review Shannon Burgess's report summarizing his findings and conclusions regarding clock drift? That report was dated in January of 2025.
Yes.
He did not retrieve
And
the
what
data
did you
himself.
do in that regard?
I analyzed the methods that Mr. Burgess proposed for aligning the clocks in that report.
Were you also asked at some point to review Judson Welcher's report and PowerPoint presentation regarding the timing of the text stream event known as 1162-2, 1162-2?
Yes.
He did not testify. Oh, wait. Darn
Did
it.
you
that was
determine
not
whether
the-
Dr. Welcher
I wanna
had
know
based
this,
his
but-
report on Shannon Burgess's analysis?
He did not
Yes.
testify last trial.
Before
He's
we get
the
into
battle
that,
of
I
the
want to ask you a
experts.
couple of questions about text stream events. So we're all talking sort of with the same vocabulary, if we could. When I say text stream event, have you ever heard that called a trigger event?
Yes.
Are those sort of synonymous?
The event, in order to be generated, has to be triggered by something. So, yes.
You became aware in your analysis, I'm assuming that Dr. Welcher reported a trigger event at a particular time or span of time, correct?
Correct.
What span of time was that?
I
Or
would-
I should say, what time was that?
For which event? Just so
For
I'm
the
clear.
1162-2 event, sorry.
Do you mind if I reference the slide? Because I don't have the number committed.
With the court's
to my-
permission.
Go ahead.
Do you have a copy of it in front of you?
I do.
Look, asking for permission. We appreciate it. Look at that. May I refer to my report? Yes, you may. I have no problem when they ask.
So, the original analysis places event 1162-2 ending at 12:31:43 a.m.
Now, Dr. Welcher, and this is what I want to talk about for just a quick second. Dr. Welcher indicated that the trigger event began at 12:31:38, correct?
I believe so.
That would suggest that a trigger event lasts 5 seconds, 12:31:38 to 12:31:43, correct?
Jackson's starting to sound like Alessi. Did you catch that? He's picking up Alessi's habits because that is an Alessi habit, not a Jackson habit. 5 seconds. That is 100% the way that Alessi emphasizes things. That's funny to me because that's just funny to me. The 5 seconds. It's interesting to see how the different teams have evolved and how the parlance of the teams has evolved.
Correct?
Sustained is to fall.
I love all of you in the chat. We're like, I just caught that. Look, attorneys are really just going to school to learn how to learn and continue to learn. And they're always learning new stuff, which is what I love. So you're always learning new stuff. So I appreciate watching the attorneys, even throughout this trial, even incredibly experienced attorneys still learning.
Ending at 12:31:43 a.m.
Now, Dr. Welcher, and this is what I want to talk about for just a quick second. Dr. Welcher indicated that the trigger event began at 12:31:38, correct?
I believe so.
That would suggest that a trigger event lasts 5 seconds, 12:31:38 to 12:31:43, correct?
Sustained is to fall.
Let me ask you this. Does a trigger event or does a text stream event last 5 seconds or 10 seconds?
The trigger is a singular point in time.
That's my question. All right, so if we're thinking about a trigger event, it's like that clap, snap, right? It's a point
I
in
saw him
time,
close the binder.
not a series of, not a time span, correct?
It's a singular point, correct?
He looked at it, closed it.
Does a trigger event or a text stream
Very
event
experty.
cause a recording to bookend the trigger event itself?
Yes.
Explain that for the jurors so that we're very clear about that.
5.
Sure.
Middle.
So when an event is triggered, what we end up with is some data from before the event was triggered and some data from after the event was triggered. The way it does that is it's kind of always recording, and as soon as it sees a trigger,
Stays
it says,
ready.
aha, and it goes and it grabs the previous 5 seconds. That number can vary. It can be more or less than 5, but for the specific trigger we're talking about, it grabs the previous 5 seconds of data, and then it keeps recording for an additional 5 seconds, and that completes its recording phase.
Right. So if Dr. Welcher indicated that
Kiki, that's why we did
the
the app.
text stream event
It happens.
trigger was at 12:31:38, would it be accurate if he said that trigger ended at 12:31:43?
Objection.
Sustained as to full.
Leading.
Is there any, if a trigger event is one point in time, one snap in time, would it be accurate to say that the trigger event itself lasted 5 seconds and ended 5 seconds later?
It wouldn't be accurate to say the trigger lasted that long.
That's my question.
The event lasts that long, but the trigger is only one point within the event.
The recording lasts that long.
They did keep
correct?
saying the
Correct.
In
trigger
other words, it
event
captures,
lasted that
or
long.
does it? Let me ask you this. Does it capture 5 seconds before and 5 seconds after? But the trigger event is the singular point right in the middle.
That's correct.
Okay.
I don't think that point is a serve at all. I think it was very clear with the other witnesses. One of the things it was is that the trigger event, whatever the trigger is, happens and it records 5 before, 5 after. That trigger event then records 10 seconds of time, but the event is the 1 point. I thought that was clear. Maybe Jackson thinks it wasn't clear, but I think that parlance is not a huge differentiation.
If we were to calculate
but that
the
one
window
point is what causes it to
between the
record.
trigger event or the text stream event and a lock event
A lot of you are saying it wasn't clear
on
to you.
John O'Keefe's
Perfect.
phone, you analyzed both, correct?
That's why we have chat.
Reviewed both, correct?
Correct.
Fair enough. A ton of you said, no, that wasn't clear to me the first time. That's completely fair. Completely fair. I also spent a lot of time with this information. So a lot of you are like, it was not clear to me. This is much more clear. Perfect. Thank you, chat. This is why we have, 40,000 of you chatting. A lot of you are like, not clear at all. Perfect.
Would you calculate from the point of the trigger, would you calculate from 12:31:38, that point in time, and I'm using the tip of my pen to represent the point, at 12:31:38,
tip,
or would you calculate it from 12:31:43?
Customarily, when we're doing any analysis, we're referencing everything off of the trigger. That's the normal way. Everything in the Aperture reports was referenced off of the end of the event. So
Of the recording event,
of the recording event.
not
So,
the trigger.
Correct. And I didn't correct that. I just went with that convention for all of the analysis I did.
But you noted it, correct?
Correct.
And you noted that that would be 5 seconds inaccurate? I'll withdraw it. I'll ask it a different way.
It's different.
What would be the effect of timing if you were to start at the trigger event, 12:31:38, versus timing the event if you were to start at 12:31:43?
There'd be approximately 5-second difference in every subsequent calculation.
And if, in fact, there was a
That's why he was going there. That
lock
makes
event,
sense.
which you reviewed, at 12:32:09, how long would the actual window be from the trigger event to 12:32:09?
It would be larger by 5 seconds, approximately.
Right. The time
So it
shifts.
would actually be 31 seconds, correct? Did I do my math right?
You did.
Let's get back.
We're back to the
if we
time warp.
can, to the offsets that you identified in Shannon Burgess's, the time offsets that you identified in Shannon Burgess's report. When you applied the potential offsets identified by Mr. Burgess to the text stream event at 1162-2, what opinions or conclusions did you come to with regard to that
A reasonable
analysis?
degree
or
of
that
certainty.
question?
Sustained, ask it differently.
Did you apply the potential offsets identified by Mr. Burgess in his January 2025 report to the text stream event 1162-2?
Yes.
Did you also apply Dr. Welcher's analysis based on that same Shannon Burgess analysis to reach an opinion or a conclusion?
Yes.
And what was your opinion or conclusion with regard to that event and the timing following that event?
Based on all of the data in those two original reports, regardless of what adjustment is made or which 2 points are used to try to correct the clock, the phone lock event always occurs after the end of the event, using their convention of referencing off the end of the event, not the trigger, but it always occurs after.
And that was based on Shannon Burgess's January 2025 report, correct?
Correct.
Sustained.
What was that based on? Which
was
report?
leading.
We're dealing with two different reports, May and January. I want to make sure we differentiate. Which report are you just now talking about?
I'm talking about the
He
January
said
report.
original
Now,
report.
did Mr. Burgess,
They need
were you
dates.
supplied with a supplemental report by Mr. Burgess?
Yes, I was.
When was that?
Slightly after he issued it, but I don't know the exact date.
Say that again?
It was issued on, his report was dated May 8th, and I think I was provided it a couple days after that. I don't
Okay.
remember the exact date.
So after, well, do you know when this trial started?
No, I don't know the exact date.
I know you're not watching the trial, but it was in the middle of this trial, correct?
He said, I don't know when the trial started.
Sustained.
I'll ask a different question.
It was May 8th. The jury knows. The jury's well aware
With
of how
regard to
long
the
they've been
original
fucking sitting
report,
here.
the January 2025 report, was there any circumstance in which Mr. Burgess and Mr. Welcher could conclude that the lock event on John O'Keefe's phone, that lock event, occurred before the trigger event?
Objection.
Sustained. Ask it
It,
differently.
it's A, leading, and B, it does misstate the testimony.
What is your opinion about whether or not there was any analysis done by Mr. Burgess or Mr. Welcher that put the lock
I think there's
event
already an
occurring
objection coming
before
because it looks like he was looking at.
the trigger?
Objection.
Sustained.
May we approach, Your Honor?
Yes.
They're allowed to get into this opinion. I'm going to zoom past this. I saw some great questions in the chat. I'm holding on to many of them. Blue Jays asked about working with a team of lawyers. Would AJ have Alessi look over his questions to make sure his questions are clear? I think Jackson is a clear questioner. Alessi, especially when he crosses, can add way too many parts to his question. It's just not my preference. But I think when they're talking to experts, this team has all worked together because we've seen the building blocks of what is asked in cross building towards what's going to be asked of this expert. So yes, the team would have worked together on that to know if you're crossing Burgess and I'm directing this witness, we need to have microphone. We need to have all this information together. Melanie M in the chat said, thanks so much, Emily. It's much better here than watching just the trial. I know it is. Y'all know it is. And it's not for everybody. And that's okay. We're a little behind time. So if people want to watch the trial
May I, Your Honor?
Yes.
in
Thank
real
you.
time and then come back to see
Back
what
to my
I say about
question.
something, they can.
Was there any circumstance based on your review that if the text stream event occurred at 12:31:38, that there was any circumstance that the lock event occurred before that trigger event?
There was not.
And when the timeline shifted, they say they overlap. And on the original reports, the lock event happened after. The timing of this matters a lot because of all things, whether you believe a particular witness or not, jurors tend to believe what the digital evidence shows them, what the phone shows them. Jurors know, especially younger jurors, they're like, yeah, my phone's creeping on me. It's weird. But also, if the phone says this happened, you got to show me a lot to show me that that's not what happened. The digital data, the documents, it's why I loved white collar crime cases so much. The documents are just what they are. The data is just what it is. And now we have a battle of the experts arguing over how to interpret that data. But the data is simply what it is. And that's why this is so important for both sides to have that timing lined in. Because if John O'Keefe is able to manipulate his phone after Karen Reed's car is gone, then was he struck by the car and rendered unable to physically manipulate his phone due to that head injury? Or not? So you had a lot of testimony from the prosecution's case that John O'Keefe's injury would have likely rendered him unable to do that. So if that lock event happened after the end of that 10-second recording, that's a good argument for the defense. The prosecution's going to rebut that with, right, but after that recording, the car was still going backwards. The event didn't end because remember, the text stream event was putting the car in reverse. The car was still reversing. So even when that recording event ended, the car was still going backwards. So even if the recording event ended before John O'Keefe's phone lock event, the car was still traveling backwards. Because what triggered the event was not a collision. What triggered the event was throwing the car in reverse. That's what triggered it to record. And it was still going backwards. And that's what the Commonwealth is going to argue. So we're back to, when did this happen? And if you can't answer when it happened, I think that leads to a bit of doubt.
Did you create a
maybe more than a
PowerPoint,
bit? I downplayed
for
that.
clarity's sake in March of 2025?
We love
Yes.
a clear
Did you provide that to
PowerPoint.
us?
I did.
What was the purpose of creating the PowerPoint?
Mel, I'm going to save
The
that.
purpose of the PowerPoint was really to take a bunch of different data elements that
witness
were kind
can.
of placed throughout.
We're going to get into that
Mr.
now.
Burgess's report and Dr. Welcher's report in PowerPoint, and compile them into a single source, a
To
single
explain.
table, essentially, to show as clearly as possible what the
Simplify.
conclusions would be if we look at the data as a whole.
A lot of you have said
When
this
you
witness
created
looks
that
like Andy
PowerPoint
Garcia.
presentation, did you create it with the intention of providing it to the defense, which would then be provided to the Commonwealth?
Yes.
Are you aware of whether or not that was disclosed to the Commonwealth as part of the normal discovery process?
No.
So the answer is no, the answer is
The answer stands.
Following your presentation of the PowerPoint to us,
Let's see the PowerPoint.
at some point, did you receive from Mr. Burgess an amended report, an amended PowerPoint?
I received an amended PowerPoint by Mr. Burgess, not from him, though, from you.
Fair enough. Fair enough.
That is fair.
Did that report,
Again,
or did that PowerPoint, however you want to put
that's what I expect from an engineer. Well, actually, sir, I didn't get it from Burgess. It's Burgess's report. I got it from you.
it, markedly, was it any different than his January 2025 report?
Yes.
This is important
Did
for
you
the
note any
defense.
conclusions? Did you note the conclusions that he came to in January 2025? Going back to the original report?
Yes.
Did you note conclusions and opinions that he came to in May of 2025.
Yes.
Were those two things different?
Sustained.
Were the conclusions, not his opinions, were his conclusions different?
Sustained.
Was there any difference in the two reports?
There was.
Tell me the differences.
I don't know what that objection was for. I can't
In
help.
the first
Because it wasn't
report,
leading. Though
Mr. Burgess did some of the calculations that are necessary to correct or adjust the times based on certain approaches, but never went through the final step of applying those calculations to the times and coming up with a final time. In the supplemental report, he then essentially took that analysis to the end. He approached it in a new way, a different way than he had previously laid out in the first report, but then he also took it all the way to the end by applying those calculations to the times.
What were the main differences? Explain for the court and for the jurors, what were the main differences that he changed
I appreciate
in the
this.
May 2025 report?
Contrasting it with the original
Correct.
report. In
Right.
the original report, he laid out some methodologies for correcting the clock using phone calls that were shared between the vehicle and
That's
Mr.
right.
O'Keefe's phone. And in the supplemental report, he moved away from the phone call
The
analysis
three-point turn.
and moved to attempting to align the clocks using a shared maneuver
See how he threw
between
it
the vehicle
at the
and the
attempting?
phone.
What was the shared maneuver?
Even then, he
was
didn't
a
say he did it
three-point
well.
turn.
Was that the same analysis that he had in January 2025?
Did not have that analysis in the January 2025 report.
Thank you. Based on the new information in the May 2025 report, what was the effect, as you see it, regarding the possible scenarios?
So I did the exact same process I did using the supplemental report as I did on the first report. And when I ran all those numbers and those calculations, it turned out there are now some scenarios in which the phone lock occurs after the end of the event. There's some scenarios where the phone lock occurs simultaneously, like literally at the same second. And there are some scenarios where it occurs before. So now there's a range.
Chad,
So-
I appreciate that all of you very much wants to know if this witness makes their spouse coffee and when that coffee is made. I very much appreciate it. It's like, sir, what's your morning routine? I appreciate you, Chad. I see you. All of you want to know. Maybe it's a green smoothie. We don't know.
Mr. Burgess's report,
Who knows?
his new report, his amended report, widened
But I appreciate
that
it.
gap to allow him to opine that there were scenarios that occurred after the phone lock event, correct?
The objection sustained.
Chad
Did
also
you
wants a
prepare a
skincare
PowerPoint
routine.
presentation in furtherance of clarifying
Some of it's probably genetics.
Mr. Burgess's analysis?
Sustained.
Did you
What?
seek to clarify Mr. Burgess's analysis?
Why was that sustained? I'm going to have... I don't know why some of these are getting sustained. I can't... All of you are asking me. I can't tell you. I don't know.
Sustained.
Your Honor, may we approach?
Yes.
Yeah, what is the... Jackson can't figure it out either. Jackson's like, what is the deal? Yeah, I'm with Jackson on that one. I don't know. But he's allowed to get into his... Oh, well, I would think he's allowed to get into his PowerPoint. It was properly
Yes.
discovered.
Did you...
I'm going to zoom past that sidebar. I appreciate that Jackson is like, WTF, let's
May
go
I?
to sidebar.
Yes.
Did you prepare a PowerPoint presentation in furtherance of your analysis?
Yes.
What was the reason and what was the purpose for your PowerPoint presentation?
Really? It was asking about Burgess in it that was the issue. Seriously? Okay.
I needed to include in my analysis
A lot of you are saying foundation.
the approach and the conclusions from the supplemental report by Mr. Burgess.
May I have a moment, Your Honor?
Yes.
I appreciate that. Chad is saying it was foundational. I trust Chad because Chad is
Yes.
Bay and very smart. There's a lot more ears than just mine. Also,
If you wouldn't mind taking a look at that document.
Miguelina has let me know
I just
that
handed you and just flip
y'all
through
have
it, let me
taken
know
the
once
Emily
you've
Show
familiarized yourself
channel
with it.
to over 200,000 subscribers, so thank you. That's awesome. The second channel, you guys have been loving the case briefs, and I can't even say y'all because
What
some
is
of
that
y'all,
document?
This is a print.
some of y'all who are loving the case briefs aren't here because you're like, I can't do this day by day. It's painful. So thank you.
out of the PowerPoint presentation that I prepared.
Is it true and accurate?
Yes,
And it's complete?
it appears to be.
Your Honor, I would move for its admission, please.
I have no objection.
Okay.
All right, PowerPoint.
Quick second.
Let's just get to the PowerPoint.
208.
PowerPoint me. Also, a number of you had thoughts about things that rolled
Yeah,
out in
permissions.
chat yesterday. We reached out to those who know at YouTube about it and let them know our strong feelings about it. And today on the channel, there is no chat leaderboard. It is gone, as it should be. I'm very glad.
To display the PowerPoint presentation?
Okay.
Let's get to PowerPoint.
Mr. DeSogra,
Sir, if your
can we still
PowerPoint
see with
sucks,
the
I'm gonna be
lights
pissed.
off, sufficient
I
to-
can't spend another day looking
see
at
what's on the
terrible
screen
fucking
and what's in front of you?
PowerPoints.
Yes.
Okay. Do you recognize what's on the screen?
We're all
Yes.
rooting
What
for
is
you.
that?
That is the title page of the PowerPoint that I prepared.
And what is the how would you describe the PowerPoint?
So this PowerPoint is largely identical to the first PowerPoint I prepared in that it seeks to take all of the different approaches between the initial Burgess report, the supplemental Burgess report, and Dr. Welcher's report, lay out all of those approaches in one kind of coherent fashion
With
so
the
we can look at
with the
what
degrees,
conclusions we can draw from all of that data.
Certifications at the end of the name.
With the court's permission, can we go to slide 2?
Yes. Mr. Jackson, you can just use this PowerPoint. It's in evidence. You don't have to ask slide to slide.
Thank you, Your Honor. Taking a look at this next slide,
I appreciate that Jackson is like, I don't even know what you want this morning, so I'm just gonna let you tell me. Good. I
what is this?
hate this
What are we looking
slide.
at?
This is a slide from Dr. Welcher's presentation that I was provided. Specifically, this is his slide number 33.
And what does it show?
This is where he introduces the first, acknowledgement that there's a difference between the time that Aperture calculated for the end of event 1162-2 and the lock event on Mr. O'Keefe's cell phone.
Is there anything in this slide that you disagree with in Mr. Welcher's presentation that you disagree with? It's up on the...
I added the 2 green boxes and the text, the word after. That's not Dr. Welcher's. And I added that because
have
it's
to
stated
move
here
me a
that
little bit. Hold
the
on.
event occurred within 26
There we go.
seconds. But
Trying to move me out
if,
of the way.
if we do the math, and he actually does the math, he really means after. It means the phone lock event occurred 26 seconds after the end of
He's
the
using
vehicle event. as
within and
calculated.
after.
No, I'm going to allow it.
The
The phone
prosecutor just
interaction happens how...
the prosecutor just moved to strike the he really means after, but it says within, and the court said no, I'm going to allow it. It was very low, but that's what just happened. So Brennan moved to strike. The court said no, I'm allowing it.
How many
Moving on.
seconds after the text stream event?
Based on this slide, 26 seconds.
Thank you. And the text stream event that we're talking about is what number?
1162-2.
And this slide, other than the green, is this slide or the portion of the slide that we're looking at, other than what you've described, is this directly from Mr. Welcher's own analysis or his PowerPoint?
Right. I added the green box around within, the dashed green box around the whole paragraph, the line, and the words after. Those are my additions.
Let's go to the next slide.
Here's where I now would like clarity. Oh, I hate a white background. Here's where I now would like clarity. And I realize that people who do not have sensory issues with bright white slides are probably not in the same boat I am. Hate a bright white slide. At least it's easier to read and there's way less data. It doesn't feel like somebody's cramming for an exam. But here's where I now have a question. When they are talking about the text stream event, are they talking about the entirety of the recording event? Because they're now trying to explain Burgess's PowerPoint. Or are they trying to talk about the triggering event? Because if you have the triggering event and 5 seconds after it and 5 seconds before that, are we calling that whole thing the event or not? So we will just, I'm waiting for him to clarify it. So we will continue on.
Can you tell us what this is?
But the white background
This is
immediately gives me a headache.
more or less a repeat of what's on the first slide, but just shown with a little more focus. The first slide is a little busy. So
Did you
Did we just become best friends? With our mutual hate for that first slide?
can you tell us what this is?
I rewound.
this is more or less a repeat of what's on the first slide, but just shown with a little more focus. The first slide is a little busy. So
I love it.
Did you, I'm sorry, Mr. DiSogra, did you create this or is this from Dr. Welcher's report?
I created everything on this slide apart from in the top right. That came from Dr. Welcher's slide 33.
Although you created the slide, where's
He's summarizing the
coming
data
from for this slide?
All of the data on this slide and all of my subsequent slides comes from the Aperture reports collectively, either Dr. Welcher's report or slides or Mr. Burgess's first and second reports.
What did their analysis reveal in terms of the time, the exact time of the lock event for Mr. O'Keefe's phone?
So in their analysis, in Aperture's analysis, they report the Lexus event 1162.2 ends at 12:31:43, and they also report there's a phone lock at 12:32:09. So if we just simply take the difference in those two times, we get 26 seconds.
If you were to add the 5 seconds.
And the thing is about the 26 seconds is that's where this variance came in to play. So this witness is really here to talk about that time variance a lot. Because remember, the time variance originally from Burgess was, hey, we give a window between clocks of a minute. So I didn't even do any of this calculation because we give a window of a minute. And then it seems to me, and some may differ, but it seems to me when they got the report from this expert, they went, no, we can narrow it down from a minute. We can refine that. And then they refined the difference between the two phones to be that shorter period of time difference, down from a minute into that 21 to 26 or 21 to 29 second window. So they cut it down to under 30 seconds so that the last phone interaction and the end of the recording of the text stream recording event overlapped. That.
Back to 12:31:38, which is the actual trigger event, what would you come up with?
31 seconds.
Which of the two, in your expert opinion, which of those two numbers is more accurate as it relates to the trigger event?
If we wanted to conduct the analysis relative to the trigger, it would be better to use the actual trigger time. However, as long as we're consistent through the analysis, it's not entirely wrong to use the end. It would be wrong if I suddenly switched up and started talking about this relative to the trigger event, but they present it as the end of the event, so I conduct the rest of my analysis using that convention.
Is another word for the end of the event the end of the recording?
End of the recording, yeah. When I say event, what I mean by that is the data
Recorded
event,
data.
the data recording event.
But
That's
the trigger
clear.
event itself, 12:31:38.
Correct.
Did you put a name on this gap, if you will, this time frame?
Yes, I did. For the sake of the rest of the analysis that I'm going to do, I thought it would be helpful to just refer to this difference in time as John's interaction window.
And that refers directly to the interaction with the phone, the human interaction of locking the phone.
The 123209 lock.
Okay, let's go to the next slide, please. What does this slide show us?
So this, here what I'm doing is I'm kind of laying out the bounds of what I mean in John's interaction window, which should make, we have a lot of numbers to go through here, and so this should give us
That's
a very
fair.
easy metric for kind of determining whether we have an event before or after. So what I mean by that is when we calculate John's interaction window, if that number comes out and is positive, that means the phone interaction occurs after the end of the vehicle event. And if we calculate John's interaction window and that number becomes a negative value, then that means the phone interaction occurs before. So now we have just a convention we can use really quickly to say, is it positive or is it negative? And we can maybe spare ourselves some of the math with 1,000
I
numbers.
can just
So positive means what?
Chad,
One more time.
I'm putting my
Positive, John's interaction window positive means
I'm putting my computer on night mode because otherwise the white background is going to give me a migraine. I do not think it will change on your end, but if all of a sudden something looks more yellow on your end, it's my change, not yours. So I don't fatigue streaming if we're going to be looking at white backgrounds, just because I am incredibly sensitive to white backgrounds. So if it does change the way it looks on your end, I did it. It's
the
on me.
phone lock occurs after
But
the end
hopefully if I put
of
on night
vehicle
mode,
event
it'll help.
1162-2.
Got it. Let's go to the next slide, please.
Because otherwise it's going to wreck me.
What does this slide show us?
So what I'm saying here, I'm kind of laying the foundation for why we're going to even do this. Why do we need to start doing math on these clocks? So fundamentally, the phone, Mr. O'Keefe's phone, and the vehicle, Ms. Reed's vehicle, they're separate clocks. And it's very unlikely that they're going to be aligned perfectly in time. Right? If I compared my watch to your watch, it would probably be off. And that's the same case for any two independent clock sources. So Aperture, in their collective reports, propose a number of different ways in which that can be corrected. So I'm going to go through all of those ways that Aperture has proposed and show if we align the clocks based on how they lay it out, does John's interaction window stay positive or does it ever become negative? Where does it end up when we run all those analyses? Or another way to put it is, does the phone interaction always occur after the end of the vehicle event?
And what did you determine?
He said that it does.
Based on the initial reports,
Yes.
the phone interaction always occurs after the end of the vehicle event.
Did all of the information that's on this slide come from the same source or multiple sources, meaning Mr. Burgess and Dr. Welcher?
In the PowerPoint as a whole, all of the information comes from the Aperture reports collectively,
Okay.
from Dr. Welcher and Mr. Burgess.
Did Mr. Burgess make any adjustments from his original report to his subsequent report in May of 2025?
Yes.
Let's go to slide 6, please. Tell me about this slide.
Yeah, so this is the first adjustment we're going to talk about and this one comes from Mr. Burgess's original report. And to summarize this adjustment, this is a key on timing adjustment, and we're going to show that the key on, the actual turning of the vehicle on, occurs about 3 seconds before that time gets registered
I wanna see
in
the
the
slides too, Chad.
infotainment.
I'm
So the
with you.
time we see is basically stale by 3 seconds.
We're all familiar with how computers turn on. When you say key on, do you mean a physical key, or could it be the push button to turn the car on?
In this case, it's a button. I refer to key on because generally that event is considered the key on in vehicle parlance, regardless of whether there's a physical key or it's a push button.
So those 3 seconds mean what?
Key on
What's the
is your
difference
preferred
between
parlance.
pushing that button and the 3 seconds later that you just described.
It means that when we're trying to use the timestamps that were recovered from the infotainment system that show when the vehicle was keyed on or turned on, that
There's a
The
3 second
vehicle was
delay.
actually, or likely, turned on 3 seconds before that.
Do you know where the 3 second conclusion came from in Mr. Burgess's report?
That came from the testing that Aperture conducted with the exemplar Lexus that they purchased.
Was there anything in the report that indicated testing, this type of exact testing on Miss Reed's actual Lexus?
No.
Do you have an opinion as to whether or not all Lexuses, at least of this make and model and year, would have the exact same 3 second delay? Or could that be different?
It could be different in their testing. In their testing, they only tested one exemplar vehicle. So I think there was a solid foundation that the exemplar that was used exhibited this 3 second delay. It was a very close match in terms of part numbers and software versions to Ms. Reed's Lexus. But without any kind of testing of, let's say, a second vehicle, a second exemplar, we wouldn't know, we wouldn't have any basis
For
to
sure.
say it must be 3. We could test a second vehicle and it could be 5. So we say, well, there's a delay, but it varies vehicle to vehicle. They could have tested a second vehicle and found it's also 3, and then you start to build some confidence that maybe it is 3 across every vehicle. But with only testing one and not testing the subject vehicle, it is difficult to say with absolute certainty it would be 3 seconds.
They couldn't really test the subject vehicle.
What
now,
is your
could they?
opinion
'Cause
about
they chip offed it
best practices
wildly.
with regard to trying to create this gap for purposes of coming to an opinion or an analysis?
So because we don't know whether or not this specifically would apply to Ms. Reed's vehicle, the best way to conduct that analysis would be to do the entire thing with the key switch adjustment at 3 seconds. Because if we're going to use a value, 3 is the most reasonable one because that's the one shown in testing. But we should also do the entire analysis without it in case
To give
we feel
that
that that's the
range.
most appropriate. So in fact, that's what I do and will show is I ran the analysis both ways, with and without, to be as conservative as possible.
Did your review of Mr. Burgess's report indicate that he ran the analysis both ways?
He did not.
Let's go to slide 7.
The
What are we
3
looking at
seconds, the 3 seconds that they're talking about is when you push the button, start singing again. When you push the button, there is a 3 second delay in the exemplar Lexus before the infotainment system goes on. When the infotainment system goes on, that is when the infotainment clock or stopwatch starts counting up. And so from the time it counts up, there could be 3 seconds from when the key cycle starts. So if you're looking at when into the key cycle an event happened, you're already at a 3 second delay. So you might need to shift the time when you account for it 3 seconds forward because the key cycle data and the infotainment data has that 3 second delay, and the infotainment data does not pin to a time on like the dashboard. The infotainment starts a stopwatch, and so you'll get like 10 minutes and 3 seconds into a drive, or 15 minutes and 20 seconds into a key cycle. But the key cycle has a time from the Lexus clock. So if you're taking the key cycle time to the Lexus clock, the infotainment system needs to be converted from the count up to the real time, but you need to account for that 3 seconds. Hopefully that makes sense. So key on, keys to Lexus clock, 3 seconds, then the infotainment system starts counting up in a stopwatch for that key cycle. So that needs to be converted to real time, and then you need to account for that 3 second window from the key on. That's where we're at.
This is an excerpt from Mr. Burgess's original report, his page 28 and his page, there's a screenshot also from his page 30 at the bottom. And this is where he states in that report that when they were doing the testing with the exemplar, they observed across 4 different key-on cycles this 3 second difference. So what I mean by that is They had a video camera in the car that had a timer on it. And so in the video, you can see the button pressed. So in their testing, for example, they pressed the button at 21:48:05, and that's sort of nailed down. When they went back and downloaded the data from the infotainment, the key on was logged in the infotainment as 21:48:08. So there's the 3 seconds. That's where they're getting that from. And that's what he states, highlighted in red there. It's a little hard to read, but it basically says the average across 4 runs.
Because
was
they're
3
the
seconds.
worst slides
The 3-second
ever.
delay, was that actually in his report?
This is the only point in the report it's mentioned.
And I guess what I'm asking, it was an inartful question. The portion to the left, is that his report or your report?
That is his report. Everything on the left-hand side of this slide comes from Mr. Burgess's report.
So the 3-second delay was noted in his report.
It was noted.
Did he apply the 3 seconds in his analysis?
He did not.
Did he indicate in his report why he ignored that 3-second delay?
He did not.
Sustained as to that question.
I'll rephrase it.
Strike the
It's
answer.
Did he
The word
indicate
ignored.
in his report the reason that he did not apply the 3-second correction?
He did not.
When you do apply the 3-second correction, what do you come up with as it relates to the 26 seconds from the end of the recording?
So the positive 26-second window, if we only apply the 3-second key on, grows to positive 29 seconds.
If you applied the same 3 seconds to the trigger event time, now what does the gap?
That gap would grow to a positive 34 seconds.
Between the trigger event and what?
The phone lock.
In your opinion, was it best practice to not account for that 3-second delay between the on switch and the data coming on?
Sustained, ask it to.
What, in your opinion, would be the best practice in terms of this 3 seconds that was noted in the exemplar vehicle?
The best practice would be to run the analysis with that adjustment included and without that adjustment included. Because like I stated, without testing of an additional vehicle, we really don't know if 3 seconds is just a specific behavior of that exemplar or if it's representative of all Lexuses of this type.
Let's go to slide 8, please. Tell us what we're looking at in this slide.
So now we're going to get into the next adjustments. That first adjustment we just talked about was really a vehicle-to-vehicle adjustment. We haven't talked about the phone yet. We're going to get into the phone now and talk about aligning that. But we had to get through the internal adjustment that has to get done first. Now we're going to look
That's really
on the
clear
subsequent
on
slides here at all
what
of the
point we're
different
at.
ways the Aperture reports.
I will say where this expert has the advantage, though, is that the jury's hearing this information now for the second time. So even if the first expert is as clear as can be, it's always going to be a bit more clear for humans when you hear it a second time. So that gives an advantage to, I get to explain it again, and now you're not hearing it just for the first time. I do think he's clarified, and I appreciate that he's taken the slides from Burgess and then clarified them to simplify what's being said. And then taking those foundational points and saying, and we disagree with this foundational point and this foundational point, and pulling out that information. So then when we come back around to this on Aperture, it'll be the third time. And then by the time we get to closing, the jury will have heard this the fourth or fifth time by the time we get into closing. It's important information for both sides. It is an easier job for the defense to start saying, well, things could shift this way or that way. The Commonwealth has to make that more solidified. That is their job.
Compared the vehicle to Mr. O'Keefe's phone.
Is is there any additional adjustment that you believe should be made?
The Aperture reports lay out two methodologies for adjusting. There is a methodology based on phone calls, and there's a methodology based on the 3-point term.
And where did you get that information from?
From the Aperture reports.
In Mr. Burgess's original report on differentiating, the January report, which did he use to determine his determination of the clock skew?
In his initial January report, he never actually takes the calculation to the end by applying the differences in times to the calculated time for 1162-2, but he does do the math, which I'll show, for the differences on these phone calls.
In terms of Dr. Welcher's
And I think Burgess
report,
explained that well on direct.
did he
why
identify
he changed
a
the
GPS
approach.
point of 154 at all?
Yes.
How did he describe that GPS data point?
He describes in his initial PowerPoint slides as point 154 aligning with the end of vehicle event 1162-1, talking about a different event now. This is the 3-point turn event. So he uses that as an anchor point.
And that anchor point you said was the end of the text stream event, or the end of the recording of that text stream event.
Correct. The Aperture reports consistently reference everything from the end of the events.
Let's go to slide 9, please. What are we looking at here?
On the left is an excerpt of page 33 from Mr. Burgess's initial report. And what he shows here is he has identified 7 call logs that exist both in the infotainment from Ms. Reed's Lexus and in Mr. O'Keefe's phone. He puts them in a table form. Then he actually goes on and calculates the difference between those two times. So that's what I meant by he sort of does the math. He makes my job a little easier, and the numbers are already there. He just never applies these to any of the times. So that's where I step in and say, if I take that third column that he lays out, those are in seconds. If I apply those seconds, that adjustment to 12:31:43, where do we end up with John's interaction window in those times?
What did you conclude in terms of finishing the work?
Sure, I did all of them. And so I highlight on this particular slide, I just highlighted the very first one he has in here. In that case, he identified that Mr. O'Keefe's phone was 2 seconds slow relative to the infotainment system. So if we apply only that adjustment, then John's interaction window becomes positive 28 seconds.
Did Mr. Burgess apply all of the potential offsets?
He didn't apply any of the offsets. He calculated all of them, but he didn't apply any of them.
Did you ultimately apply
I
all
think
of the
why
offsets?
though, and I
Yes,
think
I
he
did.
explained
And
well.
what did you determine?
Why?
Regardless of which offset you apply, John's interaction window remains positive. The number changes, but it remains positive.
Let's take a look at those one at a time if we can. Let's have the next slide.
So on this slide, I just took the other end of the spectrum. There's a large range in values in this table.
And that's because the
He doesn't
car
actually,
was
Mr.
off and
Burgess
then went back
doesn't
on. He
show
explained
the
why.
sign conventions on here, but
How
actually
many sign conventions?
sign conventions, he doesn't show when he calculates the difference whether it's positive or negative. All the numbers in the table don't have a sign, don't have a plus or minus in front of them, but there's an implication. Some of them are plus, some of them are minus. So the first one that we just looked at,
For those of you, a lot of you are asking in the chat, what did Burgess testify about this? When Burgess testified about this, he testified that the calls between 1:14 and 5:04 were calls that happened when the car was off and Karen Reed was out of the car and inside One Meadows Ave. So those calls loaded back into the infotainment at 5:07 when the car went on and started backing out of the driveway, so that the time variance or the offset of 1 to 2 seconds between 1:14 a.m. and 5:04 a.m., those are from Karen Reed's iPhone time and John O'Keefe's iPhone time. Those don't truly reflect the infotainment time because they were downloaded back into the infotainment system. They're not from the infotainment system. Where at 5:21 and 5:30, those times are from the infotainment system because the infotainment system was on at that time, but not on at the earlier time. And that's why he did not equate those earlier times, because those aren't calls made through the infotainment system. So those are iPhone time to times. And he discussed that when he testified. That's why he didn't use those other numbers. That's why he used the later numbers. That was his testimony about what he used and why. So continuing on.
Showed we had 2 seconds slow. There's another value in here that's on the other end of that. It shows that Mr. O'Keefe's phone is 21 seconds fast now relative to the infotainment. So that's the largest value in the table we could take that would bring John's interaction window down now. And so if we apply just that adjustment, John's interaction window becomes a +5.
Take a look at slide 11, if we could, please. What are we looking at here?
So I've shifted now from the phone calls, and now we're going to talk about the 3-point turn alignment. And the 3-point turn alignment is first presented in Dr. Welcher's slide from his presentation here. And in this, he doesn't say it explicitly, but he provides some math on the screen, which is a little hard to read. But he puts some math on the screen that shows.
I'm not going to be mad every time he shades the PowerPoint that I fucking hate. I'm just not going to be mad.
He's aligning this 0.154 from Mr. O'Keefe's phone to the end of event 1162-1. This is the prior event. This is a 3-point turn. And so he aligns, he says this is basically how you align it, and he doesn't do the math. Again, he lays out that he says a 19.2 second difference. I actually just adjusted that to 20, which is the most conservative way to interpret that.
Also, chat, if you didn't understand Welcher's testimony until we just went back over it, that's on Welcher. Because the jury does not have, other than themselves chatting about this when they go to deliberate, anyone but the lawyers through their questions to explain it. So if you're like, but I didn't even take that away from Burgess's testimony, you are more like the jury than I am. So if you're like, but that didn't even make sense, you're not wrong. It's just, I am trying to digest this information and share it with you. Also, I spend a lot of time in court. Jurors don't. The way of processing information that I do is not normal to the jury. So if you're like, but that didn't make sense to me, you're not wrong. You're like, I didn't get it. You're not wrong. I'm trying to help you stay on track with where we might see them argue, but just because you didn't get it doesn't mean you're not wrong. It doesn't mean you're wrong. It means that it wasn't explained well by the witness, and that is completely fair.
I don't think we have the accuracy here to talk about tenths of a second. Nevertheless, I just rounded that up to 20. And when we apply that 20 seconds to our event 1162-2, then John's interaction window becomes +6. That's just applying this. We're not combining anything. We're just applying the difference shown in this slide.
And that positive interaction window, is that calculated based on information directly from Dr. Welcher's report?
Yes.
Let's go to slide 12.
So
What are we
this is
looking at
again
here? What is this table?
explaining that window.
This is a table I made.
from
We've talked
the
about a lot of
Aperture
different
window.
approaches to how these clocks can be aligned and a lot of different variables. So I tried to summarize them in one table, put them all together, because some of them we can combine. We can combine the key on with either a phone call or a 3-point turn. But we can't combine, for example, a 3-point turn and a phone call. That's not valid. So I put all the possible combinations, all of them, with, without key switch, phone calls, and .154 on one table, and I calculated John's interaction window for all valid combinations from the Aperture reports. And when we do that, the result is that regardless of what adjustment we make, all of the numbers are positive, meaning regardless of what adjustment we
Ranging
make,
from 8 seconds to what,
phone lock
34
event
seconds?
always occurs
37
after
seconds? 45
the end
seconds.
of event 1162-2.
Did Mr. Burgess, in your review of his report in January of 2025, did he ever undertake all possible offset calculations?
No.
In his May 2025 report, did he undertake
And again, for the defense, it is very important for them to show to the jury, hey, look at all these possibilities. Could be this, could be this, could be this, could be this, could be this. They don't have to nail it down to one thing. That is the job of the Commonwealth. Hey, look at all these different options. So how can you know for certain? That's the focus. Look at all these different possibilities. There's a lot of them. So it could be this much broader range. And some of that range puts it outside the end of the text stream recording.
all possible offset calculations?
No.
What is your opinion in terms of best practices regarding calculations of this sort?
I think if there's sufficient data, if there's testing or research or literature that in a specific case supports there is a best path or a best method, then we should use that. In this case, I don't think there is a best practice. There isn't any literature I'm aware of that would specify exactly the best path to align all of these. So in the absence of any external data to support one path, the most valid approach is look at all of them as a whole and then draw the conclusion from the totality of that data, rather than cherry picking a single point.
Can you testify to a reasonable degree of scientific certainty whether all potential offsets that were described in Aperture's original report, January of 2025, result in a positive interaction window?
Yes.
And what is that opinion?
They do.
Regardless of what adjustment or combination of adjustments we make from the original reports, John's interaction window remains positive.
Does the positive interaction window mean the lock event occurred after or before the text stream event?
It means the lock event occurs after the
End
end
of the recording.
of the text stream event, 1162-2.
Which is why
You've already indicated that you
the Commonwealth continued with their experts to say the end of the recording on 1162-2 doesn't mean the end of the vehicle moving. It's why it was such a big deal when I think it was Welcher said, well, this is where the vehicle stopped. It didn't. And then he corrected himself and said, no, not stopped. It kept backing up beyond that recording, because the Commonwealth is going to argue that even if this adjustment is correct, the Lexus kept moving backwards after the end of the text stream recording. And they were very careful with their expert to say, we do not know if John O'Keefe was hit within that text stream recording or after, because there's no collision event recorded. We wouldn't expect one. So the vehicle kept backing up. I mean, the argument on the other side of that is, okay, but you said the vehicle backed up 87 feet. Where the fuck is it still going if it's still backing up down 34 Fairview? Like, where are you continuing to go? But that's where you see that shift. They're not saying this happened during this text stream data. They're saying the car was backing up during this event and continued on, and it happened somewhere on a continuum. And then there's variances in the time, so you don't know exactly. That's what they're saying.
received a second report, May of 2025,
And
correct?
The
That's
defense
correct.
is highlighting that this shifted, or I think they're trying to highlight that this shifted between the different reports.
In that report, is there the same clock skew alignment or a different clock skew alignment that Mr. Burgess now undertakes?
I think it's variance.
Mr. Burgess undertakes a different alignment in that report.
Let's go to slide 13. Describe what we're looking at in this slide.
So what I have here on the left is a screenshot of page 42 from Mr. Burgess's supplemental report. And so now he's done two things new here. He's identified a new method for aligning the data based on the three-point turn. So now he's kind of following where Dr. Welcher started, but he's approaching it a little differently. And secondly, he is now calculating the actual time. He's doing the difference calculation and he's applying that to the time. So now he's taking the calculation all the way through, which is a little different from the prior reports. And so when he does that, he makes my job really easy because I didn't have to do really any math now. He comes up that there is a range now. So prior to this point, the original report by Mr. Burgess and Dr. Welcher reports all used discrete points in time, right? They sought to find an event that occurs at a singular second and another event at a singular second and align based on that. This is a little bit of a departure from that approach. Mr. Burgess is now using a range of times, a range of uncertainty. He basically assesses that the three-point turn data from the phone and the three-point turn data in 1162-1 cannot be precisely aligned down to a single point. Rather, they overlap in this range of seconds. And so he then says that that range must be applied. So now we have to apply a range. And what we end up with is 9 possible values. So it kind of looks like one conclusion, but really there's 9 conclusions on this slide. And so if we just applying the math he has in the supplemental report, John's interaction window now has a range of 9 possible values. And that range spans from +5 now to -3. So we have 5 positive values. We have 1 value that's 0, and the 0 would mean it's simultaneous. And then we have 3 negative values.
Does Mr. Burgess indicate in his report that any one of those values is more likely than any of the other values?
He does not provide any data or analysis to support one point being preferential over the other 8.
And are there more or fewer positive results in his analysis than negative?
There are more positive numbers in that range of 9 than there are negative numbers.
Does Mr. Burgess's new data indicate anything about Dr. Welcher's analysis about the GPS data point 154 being at the end of the three-point turn?
He opines in that aligning the three-point turn on a singular point is not, and I'm paraphrasing because I don't know the exact way he states it, but not the preferred method.
Is Mr. Burgess's analysis consistent or inconsistent with Mr. Welcher's determination that GPS point 154 was at the end of the text stream event?
Objection.
Sustained.
Does Mr. Burgess, in his report, indicate whether he agrees or disagrees with Dr. Welcher's analysis?
I don't remember specifically.
In your opinion, I asked you about Mr. Burgess's report. Now I'm going to ask you about your opinion. In your opinion, is this new offset any more likely or reasonable than any other offsets previously proposed by Mr. Burgess?
I don't think it is more or less likely. I think it is a valid approach, certainly. And so I think the results from the additional analysis should be included with the analysis of all of the results so far.
And none of those results are more or less likely than any of the others, correct?
Sustained.
Are any of the results in your
The point that the defense is getting to, and I think what this witness answered well, this witness didn't say it's not a valid approach. He said this is a valid approach. However, if you're going to take this approach, you have to take it all. You have to take it all. So if you are going to do that, then that's fine. But then you have a wider range of possibilities. You can't just narrow it down to one thing. And I think that's a fair approach. Hey, yes, this is a fair approach, but then it's this much data. And if it's that much data, then it's that much data, which means there's not one point that's more reasonable than another point. Why are we getting to one point's not more reasonable than another point? Because if multiple explanations are reasonable, there's a jury instruction directly on point that the jury has to take the one that points towards not guilty. So you can't just say, this one's the one it has to be, not this one. If they're all reasonable, then they're all reasonable. And that's where this expert is getting to. Right. All of it's reasonable, which means you don't have one point in time. Anyone who has seen Center Stage will understand the pause before. Take it all. Yes, and all of you have asked for...
Mention it all. Mention it all.
Yes. Let's continue with his testimony. But I appreciate also that he said, yes, you can take that approach. He didn't just come in and slam Aperture. He shaded their slides, which is completely appropriate and deserved. But he also said, yes, you can do this, but consider everything, which is what the defense needs. You just pull those or poke those holes in how many options there are.
Opinion, to a reasonable degree of scientific certainty, are any of the results any more or less likely than any of the others?
It's my opinion they're all equally weighted.
Right, they're all
Did
reasonable.
Mr. Burgess account for the 3-second offset that we talked about earlier in his May 2025 report, his new report?
I did not see any mention of that in his supplemental report, and certainly the 3 seconds isn't present in his math. I don't see it there.
Let's go on to slide
The 3
14,
seconds
please.
is not in the room with us.
Describe what we're looking at here in this table.
This is very similar to the table we looked at previously, where I look at all possible combinations. Now, however, I just have a lot more data points to show, so I've had to break the table into two tables. So we're going to look at this, and then we'll look at slide 15 next.
We couldn't
which is
just
the second
cram it all into one
table.
slide.
I just couldn't cram 30 lines onto one slide.
Let's move to the next slide then. Is this a continuation of
the
the
second half? So think of these as a singular table. I just had to split them up. If we head back to slide 14, we'll start there.
We
so
need both
this slide,
slides.
I'm not accounting for the key on, and that's the main difference between my two tables.
I'm trying to
Table
move them.
1, I'm not accounting for the 3 second key on. In table 2, I am.
When you say key on, you're talking about that 3-second delay.
Correct.
Okay, go ahead.
But again, I want to make sure we're
This table at the top says all possible combinations without key switch, and then event, key on, phone vehicle event, John's interaction window. It's combining the other charts. So I'm trying to keep the closed captions
thinking about this as a
covering the chart too much, but it's going to be difficult. And because the targeted range is at the bottom, I've moved myself up to the top.
singular table because that's where we'll draw our conclusions from. So the first lines of the table, we've already seen those. Those were in my original table. I haven't changed those. That's the same math that's been there. All I did was I added the 9 points now from Mr. Burgess's supplemental report using the range he shows. And so now we can see if we include that, now we get some positive numbers for John's interaction window. We get that 0. And again, the 0 would imply that the end of event 1162-2 is happening exactly at the same second as the phone lock. So it's kind of not on one side or the other. So I think it should be thought of as separate. And then we have 3 negative values, which would imply that phone lock occurs before the end of 1162-2.
And did you already mention the one that was simultaneous?
When John's interaction window is 0, correct?
0.
That would imply simultaneity.
All right, is this 14 or 15?
Simultaneity.
It's 14. Let's move to 15.
I appreciate
Now,
that.
this is the continuation of that. Mentally, we'll just continue that same table?
Correct.
Okay.
Just a continuation. Imagine in your mind is just rows 16 to 30.
Okay.
And it's the same thing, same format, except for now we're just adding in that key on adjustment because, again, I think the analysis should be run with and without it.
Which I appreciate. He's like, look, this is the chart if you don't account for the 3 seconds. This is the chart if you do account for the 3 seconds. I'm showing you the math both ways.
And so now when we run this with the key on adjustment, we get 14 of these 15 are John's interaction window is positive to various degrees. And one of them, it's 0, again, simultaneous. And there are no negative values with this adjustment.
Can we go to the next slide, 16, please? What are we looking at here?
This is the summary then of that table, kind of a verbal summary of the giant 30-line table now. And if we look at all of the possibilities,
Making it
from
easy.
all of the Aperture reports collectively, then we can draw some pretty straightforward conclusions. 25 of those 30 possibilities result in interaction with the O'Keefe phone after the end of event 1162-2. Looking at all the possibilities, 2 of the 30 result in interaction where it's simultaneous. That's the zeros, they're present in both tables. And then looking at all 30, 3 of the 30 result in interaction with the phone before the end of event 1162-2.
So possibilities within each range, which is different than the testimony from the Commonwealth expert who said, every way we ran this, John O'Keefe's phone interactivity, that lock event, happened within the range of the offset.
Do you have an opinion as to which of these particular offsets that you've described, these 30 possibilities, should be applied in this case?
No.
Why is that?
Each of the approaches have their own individual strengths, and each of them have their own individual weaknesses. And there is not really any published literature, any research, or any testing done that I'm aware of that would suggest one really stands head and shoulders above another one of the methods. So I think
They're all
the
equally
most
positive.
fair way to present it is to look at, again, if we combine everything together, then we can draw some conclusions like this in terms of how many of the total result in one outcome or another.
Is every data point that we're looking at and that you've been talking about, are these all drawn directly from Aperture's reports?
That's correct. I have not proposed any methods for aligning the clocks myself. All of the methods that comprise these 30 are from the Aperture reports themselves.
Based on your analysis of the Aperture, or your review of the Aperture analysis,
That's not what I meant to do. Sorry.
is there any ability to say to a reasonable degree of scientific certainty that the text stream event occurred after the last physical interaction with John O'Keefe's phone?
Yes, there would be three out of the 30 possibilities would result in that.
Right.
Do you have an opinion to a reasonable degree of scientific certainty that it did happen after the text stream event?
Sustained.
Of the 30,
I
what's
don't.
the percentage?
Jackson is trying to push into an area I don't think he needs to push into, because he wants to narrow it down even more. I don't think they need to narrow it down even more. If there are jurors who liked the Aperture witnesses, holding open that possibility, this witness has shaded those slides a little bit, which I cannot hold open the possibility that anyone thought those slides were okay. And he said, look, if you agree with their analysis, that's fair, but you have to include all of the analysis. Because there is no methodology to pick which one, all of these are equally possible. Therefore, all of them are reasonable. Therefore, all of them must be considered. And I think that that's a fair approach. So if Jackson tries to say, yeah, but can't we just narrow it down to this one? He's not going to do that. He's going to say, these are all within the realm of possibility. And the jury then has the information that you cannot narrow this down. And that is where the defense can lean into the argument of doubt. If they try to narrow it down and say, no, this couldn't have happened the way that the prosecution said it did, he's going to push too much. But leaving all of those open, I think, leans into that argument of doubt. So that's how I see it. Because the witness, to me, let me know what you think. I think the witness comes across as incredibly neutral. Look, I took their data and I peer reviewed it. I checked their math. And I looked at what they were doing and tried to see what the methodology is for what they were doing, how they did it, and I'm trying to explain what they did. And in explaining what they did, I see where they're coming from, but it opens up all of these other possibilities, and we can't narrow them down. It comes across to me incredibly neutral, more neutral than some other defense witnesses I think we will see. It doesn't come across as if there is an outcome that they are determined to find. Instead, it comes across saying there isn't one outcome that you can define. And that comes across to me as very neutral.
Of possible events that occurred, possible scenarios, I should say, wherein the text stream event occurred after the last interaction with John's phone. What's the percentage?
That's sustained.
You said it's 3 out of 30, correct?
Yes,
Is that 10%?
that is 10%.
Yeah, it's sustained and it's stricken.
That's not your
What
fault,
percentage
witness.
is 3?
He was like, it's not your fault. I don't think Jackson needs to go here. Jackson seems to want to, but I don't think he needs to. And again, this is for argument. Jackson can take that slide in closing and argue it. The jury can see it. The jury can see the slide. 3 out of 30 is less. You can move on. There are more possibilities that it happens outside the recording than inside the recording. That's it.
Just do basic math for me. What is the percentage between 3 and 30?
Sustained.
If I told you hypothetically,
What?
I'm going to see you sidebar for a second.
Why are you objecting? Okay, they're going to sidebar on that. It's getting into argument. I think he can ask hypothetical, but I think Jackson runs the risk of pushing too far because it's a good witness. But if you push too far, you can turn a good witness into not a good witness. The data speaks for, literally the data speaks for itself.
following your analysis of the
We're at
of
full
the
race
totality
loquitur.
of the possible scenarios, did you come to a conclusion that the vast majority, let me rephrase that, did you come to any conclusion about the numbers as they relate to the positive interactions versus the negative? And when I say positive versus negative, I'm talking about the phraseology that you used. John's phone interaction being in the positive side versus John's phone interaction being in the negative side.
Yes.
And what were those?
Of the 30 possibilities, 25 of them, it's a positive. John's interaction window is positive for 25 of them.
And only 3 were negative?
Correct. Only 3 of the 30 were negative.
Okay, we can take that slide down. Is there a data recorder on the Toyota SUV that we've been talking about, that 2021 Toyota SUV 570, that's designed to record impact?
Yes.
What is that? What is that mechanism?
I'm
That would
glad
be
he
the
moved on.
airbag control module,
The ACM?
ACM.
Did you look at that?
Isn't that a music
I was
awards?
provided a copy of the download from the ACM.
What did the data recorder indicate, if anything, related to any impact on January 29th, 2022?
There were no recorded events whatsoever on the ACM.
Did the vehicle control history record whether there was any history of a collision on that car? Ever?
No.
Right.
What does the vehicle control history record specifically?
You guys in the chat have said, Emily, no, there are the AMCs and the CMAs. Aren't there the ACMs as well? Academy of Country Music? No? Have I just turned everything into country music?
It records
I haven't lived in Tennessee that long.
a lot of operational parameters about the vehicle. What I mean by that is it records things like what the driver is doing, for example, steering wheel angle, accelerator pedal position,
So a lot of you are like, yes,
whether
the
the brake is
ACMs.
being pressed. It also records what the vehicle is doing, for example, speed, or the engine RPM, or the accelerations of it.
They're the CMAs and the ACMs. There's both.
Does the tech stream data event indicate that there's a, and I'm talking about very specifically the tech stream data, does that indicate whether or not there's a collision in the car?
No.
Right.
Does the tech stream data event mean that if you find a tech stream data event or a trigger event, does that mean that the airbags are deployed?
No.
Does it mean that the vehicle impacted with something solid?
No.
Does it mean that the vehicle impacted with a pedestrian?
No.
You reviewed the raw tech stream data associated with the entirety of Ms. Reed's vehicle. did
It's
you
a
not?
good line of questioning.
How many tech stream events?
Any
or
events
triggers
register a
were
collision?
found
No.
on Ms. Reed's vehicle during the course of the 8-month period prior to January 29th?
So can you narrow that, Mr. Jackson?
He did.
Sure.
I object to the whole line.
No. This came up with the other experts and he narrowed it down. How many tech stream triggers were there? It came up before. No. This is a great question. Lisa G said, EDB, I have to ask, was there ever, if any, was there backup camera video from Karen Reed's Lexus? Not in this trial. There was not. Does it exist? Yes. Does it exist in this trial? No. All right, let's zoom past the sidebar, which was a bit of a longer
Anyway, we
sidebar.
just-
Understand.
Okay. Mr.
I'm loving Miss Little's look today. I got to be honest. I love the suit. I love the bright manicure. I'm
Okay. Mr. Jackson,
I'm envious of the ability to wear a button-up blouse because I literally could never. They just fought with me the entire time. I'm here for it.
how much longer? I'm just trying.
Oh, they're trying to decide the morning break. Emily's just standing the
Mr.
outfit.
Jackson, how much longer? I'm just trying to figure out.
I'm wrapping it up, Judge.
Okay.
It's not going to be long. A few more
Really?
questions.
Well, I'm not surprised that it's
I'm not
almost.
curbing you in any way. We just.
I'm not. Why are you asking then? If you want to send the jury to break, send the jury to break.
Understand. Respectfully, it won't be very much longer.
She wants to let him finish. If he's at the, I read this as if he's at the end of his direct, which is kind of the most important part. You want to let him finish as he's built towards the end of that direct before you take the break. If he's not near the end of the direct, you take the break now instead of breaking it up. That's how I read it. But again, when he got into, does any of this indicate a collision? We kind of know he's towards the end of this line of questioning.
You reviewed the tech stream data, otherwise known as the triggers, for the entirety of Ms. Reed's vehicle, correct?
Yes.
How many trigger events did you find in the life of the car?
That was foundation.
Not counting 1162-2.
Let's stop there. Right.
Prior to 1162-2, there were 19 prior events.
And 19 total events, correct?
Correct.
And
19
how many
prior
collisions
events in 8 months.
were clocked
He
by
said
any
0
recorder
already.
on that car?
None of the events were triggered by a collision.
And last question, do any of the tech stream events or any of the data that you've reviewed, either yourself through Mr. Burgess's report, through Dr. Welch's report, do any of the data indicate that there was a collision on January 29th, 2022
It's probably his last question.
at any time? Objection.
Ask it differently.
What did you find in terms of, I want to narrow this question to January 29th, 2022. What did you find in terms of any data regarding a collision?
Neither of the events that occurred on that date were triggered by a collision.
Thank you. May I have just a moment, Your Honor?
And the collision event system in 8 months did not indicate that there was a collision, because if the trigger event coincided with a collision, it would be recorded in two places, which we heard earlier from the other witness and from this witness. And I imagine that he is just conferring with counsel and client and then done with direct and now to the morning break.
Take the morning recess. There's some things that I need to do with the lawyers. That we'll have you come back at 12.
What do you need to do with the lawyers? Wait, what did you just say? We'll have you come back when?
There's some things that I need to do with the lawyers.
I need to hear more clearly what she just said. Did she say 2 hours? We'll have you come back at 12. Okay, so about 10 minutes from now. I thought she was going to say 2 hours. She said 12. It is 11:47 local time.
Can I see counsel at sidebar to save us some time, please?
So they will be back, well, in about 10 minutes from now. That's a long morning break. All right, well, you know what? You know who else needs to use the restroom? Not just the judge, me. So that's like a 30-minute morning break for the jury, a little bit more. So they've got about another 10 minutes. I'm going to run to the restroom real quick. I'm going to answer a few questions, and then I will. But it is a lovely morning here. All of you are like, ACMs, yes. Academy of Country Music. My hairdresser's husband directs music videos, and he is amazing. And so when I look at the different awards that he gets, the ACMs are always up there. Emily, we love that you love music so much. Look, my brain works in music. Music is my happy place. It just is. I lean in. Anyone who's like, I cannot do this task until I've created a playlist knows where my brain's at. Am I a good musician? No, I am not. But I'm a very big fan. Am I a great music fan? I am one of the best music fans. I am one of the best music fans. Not to toot my own horn, but toot toot. It's one of the reasons I love where I moved to so much, because I can get to a concert without it being a fucking 10-hour production. Living in LA and trying to get to the Hollywood Bowl is one of the most miserable life experiences, especially for everybody's like, just take the bus. I'm like, I get car sick AF. Just take the bus. Yeah. Carol by and by said, listening from my car on the way to Franklin, Tennessee, hoping Proctor is a witness. Probably not today, but I hope so too. And don't forget to check out the Frothy Monkey. Now I sound like a tour guide. Don't forget to check out the Frothy Monkey, because love the Frothy Monkey in Franklin. And if you go downtown, depending on how you feel about karaoke, Cross-Eyed Critters is a don't miss for me. Emily, tour guide, Cross-Eyed Critters is a don't miss for me. And if you love an on-off bus tour, the on-off bus tour in Nashville is a lot of fun. And you get to kind of observe the bachelorette party madness from a side. Just from a side. All right. April said, I've never heard her ask Brennan how much longer. She has asked him that a few times, but generally not so early on. Oftentimes, too, Brennan would say, I'm moving into another area. Now might be a good time to take a break. The defense has said that too. Timing is very much a whole thing. Timing is a whole thing. Anna asked, wouldn't the car's side mirrors register with the little light coming on that something was there? Would that not be in the car's data? No one has asked that question. So I do not know because no one has asked what the trigger event is. The data that we heard about what causes a trigger event is that it's proprietary to Lexis, and they seem to think that it could be this, or that. So no one's quite sure what exactly causes a trigger, and that's one of the things here. So let's see. Rahman said, this is what show your math means. We definitely understand why the show your math question was happening. All things dyslexia said, wouldn't the collision with John O'Keefe's car at 507 register with the Lexus? It did not. It did not register with the Lexus. It was asked specifically of the last witness, and it was asked specifically of this witness as well. It did not. So Sarah said, is this guy your brother or something? No, we were just on the same train of thought about our mutual hate for those slides. The slide hate is so strong on those over-crammed slides. It just, But no, my brother is like, missed me on a job that includes PowerPoint at all and does not work in a field where I think he's ever had to do a PowerPoint. I'm going to ask him now. I'm curious. I don't think he's ever had to do a PowerPoint for work, but now I'm going to ask. Pug Mama, thank you for the 5 gifted memberships. Though my brother does get to work with a machine that is called Emily, which is wild to me that that's the acronym. I think it's very funny. So I'm going to answer 2 more questions. I'm going to go to the bathroom. Let's see. Joseph said, long time no see, my fellow law nerds. Glad to see you back again, Joseph. Kelly B said, you just started what's confusing to me. You just stated what's confusing to me. The reverse, so trigger was reversed. Did she drive home in reverse? And if not, when's the trigger that she went forward again? Changing back to forward does not create the trigger event. The trigger event is the one moment in time something abrupt or quick happens with the vehicle, and then there's a trigger, and then it records 5 seconds, or it locks in and downloads the 5 seconds that it recorded before and then the 5 seconds that it recorded afterwards. But shifting back into forward did not cause a trigger event. So that is helpful. The Lauren, thank you for this super chat. Lauren said, due to you discussing ADHD symptoms, I realized what I knew about ADHD was incorrect. Look, I'm just one person and I can only share my experiences and the experiences of my friends, but I'm glad to hear this. Because Lauren goes on to say, I thought I was lazy, but nope, I have ADHD and anxiety. Now I can deal with them. Thank you for being honest and forward about being neurospicy. You're welcome. Look, if we know how our brains work, we can work with it. If we are told we should do this way or we should do this that way, oftentimes we blame ourselves for not being able to do it that way. And it's not us. People said should. Emily, you've just shoulded when you're saying don't should. Wouldn't it just be better if we conversed more about the fact that there is no one right way unless it comes to loading my dishwasher, and then absolutely the fuck there is one right way. But there's no one right way to learn. There is no one right way to do life. There is no one right way. And so especially when we're growing up and we're told you should study this way, you should learn this way, you should retain information that way, it's not right. It's changing. But a lot of us grew up in a time where it wasn't changed yet. And so there was not a lot of acknowledgement of different learning styles. You should be able to sit in a classroom and do this. The fuck I can. Not even a chance. And particularly for those of us that are women, we were not diagnosed. And for men that have more inattentive type, not hyperactivity ADHD, they weren't diagnosed. It was ADHD looks this one way and we're only going to address it this one way. It doesn't just look this one way. And the hyperverbal racing brain is a different type of hyperactivity. It's just harder to diagnose. And then a lot with the inattentive ADHD will beat themselves up for why they can't keep up, and they internalize it all instead of externalizing it. The external is what got addressed, not the internal, and how much people turned it inwards that they couldn't. And that somehow it was a personal failure. It's not a personal failure. It is a system that failed. It's changing, but it changes slowly. And I could rant forever about education. What I love is that teachers are advocating so much for it to change and are fighting for changes in education and learning how we learn. And I think in a world of AI, the thing we need the most is to learn how we learn and to learn how we operate as humans better and to learn how our emotions impact us, to learn how our learning impacts us, to learn how stress impacts us. The more we know ourselves, the better we can do. But it's going to have to change because the world is changing. Melissa said, going to Nashville, I deal with a 16 and 20-year-old. It depends on what they're into. I love the on-off bus. The Parthenon is really freaking cool in Centennial Park. The campus of Vanderbilt is beautiful. Belmont's beautiful. The on-off bus tour is a ton of fun because you can go see different things and literally hop on and hop off the bus. The Marathon building's really cool. If they like cars, there's a really cool car museum in Nashville. There's also 2 different retro video game arcades. So if this is not the kind of thing that sounds like a sensory fucking nightmare, the video game arcades are so, like the retro arcades are so much fun. They play music, they have food, they have bars, they have all different kinds of pinball machines and old school gaming machines. They are so much fun. I was playing Mortal Kombat with my teen. Loved it. There's lots to do in Nashville. And if you take a look at what's going on in any of the music venues, you can find music any time of day, everywhere. So much fun. Mary said, anyone else glad to put a face on DiSogra? Yes, I am. I'm very glad. Very glad. Yinzer said, MCA is us, morning court animals. The law nerds. You guys, since we have a longer morning break this morning, I'm actually going to take a break and go to the restroom real quick because I could sure use it. I'm sure you could use it. Court is still on their morning break. I'm going to put on our short morning break with a little bit of music because court's not going to be back for a few more minutes. So let's all take a restroom break. Look, it's Friday. I know I need it. I'm sure you might need it. So I'm going to figure out which music we're going to do. We're going to do the court short break and go from there. Hold on. I know I have a video. Where is my video? I have it. There it is. So I'll be back in just a minute. Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during Verdict Watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdapp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch. Take care of yourself. Trial days are long days. stay in the loop with this trial? I know sometimes it's hard if you miss a day. That's why I've got daily case briefs dropping over on the Emily Show YouTube channel and the Emily Show audio feed on your favorite podcast app, so you can stay in the loop even when things get busy. All right, chat. Are you ready to go back to court? Let's turn off our music and let's get back into court. I feel like I should give just a little bit of a... And then we are going to get back to court for the cross-examination of the defense's first witness. If you are just joining us, we were just at an extended morning break. We are in the first witness of the defense, who is their tech expert, engineer, accident reconstructionist. And yesterday we were talking a bit about whether or not the defense would come out of the gate with attacking the data that the jury was left with from the prosecution. And that's what the defense has done with this first witness. They have come out of the gate with this witness evaluating the reports of Burgess and Welcher and talking about the timing possibilities when you're trying to correlate the text stream event 1162-2, the backing event from Karen Reed's vehicle, and the time on John O'Keefe's phone. And what I appreciate that this witness did is they took the crammed and complex slides from Burgess and simplified those down. And instead of this witness just saying everything they did was wrong, this witness said, look, there are some things left out, because if we're following this process, then it opens up more possibilities. And the witness went through 30 different possibilities of timing between the Lexus text stream time and John O'Keefe's phone, and showed where all those different events fall when you try to correlate the timing, and said, look, there is no way to pick one of these. All of them are equally possible. So with all of them, 3 of them show that the end of the recording of the text stream event, 11:62:2, happened after John O'Keefe's phone used the manual button click. 2 of them showed it was during, or there was some synchronicity. And the rest of them showed that the text stream recording ended before John O'Keefe's phone was put into lock mode. And we've seen the prosecution shift their timing a bit in this too, where the prosecution has not said that it was during the 11:62:2 event that John O'Keefe was hit. They said that was the backing event, but that event stopped recording and the car, they argue, continued traveling backwards. So the Commonwealth is allowing the possibility for argument that after the recording stopped, the Lexus was still traveling backward. So wherever that timing correlation is, they're going to argue that they don't know where in that backing event John O'Keefe was struck, but that he was struck during that backing event. But it could be at any point in time there. And so the last lock on the phone being so close in time to the backing event, I think they will argue, indicates that that's what happened. Now, do I think that that is specific enough for all jurors? Not necessarily. But the defense used their first witness to say, okay, so from Karen Reed's car, did Karen Reed's car ever, in the time she was driving that car, 8 months, ever register a collision? No. On January 29th, 2022, during any of these trigger events, did it register a collision? No. Were these trigger events triggered by a collision? No. Were any of the trigger events triggered by a collision? No. And went through no collision, no collision, no collision, no collision. And went through all of it. So we saw more discussion again of pinning John O'Keefe's, or trying to align John O'Keefe's phone to the phone calls from the text stream or the infotainment system, not the text stream, and then trying to align John O'Keefe's phone to the 3-point turn before the backing event happens. But this timing is critical because the defense has the easier argument here saying, hey, when did this happen? Because if it could be here, it could be here, it could be here, it could be here, it could also not be. The Commonwealth has to close those doors. All right, y'all, let's get back to court. I hope we're all caught up. Do we feel all caught up? Hopefully we feel all caught up. It's day 24. A lot has happened. Let's get into cross-examination.
Mr. Brennan?
We know Emily, you're immediately pausing. We know Mr. Brennan loves a leading question, and this is the first time he's out of the gate for cross.
And Mr. DiSogra, I'm going to ask that you keep your voice up because we're going to try and keep the air conditioning on. And the fans, it's a little stuffy in here.
Is it getting warm in Mass?
Directly into the microphone, that would be great.
Not a problem, Your Honor.
Thank you.
Getting warm in Mass?
May I proceed?
Please.
Good morning, sir. Good morning, sir. Sir, are you trying to offer an opinion suggesting that Ms. Reed's Lexus never hit John O'Keefe on January 29, 2022? Objection.
I'll allow it. Is that what you're doing?
Is that your opinion?
No, sir.
Are you offering an opinion that Ms. Reed's Lexus never got in a collision before?
Yes. Never registered a collision.
The way I stated it was none of the prior events were triggered by a collision.
What I'm asking you, are you offering an opinion that Ms. Reed's Lexus never got into a collision before January 29, 2022 or on that day?
No.
So when you were talking about collisions to the jury, you weren't making any suggestion that that Lexus was not in a collision, are you?
I think you threw a double negative in there. Can you just clarify what you meant? Yeah.
You were not suggesting to this jury that Ms. Reed's Lexus did not ever get in a collision before?
No.
Okay. You're just saying that there's no data on the text stream to suggest a collision.
Specifically, none of the events were triggered by a collision. That's
Text stream data can be triggered by a number of different things other than a collision. Isn't that true?
correct.
And in fact, when you talk about text stream data, you know that text stream data does not record a collision. You know that.
A collision is not one of the triggers. That's correct.
Right. So when you were saying it,
I think that's the first time we've heard that a collision is not one of the text stream triggers. but a collision that would trigger the black box system. But we know, I saw Melissa in the chat and a lot of you asked, what about the collision with John O'Keefe's car? It didn't register anywhere in Karen Reed's car. And the last expert said they didn't expect it would. They didn't expect it would trigger a collision recording with the black box, because it's the black box that does the recording of collisions. But that needs to be triggered by a larger collision, not the car's bumping. It is something that records a larger collision event, and the slower speed hit between the two vehicles, he said he wouldn't even expect that to register on the black box. The trigger events register other things the car is doing with its systems. But we went through that with the last experts, so I'm not going to go through all of it again. But it makes sense. Are you saying the car never got in a collision? No, I'm saying it never registered a collision.
It wasn't triggered by a collision. It's never going to be triggered by a collision ever on tech stream data.
Not the collision in and of itself, correct?
Because tech stream doesn't trigger for
So
collisions.
there's other things that will trigger tech stream data,
Correct.
like sudden acceleration.
The only acceleration trigger that I'm aware of on TechStream is if there's a large acceleration during what Lexus calls a PCS, or a pre-collision safety event. But a large acceleration on its own, I do not believe is one of the triggers.
Are you sure you know a lot about tech stream data?
Yes.
Sustained.
It's
You know a
argumentative.
lot about tech stream data?
Yes.
And you're saying that if a car accelerates over 30%, in and of itself wouldn't initiate a trigger?
I'm not sure I understand.
You just said pre-collision is the only time sudden acceleration, from your perspective, would cause a triggering event. Now, I'm asking you,
I'm allowing this.
if someone accelerated Miss Reed's Lexus at over 30% acceleration, would that cause a triggering event?
I am not sure what you mean by 30% acceleration.
Accelerator, 30%.
Accelerator pedal.
Yes.
Oh, yeah, there's a lot of triggers there's a number of ways that these VCH events can be triggered based on the accelerator pedal angle. I think, is that, yeah.
And what is the percentage from your experience that would create a triggering event?
There's various. Toyota, Lexus calls it high, medium to high is what they put it.
Do you have a number? Do you know the actual data on what percent of pressing the accelerator on the same Lexus as Miss Reed's would create a triggering event? Do you know?
Off the top of my head, I don't know the exact percentage down to this percentage point, no.
I would like to know, though.
There is something different than the tech stream data. That's the EDR data, correct?
Yes.
You would not expect, it would be abnormal for the EDR to register data based on a side swipe between a 6,000-pound Lexus and a 216-pound person, wouldn't it?
Objection.
I'll allow it.
That would be abnormal to register that data into the EDR, wouldn't it?
Yeah.
I don't know if I would use the word abnormal, but I would state it that there's a minimum threshold to record in the EDR, and
What's
a
that?
pedestrian impact generally wouldn't meet that.
I'm sorry.
A pedestrian impact generally wouldn't meet that, but I don't want to make a blanket statement as if it's always the case.
You're saying it would meet that.
Would not.
Would not. Okay. And a side swipe or a clip has less force and impact than a head-on collision, depending on the speed, correct?
Generally, yes.
When
Okay.
you are
That answers that question. A vehicle pedestrian collision would generally not trigger the EDR event. So that's what the Commonwealth expert said too. We wouldn't expect to see it.
discussing the triggering event, that is the moment that something registers to the car to capture data in the text stream, correct?
Correct.
So if I was to suggest 30% of depressing the accelerator pedal would cause a triggering event, would the triggering event be when it reaches 30%?
Yes.
The event data captures potentially part of an event, doesn't it?
I think we're into semantics a little bit, and I think it depends on what you mean by event.
Exactly.
Because previously we'd been talking about an event as the data, but event can mean a lot of other things.
If an event's only 3 seconds long and 10 seconds of data is captured, then the data will capture more than the event, correct?
Correct.
If the event is longer, 15 seconds, 20, 25 seconds, and the data is only captured for 10, the text stream data only captures part of the event.
You're
Correct.
Fair to say?
Very fair.
So when you're looking at the data,
what Brennan is trying to get to, and the reason he's like, we're in semantics, because the way they were using the word trigger event earlier is that there is a thing that causes the car to go, oh, we should record. We might need this information. We should record it. We should memorialize it. But that is one point in time. And that one point in time is caused by a variety of different things. Here, it seems to be the throttle percentage. So that is one point in time that triggered it. But the event that follows the thing that's done to trigger the recording can take more time. The accelerator or the throttle can be at that percent for more than 10 seconds after it's depressed, but all of that wouldn't be recorded. The one thing that happens that caused the car to go, ooh, record, could be a longer chain of events, but the car captures 5 seconds before the, oh, we should track this, and 5 seconds after the, oh, should we track this? Brennan is going to get to, so the car would keep going. Because the car will keep going. So it depends on how you talk about event, the driving event that follows the thing that made the car go, we should record this, we might need it. Hopefully that makes sense, but that's where he's going. So the car could keep moving. Okay. And this expert's like, can we clarify a little bit? Which I expect with every expert. Can we clarify that? Because what do you mean? Fair.
data, it doesn't tell you about the entire event, correct?
The data only tells us about the window of time the data captures. There's no way to know beyond that from the data.
All of your equations and pluses and minuses and graphs you're talking about deal with the 10-second text stream data that was captured, correct?
I don't like him
They deal with
discounting
event
all those pluses and
1162.2,
minuses.
right, and the 10 seconds it's
It's based on
comprised of.
your
Actually, they really just deal with
expertise,
the end of the event. That's what everything in the Aperture reports reference.
Fair enough. But it doesn't deal with anything that could potentially happen after those 10 seconds, does it?
No.
Or anything before?
No, it does not.
The triggering event is spot in the middle, captures 5 seconds before, 5 seconds after.
Approximately 5 seconds. It's not exact.
And you would have to look elsewhere for evidence to know what might have happened before. Yes?
Correct.
And you'd have to look elsewhere for evidence to see or determine what happened after.
Yes.
Do you know at the end of this triggering event, that 10-second
That's where I thought he was going.
window of data, do you know
Well, it's really 5 seconds at the end. But
what happened with the defendant's Lexus after that 10-second of data?
No,
You have no idea, right?
I don't.
Okay. I want to just ask you some
Great.
questions about
Nobody
your
does.
background and then leading into this case, if I could. You have a bachelor's degree and a master's degree.
That's correct.
You've worked for your company for some time.
Coming up on 13 years next month. Correct.
You've advanced through the company.
Yes.
You presently are the director of engineering.
Yes.
Are you ACTAR certified?
No.
What is ACTAR?
ACTAR is a body that
Yes, I just tried to take notes on ACTAR certification, and yes, I wrote ACTAR. Yes, I did. Yes, I did. I keep trying to remember what ACTAR means, but my brain just defaults to ACTAR. They're not the same.
Basically offers a certification in accident reconstruction.
Do you offer services as an accident reconstructionist?
Sometimes.
And you have been hired and come into court and offer opinions as an accident reconstructionist?
In the singular time I've testified in court, it was not specifically for accident reconstruction, it was data analysis.
Okay. You continue your education and you go to a number of different trainings and seminars as well as teach, correct?
Regularly.
And when you regularly go to continuing education, you have quite a bit of continuing education that you've been through, haven't you?
Sorry?
You've been through quite a bit of continuing education.
Yes.
You focus, as part of your specialty, on EDRs, don't you?
That's correct.
Event data recorders?
Correct.
In fact, when you promote your services, that's one of your real specialty, isn't it?
Correct.
And it's something that not only are you schooled on and you go through continuing education, you're well published, aren't you?
That's correct.
And in your publications, you speak primarily about EDR type information.
Yes.
And that's something you are well skilled in, isn't it?
Yes.
Now, forensics or data forensics is a wide field, isn't it?
It is.
And you can do some things or many things in it, but oftentimes people specialize in parts of data forensics, don't they?
Generally, yes.
Well, speaking of you, you specialize in EDRs, true?
Yes.
There is a difference in different subspecialties, isn't there?
In general,
Oh, yes.
yes.
Okay. Now, are cell phones, is that a subspecialty in digital forensics?
Yes.
Is that something you're a specialist in?
No.
He's
iPhones.
very clear with what he
A
knows
specialist in iPhones.
and
No.
what he does.
Have you ever taken any specific training on mobile forensics?
No.
Have you ever written any papers on mobile forensics?
No.
Have you ever promoted yourself of having any type of subspecialty as an expert in mobile forensics?
Never.
In any of your continuing
It's not-
education, and you have a vast amount,
That's not my shit.
have you ever taken any classes or seminars in mobile forensics?
No.
He's trying to differentiate Burgess.
Have you ever
I don't
taken
know if
any
it's going to
class or
work
study
with Burgess.
about variances between infotainment systems and mobile forensics?
Classes? No.
Have you ever attended any seminars on variances relative to mobile forensics?
No.
None of this matters for
testified
the work that he did
about
in this
variances
case.
in
that's
mobile
the game on
forensics
cross.
before you testified in this court today?
No.
Have you ever published anything to do with variances in mobile forensics?
No.
In this case, you had an opportunity to review a number of reports from Dr. Judd Welcher, yes,
Yes.
and Mr. Shannon Burgess.
Correct.
In reviewing those reports, you've offered your opinions and analysis. Did you ever engage in actually any efforts or study in this case to obtain data?
He said no. He got
Could
their
you maybe
data.
clarify what specifically you're asking?
Yes.
He got their
Did you
data.
ever yourself, not watch someone else do it, did you ever download or obtain data in this case?
No.
No.
Did you ever test Miss Reed's car?
No.
Did you ever get an exemplar vehicle to run any tests?
I did not.
He's asking this because it will matter to some of the jurors. But
Did
that's
you
not
ever
the
do
purpose that
any
he's here for.
actual
But it may
testing in
matter
this
to some of
case?
the jurors.
No.
He wasn't here to do
And so
testing.
your role is to look at other people's work and offer opinions and criticisms, basically.
Opinions.
And provide some clarity to the work, but generally, yes.
Clarity for who? Who asked you to provide clarity?
Well, for the jury, but
My clients in this case.
You what?
Mr. Jackson,
Right, okay.
my client.
Did you ever speak to me?
No.
Did you try to speak to him? No, he gave you a report. That's the normal process, Brennan.
As an expert,
You know it.
when you analyze data, whether you actively got it yourself or not, do you ever give an opinion in paper called a report? You ever write a report?
Yes.
And you've seen reports in this case that you've looked at, correct?
Correct.
A number of reports by Mr. Burgess,
Correct.
report by Dr. Welcher,
Also correct.
reports that you're critiquing, right?
Correct.
Did you see Ian Whiffin's reports?
It did not.
How about Jessica Hyde? Did you see her reports?
not.
You were asked to consider information
didn't
from
need
Mr.
to.
Whiffin's report.
No.
Well, you were asked to assume that the last user interaction on John O'Keefe's cell phone was 12/32/09.
That was stated in Dr. Welcher's report, so I started my analysis at that level.
So none of the information did you actually personally go and vet or analyze or make any determinations about. You're just critiquing written reports.
Correct.
Again, that's not what he's there for. It will
Well,
matter to some jurors.
As an expert,
That's
coming
why
in
he's making the
court
point.
and testifying and having opinions, you put together a PowerPoint, didn't you?
Yes.
Why didn't you ever put together a report to share the basis of your opinions and the process you went through to arrive at your opinions before you came into court?
Primarily, I wasn't asked to, so I didn't do it. I wouldn't commission work without being asked to do it. And number two, the extent of my
The
work
shade.
beyond building the PowerPoint was just basic addition, just adding numbers together that already existed in the Aperture reports. So there wasn't a
Completing the
tremendous
work.
amount of complexity to what I engaged in.
What about your work product and your calculations? Did you do all this in your head, or did you type it out and go through a computer program? How did you do it?
I used a calculator for most of it, and
I mean, it's
the
math.
tables in my PowerPoint were generated in Excel, which has some calculation capabilities.
Were you ever asked not to write a report?
No.
You had provided an initial PowerPoint,
Yes.
and then you received information from Mr. Burgess,
Yes.
and then you added new slides
George.
to your PowerPoint.
That's correct.
Mr. Burgess's report was May 8th.
Yes.
You provided your PowerPoint on May 25th.
Correct.
Did it take you that long for the calculations between when you got the report and May 25th to put together the new presentation?
No, it didn't.
Why did you wait until May 25th to provide the new information?
That's when I was asked to do it.
What do you mean by that? I just want to see what the date is today. Today's the 30th. When you finished your PowerPoint on May 25th, did you send it to the defense on May 25th?
Yes, I did.
They had a copy of your PowerPoint on May 25th. Don't be shy.
No, I'm pretty sure it was the 25th.
Ew.
So sustained.
Brennan, ew.
Um,
If he needs to check his report, he can check
yeah,
the
if it wasn't the
report.
25th, it would have been maybe the day after, but it's dated the 25th. I'm almost positive I provided it on the 25th.
There's
Yeah.
no reason for you to hold on to it for a couple extra days.
No, I think it was the 25th.
Do you know what was provided to the Commonwealth, that report?
No, I don't.
In the 25th, the report that you provided to the defense on the 25th, it had new information.
Can you go back to the mic, Brennan?
It had the information from Mr. Burgess's supplemental report. That was the
And Chad, I know you're like, fuck it, Brennan, stay away from the mic. We don't want to hear it. We don't want to hear it. But yeah, no, Brennan, come back to the mic. We want to hear your cross.
additions.
Why did you wait until the 25th to put it together?
That's when I was asked to do it.
Who asked?
My clients, Mr. Jackson.
Jackson.
He said, please have this on the 25th.
We had a phone call on the 25th and discussed Mr. Burgess's supplemental report. During that phone call, he asked me to update the presentation, and I did so, and then provided it.
Okay.
How did the date of the 25th come about? Why the 25th was the date you provided?
That's when he requested it. I think it was a Sunday, actually.
When you
Brennan's,
first got involved
Brennan's
in
getting
this
at
case,
this changed
it was last fall.
late because the
Correct.
defense is playing that game too. That's what they're
And at
getting
that
to.
time, you received some information that
Both sides are going to
Mr.
play that
Burgess
game.
wanted to look at the text stream data or the different modules on what you later learned was the defendant's Lexus, correct?
Correct.
There was a proposal from Mr. Burgess. Mr. Burgess wanted to go back to the car and look at the modules and try to download more information from them, correct?
Correct.
And you then got involved to look at what his request was, the procedure that you wanted to follow.
Yes.
When you did that, were you given any materials about what had happened before you and Mr. Burgess both got involved?
I don't recall specifically, and I don't think so. I think I was just provided the notice of testing that was to be done.
Well, you ended up drafting an affidavit.
I did.
And in drafting an affidavit, you pointed out some oversights of Mr. Burgess, didn't you?
I did.
Determining the oversights required some study of actually the data and the information that was available, wouldn't it?
It would.
So, can we presume that before you wrote the affidavit pointing out the oversights, you had looked at other materials?
If I recall correctly, the notice of additional testing from Mr. Burgess contained attached to it a whole report by him documenting why he thought there was an inadequate initial acquisition, why he thought the sizes were wrong. So I don't remember referencing anything beyond all the information that was contained in that. And whether that was combined by somebody else or not, I don't know. That's how it was provided.
Did you end up looking at the report of Ms. Gaffney and what had happened in the past with the download and search of Ms. Alexis materials?
If I'm remembering right again, I think Ms. Gaffney's report was also attached to that same singular file.
You learned that the defense expert, Ms. Gaffney, had downloaded data from chips, correct?
Correct.
And Mr. Burgess was asserting that there was information missing and believed that there was missing information from the chips.
Correct.
In that form, it's sustained. It's stricken.
Okay.
My apologies. The conclusion
My apologies, he says.
Mr. Burgess had is that he believed there was missing information from the chips.
He did. He miscalculated the size of the chips.
Did you do any study to see if there was actually information missing from the original download?
No, I looked at the data sheets for the chips and then immediately.
Burgess already testified that he miscalculated it and there wasn't any data missing. Don't misstate what Burgess said. Burgess said that there was no data missing and that he didn't obtain new data.
Immediately realized what the error was. The data sheets specify a size in megabits or gigabits, and Mr. Burgess had written his report in the context of megabytes and gigabytes.
And then you asserted, or you took the position in your affidavit, that there should be no further chip lock, no further study of those chips, other than to ensure the amount of memory was sufficient.
It's not how I recall specifically what I said.
Well, let me read it because I don't want to try to malign your words.
Please.
And don't put words in his mouth.
Mr. Burgess proposed protocol.
I also appreciate that the way he responded to that is, I don't remember that that's exactly how I said it. I appreciate that. He's not fighting with him, but he's also not going to adopt something that's not accurate.
Labeled, we attempt chip-off acquisition is unnecessary because the file size of the acquisition performed by Ms. Gaffney already matches the expected memory storage capacity of the components.
That sounds accurate.
If you want to see this, I don't want to read from the document. If you need to see it actually, just let me know.
That's fine. I trust your reading.
However, an acquisition may be conducted.
Right, I don't need to see it. I don't need to fight with you.
The contents of the memory chips have not been altered since the last testing by recording the checksum.
Yes.
Did it cross your mind at that point that there was important data in those modules that was not seen or recovered or obtained by Ms. Gaffney?
No.
Did you want to know when Mr. Burgess was looking for more data, more information, what he thought was missing?
He stated, I think, in his report or affidavit, I'm not sure what it was, but he stated what he thought was missing was there was a physical size difference. So he thought there was not corrupt data, but just missing chunks of data.
Log on information, you've heard of that. Ignition on is the ignition off information.
Yes.
And an infotainment system. That's important information when you're reconstructing an accident, isn't it?
It could be.
Well, you read information in this case. Pretty important in this case, what you said.
Yes.
And so you would not want to engage in that process without this pretty important information, would you?
Which process?
Of an accident reconstruction?
He wasn't doing accident reconstruction here.
Sorry, so can you restate it, the whole question?
I'll
Yeah.
ask it again.
Yeah.
You said you
Excuse
have some
me,
experience
what?
in accident reconstructions.
Yes.
Don't you want all the data available? The more data, the better.
Generally, yes.
You wouldn't want to ignore data on purpose, would you?
No.
He thought he had it, though. That's what he just
Data
said.
analyst, the more data, the more you get to look at.
Yes.
And so the power log on information that actually has date and time, that's critical in an accident reconstruction, isn't it?
In some accident reconstructions, in some, there's no debate about when a vehicle was on or off, but if there is, then yes.
Not just on and off. The power log on and off gives you the date and time that you can match with the text stream data, correct?
Yes, it
Because
does.
you know text stream data itself doesn't have date and time.
It can, this vehicle didn't. It can, but this vehicle did not.
This had a running time instead. Like a
That's
stopwatch.
correct.
So this data that was not found during the initial process, that was critical data left behind.
I don't think prior to the process anyone knew that this particular Lexus infotainment system stored those key on and key off times.
Right, the only person that found this out was Shannon Burgess.
He found it in the process, but I don't think anybody knew in advance of
Oh,
this
so there
case.
was
There was
new
nothing out there
information.
about it. So to my knowledge, this is the first time that this specific data has ever been released into the wild.
But it was on the board there. So
I think that's actually a really good answer to the point that the prosecution is making for them. The point that the prosecution is making is that no one knew that there was a log that would correlate the key on, key off cycle to date and time. No one knew that the car stored that at all until Burgess found it, which is why last trial there was a lot of fight over the key cycles and when the key cycles could be. In this trial, there has been very little fight about the key cycles and when the key cycle could be, because there was that micro SD card that Burgess took out of the car and found it. So he's saying, no one knew this existed. Burgess actually found that could be gotten because he took out the micro SD card, and that's where it was stored. But what this expert is saying to differentiate it is no one knew that information even existed, so no one was looking for it. So it didn't appear that there was any information missing because no one knew that information could exist. Burgess saw the other card or what have you and grabbed it. So Burgess was the first one that found that somewhere that information was stored. So, and this witness, I think, just said, yeah, Burgess is the first one that actually found it because no one knew it existed. So he didn't think any data was missing because Burgess had misread the size of the chips and said he might have like Inspector Gadgeted his way into it. Burgess is like, I think there's data missing because I misread the chipset files, and then he found data that no one knew existed, so no one could know it's missing, but then he found it. And that's why there's not as much fight over what date and time the key cycles happened, because now there's data that correlates them. That's why there's no fight over when this key cycle happened in the same way. The fight has moved over where the key cycle and John O'Keefe's phone align, not we don't even know the key cycle happened on that day. But it's more clear when he said it.
Knew what to look for or got creative, they could maybe find it.
Yes, more so to your if got creative, because I don't think anyone would have been able to have the foreknowledge that there would have definitely been that.
Shannon Burgess did.
Sustained.
That's argumentative.
I'll strike.
I don't think Burgess knew it existed. Burgess went looking for something else and found it.
Strike it.
And when Shannon Burgess went to obtain that data that everybody else overlooked or didn't know about,
They didn't
you
overlook
went
it.
with him.
It didn't exist from anyone else.
Yes.
So you had a process where he was going to now control the data
When he was
and
with him.
take the
Interesting.
information that was left behind and remove it from the infotainment board, correct?
He actually never specified anything about the SD card in that initial notice. So it was a departure from his protocol, and it was a little surprising to me when I got there that the protocol was written with a specific focus on a number of other chips And it became very apparent to me very quickly that the focus was not on those chips, and the focus was on this SD card that had previously been unmentioned. There was nothing in there about that prior to that.
Did it offend you, or were you impressed that he had found that?
I was a little confused because I went into it with an expectation. Generally, if we write a protocol, we adhere to the protocol. If we're going to deviate, we have a discussion about deviation.
He's like, I'm an engineer. It's not guidelines. I'm an engineer. If there's a plan, we stick to the fucking plan. And if you change the plan, there's a conversation about changing the plan. Don't change the fucking plan. Engineer. Don't change the plan. What are you doing? We don't willy-nilly start pulling chips off. There's a protocol. We follow the protocol. What the fuck? That's the most engineering thing I've heard on the witness stand from any of the engineers. Well, we just adhere to the plan. We don't deviate. An engineer that speaks like an engineer. The engineer's like, what? Stick to the plan. It's not guidelines.
So I was just surprised.
I was confused. He's like, engineers don't do that. What are we doing?
This SD card that had previously been unmentioned. There was nothing in there about that prior to that.
Did it offend you, or were you impressed that he had found that?
That's argument.
I was a little confused because I went into it with an expectation. Generally, if we write a protocol, we adhere to the protocol. If we're going to deviate, we have a discussion about deviations. So I was just surprised. It's not customary to sort of shift out of nowhere. But other than that, I did not know what to think of it because I'd never heard of that.
Did you give any input? Did you have any knowledge about the SD card and how it worked?
No.
So when you watched Mr. Burgess remove the SD card, did you appreciate he'd have to engage in what you call reverse engineering?
He did not elaborate to me exactly what his whole process was at first. It sort of came out as time progressed through the first day in his office in Texas, and then I learned more as we moved to the second.
What's so interesting to me is that this expert generally and traditionally deals with EDR and text stream data. Burgess seems to deal with cars, but mostly deal with phones. So it doesn't, me just nerding through this, it doesn't surprise me that the expert that mostly deals with phones sees an SD card and goes, huh, I wonder what's on there. And someone who mostly deals with text stream and EDR data goes, huh, we don't pull that off. There's no data on it. Everything from Lexus says that the chipset that we have is where the information is stored. So we don't just go noodling around because the information from Lexus says that the information's on these chips. We have those chips. We have all the information from those chips. And phone guy goes, but SD cards store things. So we should look. That makes perfect sense to me. That they're looking at it. Look, there is a phrase that I'm sure is used in many fields, but Dr. B regularly says, you know, if your only tool is a hammer, everything looks like a nail. So I'm not surprised that these two experts with different backgrounds are looking at a set of chips in a different way. Hey, we have all the chips, we have all the data, leave that alone. Hey, SD card, might be something on it. Interesting. But also, this makes all of the sense in the world that he wouldn't think to look there because he thinks he has the complete chipset, and Burgess would be like, no, I want to know what's on the SD card. Interesting.
Testing in Massachusetts, but he didn't explain it to me in one go.
I think Burgess didn't explain it to you on go because Burgess didn't know what was going to happen. Burgess was like, let's see.
Did you, at that point, understand or appreciate the relevance of the SD card relative to the infotainment?
I don't think anyone did.
As far as the amount of information that could then be available?
He never spoke throughout the 3 days at all about what kind of data he expected from the card, or would be on the card, or could be. He made no mention of the data.
I don't think he knew.
No one said to you, but given your expertise, did it ever dawn on you the significance or importance of this SD card that was sitting in plain sight?
No one knew what was on it.
Sustained, you can ask it to.
The plain sight's argumentative.
As Mr. Burgess was recovering this information left behind, that there was something important or significant about it.
At the time, I thought it was a possibility. If you reference the initial work, a number of different memory components were identified in this infotainment. There isn't a singular memory chip. So if we're looking for data, it could be in any of them. So we found a new source of data storage, and there could be something there, there could be nothing there. It was unknown to me.
But it turned out there was.
There was.
Now, when you were watching Mr.
Look.
Burgess work,
Brennan has done a good job of using this witness to make Burgess a better witness. No matter how you feel about Burgess, this witness in his cross has made Burgess a better witness because of what's on that SD card. That is a good cross.
as an expert, if you felt like there was something inappropriate or he had some great oversight, you could write a report about that, couldn't you?
I could.
Did you ever write any report in this case?
No.
So you never wrote a report for your preparation of coming in and your data in the PowerPoint presentation, right?
Correct.
You never wrote a report regarding any of your observations of Mr. Burgess.
Correct.
You said that he didn't say anything. He spoke to you quite a bit during the process, didn't he?
He did.
He showed you what he was doing.
He did.
He explained to you
Wait.
what he was doing.
He explained the process. I think you had asked me earlier about whether he
Were you
explained
like-
the data, and he didn't.
Was Burgess trying to group
He
project it?
demonstrated great proficiency, wouldn't you say?
He ended up with a successful acquisition of the card at the end of the process.
That part. That part. He's trying not to say he got lucky, but that's the answer. The answer is no. His curiosity paid off. Right. Right. He didn't know it was there.
When you are considering
His
all your
curiosity paid
equations,
off,
did you
and it did.
consider the timing information taken from the SD card that Mr. Burgess found regarding power on and power off of that car?
Yes, to the extent that he considered it in his own report. Again, I'm referencing his report.
But how about you? You're coming in here giving an opinion saying what's better or best practice or right. How about you? Did you consider, you personally,
How
the one
about
who's giving the opinions,
you?
did you consider the significance of the power on, power off data as it relates to all these times?
Yes.
He did quite a
Yes?
lot, it
You sure?
seems.
Yeah.
Okay.
I mean, I considered it. If that's the question is, did I consider it? I considered it.
Did you do any study yourself?
No.
Now, we agree, or you agree, that there are variances between different devices.
Yes.
So a Lexus clock that comes from the infotainment system is very common that it would be different than a different device like an iPhone.
Specifically, this Lexus, I don't know if we can make the statement that it's common or not, because, again, this is the only time that I know of that this specific data has been analyzed. So I don't know the answer to that question.
Did you say on direct examination that variances between devices are common?
Variance between devices are common.
In a variance of
Right.
45 seconds, that wouldn't be remarkable on
No.
different devices. It's common in the industry.
Correct.
And in your business, that's an accepted amount.
I'm not sure what you mean by accepted. The amounts are what they are, and we have to correct for them. I've done analyses of clocks that are anywhere from completely correct, 1 second off. I've done analyses of clocks that are 25 years apart. So it's a wide range of possibilities.
What?
I understand your point.
Yeah.
If you see as an analyst a
Was it a clock on the Titanic? Why were the clocks 25 years apart?
45-second variance or 30-second variance,
I have so
that
many
wouldn't shock you, would
questions.
it?
Can I?
No amount of variance would shock.
God damn it, Brennan. I need a side quest. What the fuck do you mean the clocks are 25 years apart? What? Was it the Edmund Fitzgerald? I have questions.
Me is the answer.
I have questions. I have so many questions.
I want to ask you questions and go through your PowerPoint. And I want to ask you your specific opinions and how you arrived at certain claims that you've made.
Sure.
Okay? If we could put up Mr. DiSogra's new PowerPoint 52525. You've made a modification to your PowerPoint?
Yes.
You've made an amendment to your PowerPoint?
Yes.
So there was something that happened, you received new information or new data, and you updated or changed your PowerPoint.
I did.
And that's an appropriate thing to do when you receive new information, isn't it?
Yes.
If you have new data, you don't want to leave
Brennan's-
it behind. You want to make the best presentation with the best data you can.
Brennan's trying to
I want
lessen the
my
sting of the Burgess
presentation of the
report.
data to be as accurate as possible, so I included all the data.
And you would expect that from any expert.
They changed their data. I changed my data. Brennan's trying to lessen the sting of the data change to be like, see, this is what everybody does. It's totally normal.
Wouldn't you, if they received new information or analyzed new data and it was important, it would be an appropriate best practice to update the PowerPoint or information they're providing, wouldn't it?
I'm going to allow that.
It allows him to say, right, if they change
I don't know if
theirs,
I would
I'm
tell
changing
other experts
mine.
what their best practices are. I would say, generally as experts, we do work that our clients ask us to do. So if we're asked to do it, we do it. If our clients say, hey, don't do that, then we don't do it.
Well, you like the phrase best practice on direct, so I'm just wondering if I can borrow that phrase.
The comments, Brennan. I love that Jackson is objecting to Brennan doing the exact same thing that Jackson always does. It's really funny because there is some parts of their style that is similar, and it's just funny that they both have the same kind of comment quips at the beginning of their sentences, but he's trying to lessen the sting of his experts changing their reports. I think this expert, though, can be like, well, he's opening the door for this expert to say, hey, when they updated their report, I had to update my report because I got new information from them. Had they not updated theirs, I wouldn't have updated mine. But he did throw in, I would never just update something without being asked to do it. What is that about? The jury doesn't know all of the back and forth about who asked for the May 8th report, but we do. And he's like, no, I don't do shit that I'm not asked to do. So we're not just running around doing things.
Okay. We can turn to page 2. Now, this is taken from Dr. Welcher's report.
Yes.
And again, you did no testing whatsoever. You just read
I did not.
reports. Did you read all of Dr. Welcher's data, the gigabytes and gigabytes of data? Did you go through it all?
Not every slide, no.
Not just the PowerPoint. I mean the actual massive amount of data in his study. Did you go through the data?
Oh, no, I didn't look at any of the data.
Did you ever speak to Dr. Welcher?
No.
And so when you are making assumptions on what he thought or how he analyzed, you're just guessing.
I am looking at what Dr. Welcher put in his trial presentation, and my assumption that's baked in there is that he's going to stand behind the things he says in a presentation. So I'm taking them at face value, but as being correct.
It's not a matter
I'm
of
not guessing.
It's not a matter if he's going to stand behind it. You don't know why he put something in here. You just see it on the paper. You don't know what his thought process was, did you?
To an extent, yes,
tell.
because I understand how the exemplar testing by Aperture laid the foundation to align the key-on events in the infotainment to the Lexus VCH events.
When Dr. Welcher made his PowerPoint, do you know whether or not he was relying on 154 on Mr. O'Keefe's phone, stamp 154, as the end of the event as opposed to the beginning of the three-point turn, 1162-1?
Based on the math he uses, that's the implication. He puts a number on the screen that the only way you could reach that number is by making that assumption. So when I looked at the math, yes, that assumption seems baked into the math he did.
So this seems like it's baked in that he was assuming 154 on John O'Keefe's phone was the end of the three-point turn.
Not on this slide, on a later slide, but yes.
Oh, chat, no. The lights are off in the courtroom because they were looking at slides, and then the camera chose to not look at the slides. It's not you. It's not you. The lights are off in the courtroom at the moment because there's a slide on the screen. They're just showing Brennan instead of the slide.
And you said that variances, 30 seconds, 45 seconds, they're very common when you're comparing two different devices, right?
Yes.
Okay. Return to the next page, please. You point out 2 times for the jury, the Lexus event 11:62:2 ends 12:31:43, right?
Yes.
And that's based on the clock in the infotainment system.
It's that time is based on 2 things: the clock in the infotainment unit and the cumulative key-on timer in the text stream data. So it's a combination of 2 values.
Which is the running clock.
Correct.
Right. And that is compared or contrasted or coordinated with the log on off time that was found on the SD card. Yes?
Yes.
And without that SD card, we wouldn't have that time now, would we?
Correct.
Okay. 123209 isn't something you analyzed, but you just read in the report that that is information from Ian Whiffen suggesting or taking the position that was the last user interaction John O'Keefe had with his cell phone, 123209.
That's how I understand it. There was a phone lock at 12:32:09. I did not look into the underlying reports from where that came.
And you know those are 2 different devices, 2 different clocks that will have a variance.
Yes.
He's like, I trusted your experts to do their jobs competently, so I just relied on their information. Okay.
You mentioned trigger event, and you said that your preference is to, when you're doing times, to point it from the actual trigger event, and there was a little slap for emphasis to target you on that, right? The trigger event. That's not a standard practice or a protocol that is supported by any type of literature, is it?
It's the methodology I teach, especially in the class I teach on the analysis of heavy vehicle data. We have the exact same problem with heavy vehicles. They all have clocks on them. And so, in fact, I do a lot of clock adjustment on heavy vehicles relative to other sources. And the way I teach it, the way I'm not the only instructor, collectively, the way we all teach it is we generally start the analysis at the trigger, which is not to suggest you have to do that. It's not wrong to do it a different way, but that
That's
would
just
be,
the way they
let's call
prefer
it the default methodology.
The default methodology, do you have any professional literature that says that is the best time to start the analysis?
No, and he didn't say that it was.
Not literature. I mean, that's sort of my opinion, because that is
thank you, sir.
That introduces the least amount of variables. Once you start trying to align events off of subsequent times, you just introduce more addition and subtraction or math you have to do. So it's easiest to do T0 and align everything from there.
If you're lining up the end of
That makes sense to me. And here's why that makes sense to me, as we were talking again about time variance, because what the Commonwealth's expert talked about multiple times in the trigger event recording is that the 5 seconds before recording and the 5 seconds after from the trigger event, which is he is calling it T0, from that event, is that sometimes it is not exactly 5 seconds. So if you're using the end of the event, those events aren't always 5 seconds on the dot long. So if you take the trigger event, you aren't introducing any variables. When you take the end of the event, you now have a variable that it might be 5 seconds. It might be 5 1/4, 5 1/2, 5 3/4. You are now introducing a bit more variable because it doesn't always clock to exactly 5 seconds in real time. And that makes perfect sense to me. If you have a 0 point, use the 0 point. Because otherwise you've got a factor from the clocks, you've got a factor from the count up, and you've got a factor from whatever you decide real time is. Less factors, better math. That makes sense to me.
one event at the end of another event, it's more coordinated than if you take it from different spots, isn't it?
That could be a scenario where then you wouldn't use it. Right. Like I said, it's not the only way, but it's the default way.
I don't disrespect your method, but there are other ways to do it that are just as legitimate as the trigger mark.
Absolutely.
He said that.
And that's why I didn't change the convention here. I used their convention,
So you're
Apertures.
not suggesting that Mr. Burgess was being misleading by choosing the endpoint.
He didn't say that at all.
Pronounced that's exactly the point he was considering.
He said
right?
there's more
No.
variables.
So the word cherry picking, you're not saying he was cherry picking.
He didn't say that.
I don't remember the context in which I used the word cherry picking, but I don't think it was with respect to a trigger alignment.
So there's no
He didn't say they were cherry picking. He said you don't
special
want
basis
to.
suggesting your way is better or worse than going from the front or the end of the event.
No,
So you're not offering criticism on that. So just so I understand.
not criticism. I pointed out that it's not typical, but, and I
it's not
pointed out not
preferred.
even to say specifically that it's not typical, because even that, to your point, might sound critical. I just want to be clear that I adopted their convention. It's not the way I would have done it, but I kept that convention consistent in my analysis. So I wasn't changing in the middle, trying, you know what I mean, trying to obfuscate what I'm saying.
I appreciate that. I appreciate that. So if someone's looking end to end, you're not going to add 5 seconds. It's if someone went from middle to end.
Right. Not the convention.
Could you give me that?
Yeah, you were
A little
suggesting
different.
those questions about, well, since you're looking at the end instead of the middle, then you got to add another 5 seconds on. That's not really an accurate analysis if you're looking at a comparison from end to end. You wouldn't then add the 5 seconds at the time of the trigger because you're starting at the end from both devices.
I'm going to allow it if you can answer it in that form.
I can't even tell what the question was because
It's
he
gonna
walked so
depend
far away
on-
from the microphone.
If you're doing an alignment with something that is a range of values, then you have to be consistent on where you're doing it. If you're doing discrete points, then that's just a single point in time. There's no beginning or end. It's just a single second. So the best answer I can kind of give is it depends on what you're doing.
Well, in this case, you're basing it off the end of the event. The end, not trigger, the end. Comparing it
Right.
comparatively to the end of a different device. So you wouldn't just add 5 seconds just for that.
Brennan, move on.
You would not add 5 seconds for the heck of it.
Asked and answered. You are so stuck in the weeds on this, Brennan. He's answered it a bunch of
You
times.
see 12:32:09
He's actually answered
minus
it
12
saying that he adopted it. He prefers a different way. He adopted what they're doing. He's not saying it's wrong. He is saying that he adopted a different way. Move on. He's not undermining your experts in that. He's explaining the difference in the approach.
12:31:43, the middle line equals 26 seconds. Isn't that in Dr. Welcher's slides before, let me phrase it more cleanly,
Yeah, please.
before Shannon Burgess analyzed the data more closely on May 8th, in his May 8th report? Isn't this the exact difference in time that Dr. Welcher cites in his PowerPoint, 26 seconds?
I'll sustain it in that.
Did you see, when you reviewed reports, that Dr. Welcher uses this exact number plus 26 seconds in his report?
I got the number from the PowerPoint.
I'm sorry,
not the
PowerPoint.
report, but that is all of the numbers here on this slide are from Dr. Welcher's PowerPoint. And on the previous slide, I show that. So these are all just
And-
copied straight from that.
And you've labeled this John's interaction window.
I did.
Okay. Interaction window. Do you think it might be confusing when you use interaction window to make it seem like the event was limited to 10 seconds?
No, and that's not the implication there at all.
That's not what you're trying to say.
That's not what I'm trying to say.
Fair enough. Fair enough.
If I can clarify what I mean by interaction window is that there's
Please do.
a range
I appreciate Brennan's letting
of
him answer.
times that we end up with when we start running these adjustments. So we never land on a singular point of alignment. We end up, like I showed at the end, with 30 points. That's the window that I'm talking about. That's the window that I mean.
So if we could put up page
the
33
impression that I
from
get.
Dr. Welcher's
Sure.
PowerPoint. Just to illustrate the point you're trying to help us with. Like that a little for me? So this represents, you've seen this, right?
It looks familiar, like it's from one of his slides. And if I've seen it, I did not spend a lot of time digging into it.
Does this look like the 10 seconds of data that would be
Can we see the
captured
slides,
from a
please?
triggering event
Can we
in
just,
a textual data?
can we not look at, can we just see the
See it
slides?
sidebar?
I like Brennan's suit too, but can we see the slides? Like, of all the suits Brennan has worn in trial, I think the 3-piece is at the top of the list. But can we just see the slides? And the court is asked to see everybody at sidebar. And we're going to zoom past the sidebar the best we can. Some of you don't like his suit. That's fine. Again, fair. Of the suits Brennan has worn at trial, that is the one I like the best. And even when Brennan annoys me, I still like the suit. Are they still at sidebar? Yep.
Release you for the luncheon break. Took so long here to make sure that we could give you a nice full hour luncheon break. So we'll see you back here in an hour.
All right. Whatever they were doing at sidebar, they're not done.
It took so long here to make sure that we could give you a nice full hour luncheon break. So we'll see you back here in an hour.
Mr. Rice, for the jury.
Okay. And that's lunch, everybody. Let's see if they go back. I doubt they're going to go back on the record. I also... Oh. Nope.
Follow me, please.
That is the court off the bench. After the jury had such an extended morning break, I don't think they give a shit about an hour for lunch. I really don't. I think the jury's like, can we be done? But I also wonder if it's sidebar, and this is pure speculation. I wonder if it's sidebar, they asked the defense if the defense has any other witnesses today, and the defense was like, no, this is our last witness today. So we're going to do cross and redirect, come back from lunch. And I wonder if this will be their last witness for today. That is purely speculation on my part, but it would not surprise me on a Friday where a lot of their experts are witnesses that they might not have another witness lined up today. And so far, this has gone pretty smoothly, but the court is at lunch. I'm going to answer some questions. I'm going to take the opportunity to have some lunch because, well, so many days we don't actually get to eat lunch, and it would be helpful for me as well. So let's see if we can do a lunchtime summary. Let me look at my notes real quick, and then we will take a bit of a lunch break. Now's a good time to remind you that if you want to know when I come back from lunch, the Lawnerd app is the best way to do it. YouTube is not going to notify you when we are back, when we are not back. Of course, you are welcome to hang out here and listen to our fun music and stay in the chat. But also, you could get the Lawnerd app and we will just tell you when we are back. We will tell you when they switch witnesses and we will tell you what we are doing. And if you are watching this trial going, I really don't care what else happens from here. When is Proctor on the stand? We will probably send you multiple alerts. Because when that happens, which I think it's probably gonna at some point, we will let you know. We will let you know 100%. Just 100%. So we will see where we get to the rest of the day, but we will let you know as witnesses change and as we move from direct to cross, etc. Lawnerd app is free. There's over 100,000 Lawnards in the app. So go ahead and download the Lawnerd app on your iOS or Android. Let's summarize the morning. We are at lunch. I think we're maybe midway through cross-examination, it would seem to me, of this expert. And Brennan, I think at points has done a very good job of using this expert to point out what his experts did well. And he's also used this expert to solidify the points he wants to make. He said and asked this expert, are you saying that Karen Reed's car was never in a collision? No, I'm saying that a collision was not registered in the EDR system, and one would expect that a collision with a pedestrian would not register in that system. It's not a significant enough impact to the car. We heard that from the Commonwealth experts too, that EDR system is really keyed towards registering vehicle-to-vehicle collisions, not vehicle-to-pedestrian collisions, and they wouldn't necessarily expect that would register. They, I think, also went through maybe more clearly than witness Burgess did about the second chip-off procedure that this witness was also present for, where Burgess took out the SD card. What the witness was critical of is that they had a fully different procedure prescribed for what they were going to do that day. And then Burgess was like, but there's an SD card here. We're taking that too. And this witness said, Burgess didn't explain what he expected to find on the SD card. My takeaway from all of this was that Burgess didn't really know what was on the SD card, but because Burgess wasn't sure if you had the totality of the information because of the bits versus bytes issue, Burgess's confusion about bits versus bytes led him down a rabbit hole that he wouldn't have gone down otherwise to look for that SD card. And then when he found the SD card and started downloading it, remember, Burgess's background is more in phone technology and mobile technology than vehicles, though also in vehicles. He went looking for that SD card, and the SD card happened to be where they stored the date and time that connected to the key cycles. So there was new information on that SD card that took the key cycle 1162 and had a date and time for when the car turned on with that 3-second variance. And that's why we've not heard as much fighting over the key cycles. Was that super clear when Burgess testified? No. But did Brennan make it more clear in cross? Yes. And I think that's because Brennan is much more adept at doing cross-examination. He is traditionally a defense attorney, and that does not surprise me. But he, I think, asked good questions of this witness to point out the information that Burgess found. Now, does that make Burgess a better witness? I think it clears up the information that Burgess got that this witness then said was valid information. So do I think this witness a bit bolstered Burgess in not discounting everything Burgess did? Yes, I do. But what I think the purpose of this witness was, and where the defense has room to argue with this witness, is that even though I'm relying on all of this information from Burgess and Welcher as accurate, they narrowed it down too much. And there's no reason to narrow it down that much because all of these different time variances are possible, which is really the power of this witness. All of these different time variances are possible. So yes, relying on their data, and yes, taking everything in this data as accurate and true, it was narrowed too much. And that's really the point of what this witness is here for. So where we see Brennan starting to get into the weeds is, well, did you download the data yourself? This witness is like, no, I just assumed that you're experts, and this witness would never say that. He has been very polite. But this witness essentially said, no, I relied on your experts to do their job, and I took their data as true. And I relied on the data that they got. I wasn't here to download new data. I was here to evaluate their data and see if it was reasonable to narrow it down to one time variance between the Lexus clock and the phone clock. And the thing is, there's too many factors to pick one. All of them are reasonable. So I'm not saying they did it wrong. I'm saying they narrowed it too much. But I relied on their data. It's interesting that Brennan went down that road of questioning so much about, well, you didn't download the data, you didn't do this, because the witness didn't challenge the data. The witness never said that the data was unreliable, that the data wasn't accurate. He just said it's broader. So it was interesting how much Brennan went down that road that I don't think he needed to go down. And are you saying that this witness shouldn't rely on it? Like, what? I don't think that's helpful at all. I like how the witness testified. I think even on cross, when he pushed back on, I need more clarification, it really came across, not that he was being evasive, which we've seen from some experts in this case, but that he was truly trying to clarify, like, are you talking about this or this? Which I appreciate from experts. No expert's just going to adopt what they're told on cross. But also when Brennan said, I think you said this, and the witness said, I'm not sure I said it exactly that way. Brennan read it from the report and said, do you want to see this report? And the witness said, no. That sounds like what I said in the report, which is a stark difference from so many of the Commonwealth witnesses saying, well, let me see the report. Well, where is that written? Well, let me see this. Well, let me see that. This witness was like, no, yeah, that sounds like what I said. Mm-hmm. The grasp of his work is different. And the only time this witness really shaded anything were those horrible PowerPoint slides from Welcher. And I don't fault him for it because God damn, those PowerPoint slides were awful. They were so crammed full of information. This witness did a good job, I think, of parsing that information out and making it more clear. And I saw that from all of you in the chat today too. All of you said, you know what? I understand this better because of the way this witness explained it. I agree with you. There are things that I took from the other testimonies, but it took some work to get there. This witness didn't require work to understand what he was saying. It was just laid out. And even on cross, he's laid things out very cleanly. It's not confusing. It's not evasive. Yes, no, this, that. It's the kind of expert testimony I like to see. And he didn't go the extra mile of disparaging any of the work done by the other witnesses, which is notable because you can already see Brennan laying the groundwork for our experts touched everything. Their experts didn't have hands on to anything, which for some jurors can matter. I don't know if it will matter as much for this witness, but it may matter for the later witnesses. And that's what Brennan is going to lean into as the differentiator. But our experts touched it. Our experts had the car. Our experts got an exemplar. Look at the work our experts did. Okay, your expert also had 7 different CVs. We haven't forgotten. He found an SD card. Fair. But also, I have not forgotten all of the evasiveness with the education because I did not like it at all. And both things can be true. The SD card closes the door to the conversation about what day that 11/62/2 trigger event or key cycle happened on. It's timestamped to the car. Did that come across clearly for you in the Commonwealth's case in chief? Did you clearly take away from Burgess's testimony that the information on the SD card was the date and time of the key cycle 11/62/2, tying it to after midnight on January 29th, 2022? Or did it completely get lost in everything else that witness testified to? You let me know. We're going to answer some questions. I see a lot of you already answering it. Let's get to some questions. All of you have just answered.
Survey says.
Right. I think this witness made it more clear that that's true. And this witness did clear up that point for the Commonwealth. Truly did clear up that point for the Commonwealth. Move my desk up a little bit. I moved my desk, something fell. It's fine. Everything's fine. I can't even blame it on Fred. All right, let's get to some questions and then we will get to lunch. We're going to do about 10 minutes of questions and then we'll go to lunch. And then we get a little bit of lunch today, which I definitely need because, wow, it's been a busy trial. And I went to the grocery store yesterday. So I have some all-dressed chips. They're the Lay's ones, not the Ruffles ones. So many of you in the chat said there were Pringles ones that exist. I couldn't find them. I looked, but they're the Lay's ones. I really am waiting for the Ruffles ones to come to the US. All-dressed chips are my favorite. It's nice to not have to import them from Canada because the Lay's ones are at my store. But I want the Ruffle ones. I want the Ruffle ones. I want the Ruffle ones. Emily, you're very stuck. They're my favorite. And I'm glad they were at the store. Emily, were you at the store at 9 o'clock last night, just like when you were working as a trial attorney? Yes, I was. I'd run out of food for breakfast. It was needed. And I wanted to be here close in time this morning. Rhapsody in Blue 111, thank you. Rhapsody in Blue factored heavily into my son's high school halftime show last year for band. And every time I hear Rhapsody in Blue, but my mom worked for United Airlines, but every time I hear Rhapsody in Blue, I just think of the old United Airlines commercials because that song was used by United Airlines for multiple decades. So every time I hear it, I'm like, oh, we're getting on a flight. What is happening? It is so inextricably linked. And as I was telling my son and some of his friends, they were like, what? And I was like, right. Fair. This doesn't bring that together. So, all right. Let's continue on. I saw a question. I think this is a question in the chat. I'm reading it as a question in the chat about why we don't see the slides. The cameras are operated by the pool camera. In this case, the pool camera is Court TV. I do not know why the pool camera shows certain things or doesn't show certain things. We are using the direct pool mixed feed. And when the pool camera shows the slides, then we get them. When it doesn't, then we don't. So we are using that direct mixed feed. It will be different when we get to the Idaho case. We will be doing a members only live. I am still looking at times, but it is going to be soon. Probably Saturday, later in the day. So I'll keep you posted. But we will talk a little bit about the media in the Kohberger case. In the Kohberger case, we are going to have just one feed of all the different angles. And that's going to be very helpful. Miguelina, can we just pin a courts at lunch note so as people come in, they are not confused? Court is not done for the day. Court's at lunch, which is fair. So let's see. The pool camera main thing is that it's a trial, not a TV show, I think. I agree. I would love to see the slides more. It's something I complain about frequently. I wish I could upload photos on YouTube. I have both bags in my pantry. Sammy, that's what we have the app for, because we can do that in our member space in the app, which is helpful. So let's get to some more questions, and a huge thank you to everyone who's gifted memberships and for the super chats. I've seen so many of them come in. Thank you, Monbet. I hope I pronounced that correctly. Thank you for the super chats. I appreciate the support, and I know the channel does as well. So thank you. We are well during trials. The team works a lot of overtime, so we appreciate it because it is definitely a busy time of year as we are making sure we get all the case briefs out as well. Have you tried the Utz lemonade potato chip? Mike, is there a typo in that sentence? Is there? What? Utz lemonade potato chips. I will look for them, but I have not heard of them. Are they good? Those words don't go together in my brain, but I'm willing to give it a try. Destined to Be said, I finally tried all dressed chips the other day. I hope that you liked them. Look, if you're not a vinegar chip fan, the all dress might be a little too vinegary, but I like the tangy. Chief Fullable said, I have the Utz lemonade chips. They are tangy. I like tangy. Tangy doesn't make me mad. So more like lemon. I don't mind tangy. All right. Sounds good. Sam said, it's my birthday tomorrow, EDB. Happy birthday tomorrow. You get a court day off for your birthday. Mara said, say Ferris, I'm late to the stream today, but might hit the only one who got our 9 times reference. Oh no, so many in the chat. So many in the chat got the 9 times. And it's fine if you're behind. Yes, lots in the chat got the 9 times reference because chat is, and please don't be offended to our younger members in the chat, but chat's all spiritually around the same age. So there are lots of references that chat gets, no matter what your earthly age is. Everybody's like vibes. 90s vibes. Deborah said, Brennan will look lovely in a bow tie. Now I can't unsee it. I don't know about that. Have we seen Brennan in a bow tie? I don't think we did. There were a few attorneys I worked with that always wore bow ties. It definitely made them stand out. Bow ties and suspenders were not the norm. Look, differentiation is important. I don't think the jury's going to have a hard time differentiating these attorneys at all. Thank you, Monbet. I don't think there's going to be any confusion. It's such a long trial. Their voices are so different. Their cadences are so different. The vibes are very different between these attorneys. There is no confusion at all. So, but I do like the bow ties. I don't hate a bow tie. Dr. B doesn't love a bow tie. Audrey asked earlier in the stream, and I wanted to get back to this question. Random question. This is not a random question. It is completely on task. The amount of money paid to the defense expert witnesses, who pays for that? The defendant. In this case, the defendant. So when defense experts are paid in a case where private counsel is retained, the defendant pays for the experts. It can operate a little bit differently in civil, but the ultimate answer is generally the party calling the expert in civil. And then if someone is represented by a public defender, that also comes out of taxpayer funds. So in the Idaho case, the experts hired in the Koberger case, those are approved and paid for by the government versus the defendant paying for them themselves. So Victoria Marie said, why not get the Lexus engineers or talk with the Lexus engineers? The trigger events are proprietary. So much like, why don't you just bring somebody from Apple in here to explain how Apple does it? Apple's going to say, yeah, no, that's proprietary. And we're not telling you how those internal components work. Same thing with Lexus's systems. We're not telling you exactly how the trigger events works. No. The big Kapowski says, my mom's CRV will constantly reset itself to 2001. So I totally get how that's possible. This is a very fair point. It's like the car has reset itself back decades. And he is dealing with fares. He is dealing with cars. Emily, you do need lunch. We do. Random question, misbehaving. As the best music fan ever, have you heard of REN or Ren? I know you love all kinds of great music. Please check them out. Love your coverage. I will. I probably have. I will generally need to listen to a few songs if it is not at the top of my brain at the moment, because it takes time. Sarah asked the same thing. Lexus would say it's all proprietary. Pound sand. I'm not telling you. Let's see. Debbie says, am I reading the witness correctly or am I biased? It seems the defense witnesses are much more professional in every way. We haven't gotten through all the defense witnesses yet. This witness does present better than the other accident reconstructionist. Though when it came to the Commonwealth, I very much like Dr. Wolf. I thought he testified really well. I like the coroner in this case, Scorty Bello. I think the scientific witnesses presented really well. So it really just depends. It really just depends on which witness. But of the accident reconstruction witnesses, this one's been the easiest for me to follow. 100%. Mari HK said, but look how calm and non-argumentative. Exactly. I find that I also prefer a quiet confidence in the experts, though I definitely give Dr. Wolf a pass. It was a louder confidence, but it was still not the snarky, combative, I'm going to just shove it in your face, everything that makes me crazy. But that is also my preference with experts. When I find that people are confident in what they are talking about, there is no need to snark because they're just like, you're cute, you're mad. Huh. There's no need to fight back. There's no need to battle for control. You just answer. And I found Wolf to testify that way too. Was there a bit of well, brain surgeon swagger? Yes. Would I expect that? Yes. Would I actually be surprised if there wasn't that? Yeah, I would. But I prefer that confident witnesses, or one of the ways I judge confident witnesses is how readily apparent it is when they don't fight on things they don't know. They're like, no, I didn't evaluate that. No, I don't know that. Because oftentimes there's nothing wrong with it. There's nothing wrong with not knowing the answer. There's nothing wrong with not evaluating that. They have a reason that they did it. They're confident in their reason. They don't need to fight with you. No, I didn't do that. They'll get a chance to explain that they didn't need to, if needed. But there's no need to fight it because they're not defensive. It's the defensiveness that I find the most off-putting. Honey 2800 said he does not deserve the title disorder. He's way too easy to understand. He is Dr. Giorno because he has a tasty slight. Oh, he's DiGiorno. I would only argue briefly, honey, and see if you might accept that he did cause disorder in the chat. So I think there is a little bit. I also think there is you can joke about DiGiorno because, oh no, he delivers even when he doesn't need to. Would that be his housewife line? It's not delivery, it's DiGiorno because I deliver either way, something like that. But he did cause chat disorder. There was much disorder in the chat in the kindest possible way, which I appreciate. All of you with the super chats about the nicknames, I appreciate it. Sarah said EDB in trial with you while chaperoning a band trip with my son's, with my soon-to-be high school freshman. Sarah, enjoy. Love a band bus. Have fun. And if any DCI shows are near you this summer, take your soon-to-be high school freshman to go see DCI. It's one of the things I love that our band director does and our boosters do, is that every year they make sure that the high school band all goes to see DCI. It's inspiring. They get to see other band enthusiasts, and they get to see a stand full of people literally just cheering for the bands. It is such an incredible experience, especially if you enjoy marching band, if you have a kid who's interested in marching band, if they want to see what that looks like. You don't have all the bother of the football game in the way. You just get to the good part. Emily, how do you feel about football? I'm here for the halftime show and snacks. So it's fun to get past all that and just see all the band shows and see everybody cheer. It's so much fun. Everybody just cheers for the bands. The other bands cheer for the bands. It's such a supportive community. I just love it the most. Pickled Sweet said at the end of trial, do we get a certificate of completion from EDB School of Law? We're working on a tour shirt, like a band shirt. Like I was on the 2025 trial tour. We're working on tour shirts. Emily, is it all related back to music? Yeah. It is. Margaret said mock trial with EDB would be a blast. It would not be very educational. I've lost all my seriousness. It would basically be a production of Chicago. We'll just lean into the razzle dazzle because I have lost my ability to be serious. It would be fun. If I could ever convince Judge Abby ever in the world to preside over a mock trial, it would be the most fun. It would be the most fun. It would also be unhinged because we have no seriousness together. Emily, couldn't Data Daddy download from Karen's vehicle? No, because they had already taken the chips off and they had already done those downloads. They could not put the chips back on to do the downloads. So I don't think they could re-download the chips, but they have them. Amber said, 1, will you be at VidCon? No. 2, is the only way she's guilty is proving it's intentional? No. So this case has 3 counts. Count 1 and count 2 involve some level of mens rea. There has to be an intent. Count 1 and count 2, the intent is slightly different, but there has to be intentional action and knowing action. Count 2 and its subparts do not require intentional action. It requires, and we broke it down, it requires some level of recklessness, and we can go through those different levels of recklessness again, because there are also subcounts. Count 2 is the involuntary. So knowing is not what is required. So hopefully that helps. But no, I won't be at VidCon this year. Travel this summer with DCI is going to be very busy. VidCon's changing stuff up this year. So to be as frank as possible, I'm going to let everyone else see what the vibes are like and then go from there. So I will not. I'm going to be out in California right before VidCon. The other thing is that VidCon overlaps with some Dave shows that I really wanted to go to. So this year I opted for Dave. Emily, the choice was between VidCon and the Dave Matthews Band. Yes. And when I got asked, are you going to talk at VidCon? Are you going to come to VidCon? Are you going to speak at VidCon? I'm like, Dave. I'm going to go see Dave. I'm going to go see 2 nights of Dave with my friends. I am going to go see Dave at one of my favorite venues to go see Dave. I am going to go see Dave. Everyone that's at VidCon this year, I'm sorry I will not see you. I adore you. But also, with the Kohberger case starting, this was one of the only times I could go see Dave this summer, because this summer, last summer, and the summer before, like we have Depp v. Heard summer, Murdaugh into the summer, Reed 1 into the summer, Reed 2 into the summer. All of these trials have overlapped summer. And then by the time the Kohberger case starts, it's like summer and fall. So we took the time where we could because it was needed. I know exactly. Disorder. We're all just singing. Law nerds. Court is still on lunch. Terry said, how many Dave concerts are we at now? I think we're closing in on 65 this summer. But I would have to double check because I don't remember off the top of my brain. Kohberger is going to go for an eternity. Kohberger is going to be a very, 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 very long trial. Like a very long trial. We were just watching Penguins of Madagascar with Griff, with Dave, and they were grabbing cheesy doodles. My grocery store has cheesy doodles. I didn't know that cheesy doodles were a real thing. Like, I had no idea that cheesy doodles were real. And I didn't buy them, and now I'm mad. I should have. But cheesy doodles are real. I had no idea. But yes, the Kohberger case is going to be extensive. Sylvia's daughter said, what do you and Dr. B do for date night? Well, if we're not going to a concert, which happens on occasion, there are times that date day looks like a trip to Costco. Because it really just depends on the time. Jay said, what's the longest trial you've ever seen? Oh, I don't know. The YSL case is one of the longest trials I've ever seen. It took them almost a year to pick a jury. That's one of the longest trials I've ever even heard of. But no, the Simpson case, the O.J. Simpson prosecution was incredibly long. This is not going to be as long as that. Kohberger won't be as long as that. Kohberger is going to be August through November. Sorry, that's loud. That's outside here. So it really just depends. All right. I'm seeing Dave in Charlotte. I'm teasing. I booked flights to the right place because my friends held my hand through it. Body doubling works. Lawners, I'm going to get some food. Court should be back soon-ish. We got through a lot of questions. Not all of them. We got through a lot of questions. I'm going to put up we'll put up our quick lunchtime and our music, and we will zoom back to court. We will send out a notification when court is back. I will be back probably just a titch after court is back, but I will see you soon. So enjoy court on lunch. Let me put up our video and then put up some music, and I will see you guys shortly. Hey Lawnard, court is still on break, but don't forget to download the Lawnard app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during Verdict Watch. The Lawnard app has all of your live court notifications to keep you in the loop. LawnardApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. stay in the loop with this trial? I know sometimes it's hard if you miss a day. That's why I've got daily case briefs dropping over on the Emily Show YouTube channel and the Emily Show audio feed on your favorite podcast app, so you can stay in the loop even when things get busy. forget to download the Lawnerd app so you know exactly when we're back from break. The Lawnerd app has all of your live court notifications to keep you in the loop. Take care of yourself. Trial days are long days. Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch. Take care of yourself. Trial days are long days. Trying to stay in the loop with this trial? I know sometimes it's hard if you miss a day. That's why I've got daily case briefs dropping over on the Emily Show YouTube channel and the Emily Show audio feed on your favorite podcast app, so you can stay in the loop even when things get busy. Still on break, but don't forget to download the Lawnerd app so you know exactly when we're back from break. The Lawnerd app has all of your live court notifications to keep you in the loop. Take care of yourself. Trial days are long days. Court is still on break, but don't forget to download the Lawnerd app so you know exactly when we're back from break. and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Lawnerd app has all of your live court notifications to keep you in the loop. LawnerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch. Take care of yourself. Trial days are long days. Trying to stay in the loop with this trial? I know sometimes it's hard if you miss a day. That's why I've got daily case briefs dropping over on the Emily Show YouTube channel and the Emily Show audio feed on your favorite podcast app, so you can stay in the loop even when things get busy. Hello. Let's turn that music off, shall we? And then we will get back to court. Did you guys have a good lunch? I hope that you did. It's time to get back to court. We are in the cross-examination of the defense first witness, their tech/engineer accident reconstructionist. And we're going to go back to court for that. So, are you ready? We are back. It's time to go. Let's get back to court, shall we? Emily, you should be able to bring court back. It always takes a minute. Let's go back to court, shall we?
Brennan.
They are back from lunch just a few moments ago. We don't have a lot of Zoom room, we just don't have a lot of Zoom room this afternoon. Hopefully the Lawnerd app, I see some of you coming in saying, thank you, Lawnerd app. So you got an app notified that we're back after lunch. It was a good break. I got to go see what Griff was doing.
DiSogra's amended PowerPoint presentation.
Brennan, you're already not doing it for me with the condescension on the amended PowerPoint. Stop it. Just stop it. He's just leaning right into amended. Okay.
Sir, I want to ask you about your opinions, and inevitably, some of the slides that you've presented to this jury regarding adjusting the clock in a time period of 3 seconds. You have given an opinion that there's a difference that you see in the reports between when the defendant's Lexus is powered on and the infotainment system begins, correct?
Yes.
There's a 3 second...
Oh, I'm not mad. I saw a number of you in the chat immediately be like, why is Brennan screaming? Because the AC is on. It's really loud in court. So even though we have a microphone, everybody else doesn't. We are getting into the time of year where it's going to get hard to hear in court because the AC is loud. So that is due to the courtroom and how difficult it is to hear in the courtroom. So the microphone is picking it up louder than it is in court because that microphone doesn't project in court. And we've already had issues with this witness and him not hearing each other, but he's just closer to the mic. He was probably at the same volume when he walked away from the mic. He's just closer to the mic.
Difference on the exemplar vehicle between when the power is turned on and then the screen lights up, the ignition, the infotainment system.
The 3 seconds I'm referring to is the timestamp
From
in the
ignition
data
on
from the SD card.
to the text stream.
So I'm referring to the timestamp in the SD card. It seems that that's coupled to the screen, but I just want to make it clear I'm referencing the data from the SD card.
That's not what I thought at all.
Data from the SD card
Okay.
correlates directly to the infotainment system itself.
The date does, yes.
Because the SD card is with the other chips part of the board that makes up the infotainment system.
Yes.
That infotainment system powers the screen that goes on after a user presses the button to start
That makes
the
sense.
vehicle.
All right.
Yes.
So the time that the infotainment system is registering is when the infotainment system goes on, not the power on event.
Correct.
So that 3
Why
seconds,
is that the first time that was clear? We shouldn't be why is that the first time that's clear?
that was tested with the exemplar vehicle, between pressing the button to turn the car on and the time the infotainment system turns on. The infotainment system clock does not accommodate that 3 seconds.
Correct.
So when we're talking about time on infotainment system, we're talking about after the 3 seconds when the screen comes on.
Yes.
Okay. Now, you've made some slides and you've made some assumptions suggesting that that 3 seconds should be added to your analysis. And I want to ask you about your analysis regarding the 3 seconds. If we could turn to page 7, please. If you could zoom in on the left side.
I mean, I think the impact and the effect is the same.
Sir, you told
I
us
just
that you
wasn't
didn't
sure
do
where
any
that info was
testing
coming from.
or data vetting yourself. You simply relied on reading and reviewing Mr. Burgess's report and Mr. Welcher's report.
That's what he said.
Correct.
And really, the information you're reviewing is Mr. Burgess's report. There's only a few references in Mr. Welcher's report where he cites Mr. Burgess's findings, correct?
Most of it is from Mr. Burgess's reports.
There's really nothing in any of Dr. Welcher's reports that you are considering that is not in Mr. Burgess's report.
The .154 alignment methodology, I think exclusively is in Dr. Welcher's and is not present in Mr. Burgess's.
Did you read both of Mr. Burgess's reports?
Yes.
You're not aware that Mr. Burgess talks about that timestamp in his reports?
He mentions it in the
gets it from
second
Welcher.
report to say that he doesn't think, basically he doesn't think Dr. Welcher should have aligned it on that.
That is exactly not what he said. Where in the report,
Sustained.
where in his report does he say that Dr. Welcher should not have relied on 154? Where does it say that in his report? I have it here. If you can give me the page, we will take a look at it.
I don't know the page, and I'm paraphrasing. By no means am I conveying that as I'm directly quoting it, but I remember that as something I read in there.
Well, I was careful in your affidavit not to paraphrase you, right?
Ew!
Sustained.
So
Stop with the
when you just made
comments.
that assumption or that suggestion,
Brennan, I hate it when AJ does it. I hate it when you do it. I allowed it with Alessi the once because Alessi was so pissed and it was allowable. But stop it with the comments. And notice, every single time that there's an objection, they're getting sustained. Every single time.
characterizing Dr. Welcher's state of mind or thought process, is there anywhere in the report you can cite or show me where Dr. Welcher said that?
No.
Okay. When you read Mr. Burgess's report and you learned that he and others obtained an exemplar vehicle and did this testing, you have no other independent information to suggest that the power on, power off event and 3-second delay is inaccurate, do you?
I just want to make sure I heard you. Did you say accurate or inaccurate?
Inaccurate. I'm sorry, the fan's on. I'm trying to.
I'm sorry the fan's on. Wait, that was a rude pause.
I
Hold
know.
on.
That's the only reason I couldn't hear that.
Here's part of the problem with Brennan's snark vis-a-vis others. You kind of have to earn it. And there are times when an attorney claps back at a witness and it doesn't feel rude at all because of how the witness is acting. That's what's out of sync here. This witness is not fighting with him at all. This witness has been incredibly respectful. This witness is not fighting with him. He's not been defensive. He's been really affable. And Brennan is just like, "Rah." He hasn't even snarked at Brennan's witnesses. So it's very out of alignment to come in so hot with a witness that isn't doing the same. Like by the time Alessi popped off at Welcher and was like, "Can you answer my questions?" Everybody was like, "Thank God, please." And that is the problem. The alignment is off of the snark.
So can you state it one more time?
I'll rephrase it. When you reviewed Mr. Burgess's report and reviewed the information about his exemplar testing regarding the 3-second difference between turning on the car and the infotainment system going on, you have no other information that you looked at or studied that changes that analysis, do you?
No.
He said he was
Now-
being cautious because it wasn't
When you are
tied to any other
suggesting-
Lexus,
could we
so there
shrink
could be
that and zoom
variance.
on the right side, please? When you are suggesting
Jessica, you're
that
right.
3 seconds should be added to the time because of that 3-second gap, do you think maybe you made a mistake in considering it that way?
No.
The time that
he
you're
doesn't.
adding 3 seconds to is the infotainment time, the infotainment clock, correct?
Yes.
The infotainment clock
The count
begins
up?
when the infotainment system goes on. We just spoke about that, correct?
Right?
Which is 3 seconds after the power on event.
Oh, that's a good point.
Correct.
So you're essentially double dipping. You're adding 3 seconds that has already been separated because it isn't reflected on the infotainment system. Isn't that true?
That's incorrect.
You believe that 3 seconds
That's an
between the
interesting
power on
point.
and the infotainment system going on should be accommodated extra on top of it.
It's not that it's extra, it's because when we're talking about times here, we're pulling a time from the infotainment and we're marrying that with a key on timer from the vehicle control history. Those are separate systems.
That's a
So
good explanation.
if the vehicle control history had its own time, then what you're saying would be correct. We wouldn't account for any delays because then it's already baked into those numbers. But this is a very unique analysis. This
That's
is
a
not
very
something I've
good
ever
point
even seen.
for the
This
witness.
type of analysis here where we're comparing a timestamp from an infotainment SD card to a VCH total time. And so the only way to reconcile those two is we have to align them. And the 3 seconds is the alignment between those because the VCH key on timer is going to start as soon as the vehicle is turned on. And that's the 3 seconds.
You've never seen this before.
I've never seen the approach taken here in this analysis by Aperture. That's what I meant by this. I'll clarify. I have not seen a timestamp from a key on event in a Lexus infotainment used in addition to the key on timer from that same Lexus.
You know Mr. Burgess actually looked at the data, not just the timestamp. He looked at the data. You understand that, don't you?
He looked at the data
Sure.
too, didn't he?
You did not, did you?
Which data?
The data for the timestamp on the text stream data.
There is no timestamp on the text stream data, is my point.
Right.
It's a derived value from the key on time, and then added to that is the elapsed time from the text stream.
That is
So
a
they're
very
separate.
clear
Did you look
answer.
at the data to make that determination that you're claiming right now? Did you actually look at the data?
Yes. Yeah.
You looked at the raw data?
I looked at, yes, the raw text stream data.
The raw text stream data from the infotainment, did you look at it?
I just don't want to mince it. The text stream data is an independent system from the infotainment, and you said from, so
Pardon me.
they're not.
Did you look at the infotainment raw data?
I did.
And did you find a timestamp on the infotainment raw data?
Yes.
Now, when you added 3 seconds, you were trying to, in
He
addition to
answered that,
the
I think, very clearly.
infotainment data, you were adding on the 3-second delay that now you're saying might not even be accurate. Is
That's
that fair
not what
to
he
say?
said.
I don't think I've ever said it's not accurate. I said that
It can't have variance
in the
between
exemplar
cars.
testing, they documented this behavior of a 3-second delay. And that needs to be accounted for if you're going to correct the timestamps. However, the caveat I put on that was only with one exemplar vehicle. So it could be that this behavior, the 3 seconds, is unique to the exemplar and would not apply to other similar vehicles.
And you don't
so
know without
that's why
testing
I did
more than one.
Either nothing or the 3, because there's nothing to support something in between.
So you disagree that the clock stamp on the infotainment module begins the run. You believe that there's potentially 3 seconds before when the ignition goes on that should be added to that time.
I know from testing other Toyota systems that the key on timer happens
At key
almost
on.
at the identical time that the vehicle is turned on. That timer starts running basically immediately.
But on this case, you don't know anything firsthand because you didn't do the testing yourself.
Oh, that's not
I
what
don't
he
know
said.
if it would specifically apply to this Lexus. I know that from other Toyota testing, but
And
not
your
this specific Lexus.
I'm sorry. I'm sorry. Finish.
No, just I'm clarifying. I do know that from other Toyota and VCH systems that key on timer is basically simultaneous with the key on. I have not tested it on this, and I don't believe that it was tested by Aperture when they had it either. They didn't document the accuracy of the run timer in their exemplar.
Because
so we
they
don't
said
know.
it was the
Well,
same.
you don't know that they didn't document that.
To be fair, if they did, it was
would
not
be
in their
reports.
reports.
Right. So in this case, you said cars are different, and that's why you're hesitant to accept the fact that there's a 3-second delay. It's a yes or no question.
I'm saying we don't know. If had Aperture done testing with a separate vehicle, then we could establish, is the 3 seconds the same or is it unique? We don't know. The answer is we don't know.
And so when you're determining that 3-second variance, you don't have any assurance in your own mind whether or not this car, Miss Reed's Lexus, has a 3-second variance. That's what you're trying to say.
Correct.
That's correct, and that's why I run my calculations with and without it.
And the way you would determine that is to actually do testing or look at the data.
More testing, I think, is the only way that would be able to be determined.
Now, let's
But your troopers destroyed the Lexus systems, so the Lexus couldn't go back on, and they didn't even know it was something they needed to look at, so they pulled all the shit out of the Lexus for Karen Reed's car before anyone did that testing, because they didn't even know to do that testing. And so Karen Reed's car can't be powered back on because of all the shit they ripped out of it the last time, and they didn't even think to do the testing because they didn't know. And that's why nobody can just go in and turn on Karen Reed's car, because y'all pulled it apart before the testing was done. So they're trying to put the shit back in the horse, and you can't put the shit back in the horse. Or the chips back on the infotainment system and the infotainment system back into the Lexus so you can turn the Lexus back on and test that one. Gee. Why can't you just decide for Karen Reed's car? Well, because you took it all apart first. What's interesting is that this witness has made it more clear where the time and date is coming from, what the time and date is connected to, and then what needs to be adjusted for the count up. It's become more clear on cross. And that's not because direct was unclear, it's because it was unclear with the other witnesses. This wasn't asked as much in direct.
turn to slide 9. As
Oh,
part
Michelle,
of your
no.
charts,
They don't compensate her for the damage they
large
did to her
left,
car.
please. As part of your
It's
charts, you took this
They may
chalk
give it back when she's
from
done.
Attorney Burgess's report,
But when law enforcement gives it back to you when it's done, you get it back in the state that it's in.
and you made some assumptions about this, didn't you?
I'm not sure.
Okay.
I applied
Let me-
the numbers in his third column to the times. So, I mean, that's the extent of the analysis.
When you looked at the first 5 columns, 1:14, 13 a.m., 4:38, 16 a.m., 4:42:06 a.m., 4:45, 12 a.m., and 5:04, 28 a.m.
Well, that's a new alarm sound.
You said on direct examination, oh boy.
I agree with Brennan.
You said on direct examination that was matching infotainment to iPhone.
He said
That's what it says on the
he
chart.
said that's
so
what
that's
that said.
Probably what I said. I don't
Well,
remember specifically, but that's what the
Is
chart
that-
says.
Is that your opinion that those first 5 columns are matching infotainment to iPhone?
That's what the chart says.
The chart says infotainment call timestamp in column 1. It says O'Keefe iPhone call timestamps in column 2, and then it says offset. So I'm taking that at face value.
And he said
You're
that.
basing your later charts on the predicate that these numbers, the first 5 columns, are infotainment compared to...
He just said, Brennan, he is taking your experts at face value. So the line of questioning you're going to go down, that I think the direction you're going to start walking in, is just going to serve back the examples from your experts aren't fucking clear. Sir, this column says infotainment system, and you believe that's from the infotainment system? Yes. But sir, you didn't know that was the infotainment system downloading the call logs from Karen Reed's phone after the car was turned on, because you didn't know that the car wasn't turned on then, did you? No. Well, why not? Well, because it's not on the chart from your witness. Interesting strategy. I'm relying on your expert. Yeah, but there's a whole bunch of information my expert left out. Is that the questioning? I think so. I think so. I think that's where we're going.
Based on the chart, yes.
You didn't do any study on your own to determine the genesis of that information, did you?
Well,
I'm
your
aware
expert said where it came
of
from.
the fact that these calls, the 5 you mentioned, were placed when the vehicle was in a keyed off state.
Bing,
I'm aware
bing.
of that.
That's what he's
What I
asking about.
asked you specifically is, on those 5 columns, did you do any research or study to determine whether or not it was infotainment matches to John O'Keefe's iPhone or some other phone matches to John O'Keefe's iPhone? Did you do any independent study about that?
No.
Because in your ultimate conclusions and all the charts you've given to the jury and shown the jury, it relies on the conclusion that the first 5 columns are a comparison between infotainment clock and John O'Keefe's iPhone. Isn't that fair to say?
That's exactly how the chart presents it, and that's how I present it.
Did you know that at 1:14:13 a.m. the defendant's Lexus was turned off?
Yes.
Did you know at 4:38:16 a.m. that the defendant's Lexus was turned off?
Yes.
And did you know for 4:42:06, 4:45:12, 5:04:28, did you know that her Lexus was turned off?
Yes.
Do you know that when you make phone calls, oh, by the way, do you know on those different times, the first 5 times, where that information is generated from?
Which column?
Left column, 1:14:13, all the way down to 5:04:28. Those 1, 2, 3, 4, 5 calls. Do you know where that information came from?
That would be 5
It came
rows
from the SD card from the
from that
infotainment.
first
Do you know
column.
where the genesis, the
That's
beginning,
5
the
rows
source
from
of that information,
first column.
that matters, right? The source?
It would.
It would. Do you know where it came from?
The assumption, the assumption is if the vehicle has a timestamp and the phone wasn't connected, it would have been synchronized after the fact. But that wasn't tested.
That's what his expert said.
Aperture didn't do any of that testing in their work to look at the behavior of a timestamp in the infotainment when a phone is synchronized after the fact.
Blaming
Oh,
actors
boy.
doesn't get you out of answering the question. Did you know?
Sustained.
Brennan walked away from the mic after getting served by this expert and then said something that wrangled an objection so fucking fast I could barely hear it. And then may we approach with the fastest sustained. Very little has been sustained so fast as that. So I'm backing it up because I couldn't even hear what happened because Brennan is so far away from the mic. So for everyone with headphones, I'm going to try to gain this up to hear what Brennan said, which might make this witness very loud for a minute. But I want to hear what happened.
In their work to look at the
I
behavior of a
backed up.
timestamp in the infotainment when a phone is synchronized after the fact.
Blaming actors is not going to get you out of answering the question. Did you know?
Sustained.
I still couldn't hear him. He said is not an answer to the question.
Payment when a phone is
I
synchronized
can do it one more
after the
time.
fact.
Blaming actors is not going to get you out of answering the question. Did you know?
Sustained. Sure.
A lot of you guys are saying blaming Aperture is not going to help you answer the question. Thank you, chat. A lot of you had said blaming Aperture is not going to help you answer the question. Brennan is just, well, they should approach. He's not blaming Aperture. He said, I am relying on your expert's chart. And this is what they said, and these are their assumptions. But they did not test it further. It's not in the report. I'm relying on their reports. So they're going to go ahead and approach on that. I'm going to try to gain that back down to normal. Blaming Aperture is not going to... Is this witness giving blaming to you? Or is he saying, I have this information, I don't have this information, and this is why I don't have this information? Are we blaming or explaining? What's happening? I zoomed past that sidebar. I'm sure Jackson is very annoyed with Brennan. I'm sure Brennan, who has settled right back into defense attorney demeanor, is thrilled. The thing is, when you are the prosecutor, you don't get to vibe defense attorney demeanor because it puts people off quite a lot. You don't get to try a case as a prosecutor like a defense attorney because you have the burden of proof. And apparently the unlimited resources of Norfolk. So,
Do you know the genesis, the source of those 4 numbers?
Definitively no.
Your entire premise for your slides and values and ranges depends on knowing the genesis of those numbers, doesn't it?
I relied on Mr. Burgess's explanation that those times were synchronized after the fact.
Did you know?
and that's what Burgess said in his testimony. It is so confusing to attack this witness over his reliance on Burgess's report. It's just wild. Because that's what Burgess said. These were downloaded after the fact. And Burgess said, so they're going to show the timestamps closer in time. Because phone to phone, because they're downloaded.
That those are all phone calls from the defendant's phone to Mr. O'Keefe's phone?
Yes.
You did know that.
I know that they're phone calls
From who?
between. Sorry, can you maybe just state it more clearly? Because I'm not sure. I don't want to fumble through an answer if I don't understand the question. So
It's fair.
Do you know where those calls came from? The source.
a phone,
Whose?
Miss Reed's phone.
Now, I know you're not an expert on mobile devices, but did you know when it's not a contemporaneous synchronization, you plug your phone in, it's going to register on the infotainment system, but come from the phone? Objection.
Sustained.
Do you know when someone plugs their phone in after they turn the car back on, how it synchronizes on the infotainment system?
I don't know if adjustments are made to those times during a synchronization or not. I think that's something that could be tested, and to my knowledge, was not tested.
If you don't know, then your conclusions and all your opinions to this jury is based on an assumption that you don't even know the predicate for. Isn't that fair to say?
My conclusions are based on all of
Based
the
on
data that
data.
Mr. Burgess laid out. So he laid these out and went so far as to calculate the offsets himself.
So I
So
relied on
there's-
his offset.
There's something implied in his table by virtue of him calculating these that maybe he would decide to align them. And so, again, to provide the clarity on all the possible alignments, I included them.
But that's not what I asked. If you're making an improper assumption about the predicate, about these calls and the source of them, and you're wrong, that would change your entire analysis and conclusions and charts that we see in your later charts.
No, it would
wouldn't
remove a few.
Sure, if there was testing that showed that that is an invalid method on this specific Lexus and SD card, then of the 30 possibilities, some of them would end up being eliminated.
Some of them would be eliminated. Brennan's point is that the reason Burgess did not calculate those is because he determined that those were not reliable numbers. So Burgess did not run those through, which is what this witness did. This witness said this was here, but he didn't finish going through the math on it. And when Burgess testified, Burgess said, right, I didn't finish going through these because I determined that these offsets were not valid. but he didn't put that in his PowerPoints. Burgess said, I did not find those points to be valid. So I did not finish trying to use those points to do the correlation. And he's saying, well, Burgess didn't finish the correlation with all these points, so I am going to use these points. And Jackson is saying, well, not Jackson, Brennan is saying, well, then doesn't that make everything wrong? And the witness said it would reduce a few of them. Okay, fine. It would reduce a few of them. Sure. It would reduce how many? 1, 2, 3, 4, 5. So it takes 5 of them out. Okay.
Did you know that when an iPhone is plugged into a car, it downloads the information from the iPhone onto the payment system? Did you know that?
I don't know how the clocks are synchronized when you plug an iPhone into a car.
Well, if you don't know, how can you make conclusions based on a part of it you don't even know what it is?
The conclusions are based on the data in Mr. Burgess's report.
Right. And Burgess did not.
So I'm going to strike that. Go ahead.
Burgess didn't say in his report why he counted those out. And again, Brennan is going back to, well, I know you're not an expert in mobile phones. And that comment was stricken again.
Ask your question.
I apologize.
You don't apologize. You did it on purpose.
2 different devices, a Lexus clock, the entertainment system, and an iPhone. You would agree that it's not unexpected to be variances, correct?
Correct.
When you're comparing 2 iPhones, do you have an opinion? Do you agree that you'd expect the variance to be very small, iPhone to iPhone?
I don't know.
Have you ever studied that?
Damn, I wish this expert said, I don't know, sir. As you said, I'm not an expert in iPhones. Just cars. In my brain, that's going to be the way it went.
2 iPhones?
Yes.
No.
So as you sit there today, you don't have any expertise, any education, any knowledge about how closely 2 iPhones would sync with each other?
No.
Do you see in the first 5 columns the numbers are small, 2, 2, 1, 2?
This witness would not be that snarky. I would love it.
1.
Yes.
Would you agree iPhone to iPhone using the same source of time is generally going to be within 1 or 2 seconds of each other?
Objection.
Sustained.
Do you have any opinion
You,
about whether
Brennan, you just spent all of the time snarking at him going, you're not an iPhone expert. And now you're like, do you have an opinion on this? Do you have an opinion on that? He just said he doesn't have an opinion. He can't have an opinion. It's asked and answered, and it's outside of his scope of expertise. So of course the judge is sustaining all of these objections. Well, you're not an iPhone expert, but do you have an opinion about how these phones work?
iPhones to iPhones will generally be within 1 to 2 seconds of each other? Objection.
You can ask if there's an opinion. Do you have an opinion on that?
No.
No, I'm not an expert.
If the first 5 calls are iPhone to iPhone rather than infotainment to iPhone, you agree all of your assumptions and conclusions are inaccurate.
They're not iPhone to iPhone in the sense that column 1 came from the infotainment. The values were read from the SD card. So there's an assumption baked into it. What you're saying that when a phone is synchronized, the infotainment assumes the times of the phone, but we don't know whether the infotainment would adjust those times to its own clock or not.
You're speculating now, aren't you?
We don't know. It wasn't tested. I don't know is the answer.
Don't know.
I don't know.
You don't know.
I do not.
Okay. Don't say we don't know. You don't know.
Brennan said, don't say we don't know, you don't know. Now he's getting argumentative. So the objection is going to be sustained. But nobody tested it.
Sustained.
So this is iPhone to iPhone. Then your assumption on the first 5, 1, 2, 2, 1, 2, 1. If they're iPhone to iPhone, and you're wrong about the fact it's infotainment to iPhone, your assumptions and conclusions are inaccurate, aren't they?
Objection.
I'll allow this.
If the title of the first column
Asked and answered.
had iPhone in it as well, then I would not have used it in my analysis.
But that's not the question. I appreciate that. My question is, if those first 5 calls were iPhone time to iPhone time, and you mistakenly analyze them as infotainment time to iPhone time,
How can he mistakenly analyze them as infotainment time when the column is literally listed as infotainment time? He's like, I'm just basing it on what your expert said. This is a wild choice, Brennan.
then the rest of your assumptions and charts would be inaccurate.
That also doesn't follow.
Sustain.
And the court's just not letting him go there. Those objections keep getting
At
sustained.
5:21:36, do you know whether or not the defendant's Lexus was on?
I don't recall if that one was an on or an off point. I don't want to guess. I don't recall.
And so if you don't know if that was on
He's
or
like, I need
off,
to look at the report.
were you able to do an analysis whether this was phone to phone or infotainment to phone?
They all say infotainment.
No.
5:30:31, do you know if the defendant's car was on?
That one I know the vehicle was on.
That's one timestamp on the infotainment system, 5:30:31, correct?
Correct.
And then in the O'Keefe iPhone call timestamps, there are 2 different numbers, 5:30:15, 5:30:52. Yes?
Yes.
Right. And do you appreciate that that is 2 separate calls, or do you think it's something different?
I'm going to paraphrase, again, Mr. Burgess' report as I recall it, in that he stated during the testing they did with the exemplar, calls placed in close succession would not necessarily both be logged in the infotainment. So as I understand this chart, what he's trying to say here is there were 2 calls placed, there were 2 call logs in Mr. O'Keefe's phone, but only one timestamp in the infotainment, and he couldn't determine which it corresponded to because of that observed behavior from testing.
I'm asking if you know.
I don't.
What he's saying is that when there was a variance or when there was some confusion, it's actually listed in the report. I wish we could see the chart right now, but we can't. But it's that last one that has 2 different potential calls. And he was saying, look, in the report that corresponds to this slide, when there was a variance, it was listed in the report. But the ones above, shit wasn't said about those. So I'm relying on you explained the variances or the differences or the asterisks and everything else, but not that. And I'm just here to review what they said. So my reliance is on what they said. If I can't rely on what they said, then how can we rely on what they said?
Did you ever look at phone records for the defendant or for Mr. O'Keefe to make a determination whether these are 2 separate calls or not? Did you ever do that?
No.
Right, why would he?
If these are 2 separate calls, can you explain to us why there is one timestamp?
Again, as I stated, that was behavior that was observed. The exact behavior was observed during the exemplar testing by Aperture. I don't know why that happens. Why does the infotainment not log every call? I don't. But I know that it was documented that that is a feature of this system.
Right, he wasn't testing it.
This information was not taken from the exemplar vehicle, was it?
It was
This
taken from
table,
the
no.
report.
This information was taken from the infotainment system of the defendant's car, isn't that true?
Yes.
And the phone calls were taken from Mr. O'Keefe's iPhone, isn't that true?
Yes.
And so, you know why there would be 2 phone calls and only one timestamp?
Beyond the testing, the exemplar testing that showed an exemplar vehicle did that, no, I don't know why it happens.
Do you know that the infotainment system doesn't always capture all of the phone calls and the phone data in the download? Did you know that?
Yes.
Well, if you know that, can you conclude that even though there's 2 calls and only one timestamp, that's because how the infotainment system works?
I think that's the most logical assumption, that's
We're back
how
to
it
2
works.
calls, 1 timestamp.
If you look at 5:30:15,
Great.
bottom middle, and 5:30:52, it is impossible to tell which one relates to the 5:30:31 infotainment on the left. Compare. It's impossible, right?
Yes.
So there's two possibilities.
Yes.
One is that you have a difference, a disparity of 16 seconds.
Yes.
And the other one, going the opposite way, is a disparity of 21 seconds.
Correct.
And so when you add those disparities, you have 27 seconds disparity in those. Correct?
You don't add them, it's a range.
There are 27 second disparity.
You don't add the range. What are you talking about?
I'm not sure I understand the math.
You're kinder than me.
5:30:31.
What are you on about?
It's 16 seconds different than 5:30:15 on Mr. O'Keefe's phone. Yes?
Yes.
Because it's a range. The variance is a range. You don't add them together to get a bigger number.
5:30:31 is 21 seconds different than the 5:30 phone call. Yes?
Yes.
And the difference is cut each way, one's minus, one's plus.
Correct.
So when you add those disparities, you get 27 seconds, don't you?
Objection. I'm going to allow that.
No.
Okay. What do you get?
You're saying if, maybe, so I can be clear what you're asking, if we have a negative 16 and we have a positive 21,
Correct.
how many seconds are in between there?
Exactly.
37?
And so you can see, did you know that the defense car was turned on at 5:07 a.m.?
So solving, and again, not having the chart in front of me, I didn't remember at all that one was a negative. I thought they were both positive, positive 16 to positive 21. So he's saying if these are the two variances, what is the variance range? 37 seconds. Okay. And
I don't have any of those keyons committed to memory.
So you can see between 5:21 and 5:30, the offset is different between them, which shows that variances change. They move.
That seems reasonable. Yes.
When I said it seems reasonable, do you have the experience and the knowledge to agree with me that variances move?
Yes, they do.
Okay. If those first 5 calls
He is
were
so
iPhone
far
to
in-
iPhone rather than
Brennan is so far in the weeds on something that's not helping at all, like at all, because he already made the points. And now Brennan is just, I think, spending a lot of time saying, well, you don't understand my expert's chart. But it's giving, that's because the chart's not complete. Okay.
infotainment to iPhone, would you agree they should not have been considered in your analysis?
Yes,
If.
with the caveat that because this is a novel analysis with this SD card and this infotainment, that it was demonstrated that that's the behavior. My opinions on things like that are based on testing and research and literature. And so when we have a brand new system with new data, we want to see some testing to prove it works the way we think it works. But under the assumption, then yes.
You would agree?
Yes.
He's like, right, then take those.
Turn to
Are there
10,
4 or
please.
5? Take those 5 out then. Fine. Strike those off the top. He's like, that's fine. Go ahead. It doesn't change the analysis. It just changes the amount of options. So from 30 options to what, 25?
Given, could you
Okay.
zoom in a little, please, on the left?
He's like, sure, reasonable. If you want to do it that way, do it that way.
Given that these data points come at 5 in the morning, or 1, 4, 4, 4, 5, 5, and 5:30, did you consider whether they would be less reliable than comparing to the triggering event, the 3-point turn at 12:23 the night before? Did you consider that?
Yes.
When you said you reviewed and you're critiquing reports, did you read Mr. Burgess's report on May 8, 2025?
This is a better line
Yes.
of
Did you read in his
questions.
report where he explains that this is a less reliable method to, it's a less reliable method because of the time distance between the actual event we're interested in, 1162 at 12:30, 1:43 to 48, than the three-point turn.
Yes.
Okay. When he explains that the method of using 5:21 and 5:30 on January 29, 2022, he explains about how the information is stored in the infotainment system when it's powered back on, doesn't he?
Lisa, pellet ice is in my cup.
I'm not sure.
Well, do you remember when you were reviewing his report that he explains the available call log correlation is restricted to a time frame between 5:21 and 5:30 a.m. on January 29, 2022, when the vehicle was powered on. All other calls stored in the infotainment module occurred while the vehicle was powered off, indicating those entries were synced from Miss Reed's iPhone upon reconnecting to the system on the morning of January 29.
Objection,
You
compound.
considered that when you decided or formulated your critique, didn't you?
Yes.
This further indicated that the associated timestamps for those calls originated from Miss Reed's iPhone. Did you read that?
Yes.
Relative to those first 5 columns, correct?
Yes.
This behavior was previously documented in the initial report, which is the January 30th report. Yes?
Yes.
You shrugged. I mean,
a
I don't
good
want you
point.
to agree with me. Do you remember it was in the January 30th report?
No, that's a good point. The point is, this was in the reports and you didn't consider it.
I don't remember how he phrased it specifically.
And you disregarded it. That's a fair
But I
question.
think there was somewhere around there where he noted that some calls were placed while the vehicle was off. I think that's basically what it said in the first one. I don't remember specifically.
Okay. Do you agree generally, or can I give you the report? You can look and remind yourself. I want to get your best memory on this.
Sure.
What would you like me to do?
If you'd like me to look at it, I'll look at it.
Sure. Do you have a copy? Would you like me to bring it
do
to
you
you?
have
Dial
the
down
reports
the
with you, sir?
snark?
Okay.
Maybe?
Do you have an extra copy for him, Mr. Brennan?
Mine is marked. You want me to show the mark? Let me see if I can get a clean copy for the witness.
Now Brennan wants to be out. Because the witness was like, okay, so if you remove a few, you remove a few. But it's indicating how important Brennan thinks this witness is, that he has spent this amount of time going through all of the different iterations. Because what Brennan is trying to do is say, no, you've said all of these things are reasonable. There's
I
no,
don't have a clean copy. I don't want to show you something.
all of these things are reasonable. There's no ability to pick between the different variance points. And Brennan is saying, actually, there is a way to narrow these down. First of all, these 5 come from something else, so those don't get included. Then we want to look closer in time to the event, so these get excluded. So he's now going through the opposite of the mention it all, include it all, to no, you don't include it all. You throw these out, and that's where he's getting to in his cross, which I think is the more helpful part of his cross. No, we don't include them all. You lop off these, you lop off those, and this witness agreed with him. Sure, if you can prove that those came from the phone clock and not the infotainment clock, then lop those 5 or whatever off. Fine. So now he's trying to narrow down the other variances to try to remove them from the analysis. And then you narrow it right back down to the ones Brennan is focusing on, which is the 3-point turn is what he wants to focus on.
Something that has my writing on it. Not that I care that you read it, but it's protocol.
It's a more
Okay.
helpful
In
level.
discussing,
He's also like, do you have a copy of the report? No. Can I give you a clean copy of the report? No, I don't have one. That's not helpful,
why
Brennan.
this is not an effective way of matching the time, did you consider in his May 8, 2025 report, when he's talking about this method, when he says, as a result, this method yields a single reference point for potential alignment?
Yes.
And
Call
when
logs
talk-
are discrete points.
I'm sorry?
The call logs are discrete points for alignment. Is that?
As a result, this method yields a single reference point, is referring to the 53031.
I don't know. It sounds like it, but I don't know.
From the 5:21 a.m. to the 5:30 a.m. window, a clock speed approximately -8 and -16 plus 21 seconds were observed between the Lexus clock and Mr. O'Keefe's iPhone clock. Did you consider that?
Yes.
This offset is measured approximately 5 hours after the time of the collision. and not
We're still on the
5 other
same
time frames stated
slide
before.
with the infotainment and the
Going to allow
phones.
it unless, do you have, I'll see Counsel at sidebar.
They're trying to find, I think the judge wants to find a report for the expert to move this along because we're getting into asked and answered territory. I'm going to zoom as much as I can through the sidebar because we are getting into very repetitive area of testimony.
Sir, going back to my question, so you read Mr. Burgess' report, the same report that you're critiquing, and you were aware of this information, weren't you?
Yes.
And so you were aware that Mr. Burgess in his May 8th report was identifying that the section in green was the only contemporaneous information for analysis. Did you know that?
Is that how he states it specifically?
I can read it again. I just read it to you.
If you don't mind.
Okay.
So let's give him a copy.
I'm sorry, Your Honor?
Let's give him a copy.
Give him a
Just so you
copy.
have the clean copy.
You.
You can turn to page 3. What I read to you was where it says clock sync method
Is that just the printout with all the PowerPoint slides on it?
1. Do you see that?
Yes.
And this is, if you look at the second paragraph, I read that to you word for word. Do you see that?
Yes.
The 5:21 a.m. and 5:30 a.m. are the only 2 data points when that car was on January 29, 2022. Is that fair to say?
Yes.
Okay. And if you look at the last paragraph, do you agree or disagree? As a result, this method yields a single reference point for potential alignment. Do you agree with that?
No.
Because you still are under the mistaken belief,
Argumentative.
Sustained.
you still have the opinion.
The court didn't even let him finish his question. Didn't even let him finish his question. Because it's so argumentative.
That the first 5 rows are an infotainment to iPhone analysis.
It's presented as that way in his initial report, which is what my initial analysis was based on. And in the supplemental report, there's no further testing to say one way or the other. He just has a new opinion. So I stand by the initial analysis that I had.
So I
Those
included it.
points should be included with all of the other points.
But that's not my question. My question is, you are taking the position those first 5 calls are an infotainment to iPhone analysis.
They could be, and so I include them. I'm not saying they definitively are or not, which is why I never say there is one way to do it. That's why I say there's a whole host of ways to do it.
So you're now saying that you're not assuming that's an infotainment to iPhone analysis. Are you now saying that?
No, he's saying that it could be. He's always said that it could be because that's the way your witness listed it in his fucking chart. Are we still talking about this?
It's stated that way, and I think it could be that way, but it might be iPhone to iPhone too, if those times are just copied over.
And if it was iPhone to iPhone, your analysis would be wrong.
Certain lines would go away. So
The analysis
if you want
is
to
the
call the
same.
whole analysis wrong because of that, it might be your characterization. Okay. It would change the total number of possibilities.
Yeah, don't give it in to him. Do
So if
not.
we put up-
He would say it would remove a few variables.
Chart
Okay.
12, page 12, please.
Brennan made some decent points, and now he's so far in the weeds on this. It's just
If you were wrong
at this point
about the infotainment to iPhone analysis,
ridiculous.
and those first 5 should not be considered, which part of your chart would now be wrong?
He's not saying it's wrong. He's saying you could, in
What do we
theory,
have?
strike 2.
12 lines on the chart?
I'm sorry?
Yeah. we have 12 lines on the chart. If we decided to eliminate the lines that are based on the calls when the vehicle was off, we would be left with 4 lines on the chart.
That's a substantial difference. Oh, but that's a substantial
And if
difference.
we turn to
You would be left with 4 lines on the chart
14,
is a big
please.
difference.
And if you could enlarge, well, I don't think you can enlarge it. If your analysis about infotainment to iPhone was wrong, you would agree those first 1, 2, 3, 4, 5, 6 columns should not be there, should they?
He didn't say that.
No, the positive 16 stays, the negative 21 stays, 1, 2, 8, and 20 would go away. So we'd lose 4 lines from this chart.
And the negative 16 line, that comes from information at 5:30 a.m. the next morning.
Correct.
And you would agree that that distance is not as accurate as queuing it from the 3-point turn event 1162-1.
The 3-point turn is closer in time than the call at 5:32,
And thus more reliable, wouldn't you say?
generally.
And the negative 21, that was from 5:30 and some seconds the next.
And the thing is, this witness isn't fighting Brennan. So closer in time is more reliable. This witness said generally. Okay, so these are the ones closer in time. Yes. Okay, but you still included all these other ones, correct? Correct. But these ones you said are generally more reliable. Yes. Yes. Done. He's not fighting with you on that. So why are you fighting back with him? Because you've lost the point. He agreed with you. And the fact that he agreed with you is going to get lost in all of the other fighting. Brennan, the witness has given you some really, really good answers. And you've mucked it all up by wanting to fight with him when he's not fighting with you. So the good answers are going to get lost in you fighting. Okay.
Next morning, same idea. Not as reliable as the 3-point turn information.
There's greater uncertainty the farther in time we get.
So when we turn to the 3-point turn information, you mentioned in Dr. Welcher's report that it was noted that the timestamp 154 was the end of the 3-point turn event, correct?
That's how he states it.
And then more information was provided when Mr. Burgess then broke down that 154 timestamp, correct?
Correct.
And when he broke down the 154 timestamp, he actually wrote a report about it, didn't he?
Yes?
He didn't just have it in his head, he put it on paper for all to see, yes?
Yes.
And in that report, not only does he break down the data, he also shows a visual of the actual data on a map, doesn't he?
He does.
I don't care if we're talking about a time variance that it's on a map. Brennan, I'm trying to eat pretzels. Are we going to ask more questions or are we done? What are we doing?
Exhibit 192A.
We're wandering away from the microphone is what we're doing.
Okay. Let's start with 192B, please. If you could open that up so we could see it a little better. When you look at the data he actually broke down, do you agree that instead of at the end of the 3-point turn event as timestamp 154, that actually is at the beginning of the 3-point turn? Do you agree with that?
I don't
What are we doing?
know if the points are numbered on here, so I can't tell which point he's referencing as 154.
Do you see the green circle?
Yes.
Do you see the black line?
Yes.
Does that orient you to the direction the car was traveling?
That appears to be what he's trying to convey with this chart.
And then the yellow is facing a different direction, towards Fairview, correct?
It is.
And do you see the green square rectangle?
Yes.
You think that correlates to the green circle?
That seems to be what this graph implies.
And it notes that,
So ask it differently, Mr. Brennan.
does that heading note the start of the three-point turn of O'Keefe's phone is 12:23:59?
I'm going to allow it.
That's what it notes.
That's what Mr. Burgess states in the report.
And do you have any information to suggest that's not spot on accurate?
No, I didn't do an independent analysis of the three-point turn maneuver.
And then the heading of the change, end of three-point turn to O'Keefe's home, 12:24:07. Do you have any information to suggest that's not spot on accurate?
I did not analyze the three-point turn maneuver.
And so when you look at that and break down 154, did you determine or make an analysis that 154 that was generally accepted, because there is variances between items, when you break it down with more specificity, 154 is actually earlier than the three-point turn conclusion. Did you consider that?
I'm going to allow that, yeah.
I'm not sure I understand the question, if you don't mind.
You mentioned Dr. Welch's report said it relied on 154 as a timestamp for the end of the three-point turn.
Yes.
Based on Mr. Burgess's May 8th report and based on the data, which you don't contest, you now agree that 154 was not the end of that three-point turn. It was at the beginning.
Based on how Mr. Burgess presents it, I didn't do an independent analysis. So I'm not on one side with Mr. Burgess or one side with Dr. Welcher.
The
They
point
present
changed.
independent methods.
Are you suggesting in any way it's inaccurate?
He's like, I have no way to know.
Are you suggesting it is in any way inaccurate?
I'm going to allow that.
I don't have any opinions as to the individual accuracy of the methods
Between the two.
selected by either Mr. Burgess or Dr. Welcher.
Do you have any information you'd like to add or weigh in on to dispute the accuracy of those times?
Sustained.
And let's turn to the previous exhibit so we can actually see the data that's broken down.
He's gotten very
open that?
lost in the weeds.
The 154 timestamp, if you go to the left, please.
And he
You see
made
that right
some
above the
really
green
good
line?
headway with his witness, and he's just
Yes.
gotten lost in all of the weeds.
12:23:58. You see that?
Yes.
And then the green goes to the orange, and that's an 8-second difference, isn't it?
Yes.
And when you looked at this, you considered that this was a more detailed study of that timestamp by Mr. Burgess, right?
He didn't
More
study the
detailed is
timestamp.
yes, that's correct.
And do you know why he did a more detailed analysis of this? Why it wasn't in the original PowerPoint?
No, I don't.
Well, you said
Is it because the original PowerPoints didn't have a ton of information? Or is it because this expert submitted his in the middle and then they went back and went, oh, there's more information?
that variances are generally accepted in the community, right?
Yes.
But then you wrote a report suggesting numbers and additions, and you submitted that report as part of the basis of your testimony, right?
I only submitted a PowerPoint. I have no report.
PowerPoint. And after you submitted the PowerPoint, isn't it fair to say Mr. Burgess then analyzed this data to be more specific after you introduced your PowerPoint?
Yes.
So can you guess why he went through a more detailed analysis?
That calls for all the speculation. Isn't that what the defense was arguing with Burgess? You got this expert's report and then you updated your report. Isn't that exactly what they asked with Burgess? And now he's like, so Burgess wrote a report, you wrote a report, and then Burgess responded to your report with his report. I'm sorry, PowerPoint.
No.
Sustain. Strike it.
It should be stricken. It's all speculative.
In the final exhibit. Let's go back to the data. You said that Mr. Burgess had an 8-second range, 21 to 29 seconds, remember?
Yes.
And you were suggesting that somehow there was some uncertainty. Do you remember that?
Yes.
Okay. Were you guessing about his state of mind, whether he was certain or not? Do you know why he gave an 8-second range?
Objection.
So ask it differently, Mr.
Okay. You suggested
Calls for
the reason why there's an
speculation.
8-second range is that Mr. Burgess was uncertain. Remember saying that to this jury?
Not in those exact words, but that's what uncertainty is. Uncertainty is a range. If we don't know a specific value, we put a range around it. That's uncertainty. That's a
This data from the green, would you agree it indicates
He's
the
like, it's not a
beginning
value
of the
judgment.
curve, and then the orange is at the end when the car is already in motion at 11.2 miles per hour?
Objection.
I'm going to allow it. Do you agree with that?
I see speed values there. I see some headings. I can't convert GPS in my head, so I don't know.
You could have analyzed this data yourself, right? Before you came and gave an opinion.
I could have.
But you didn't.
He wasn't
I did
asked
not.
to.
Do you have any reason to test the accuracy of this data that's been broken? No objection.
I'm going to allow that.
No.
And so by giving the range of 8 seconds, you talked about looking at different values to be fair, wide range, right? Even though this analysis depends on the end of the three-point turn, would you agree it's kind of forgiving to give that 8-second range to give the benefit of the doubt by starting at the beginning of the
What?
three-point turn all the way to the end of it rather than just giving the end point?
As to that form, ask it differently, Mr. Brennan.
Does the 8-second range that is provided by Mr. Burgess coincide with the data and the 8-second range between the green and the orange?
That's where he comes up with the 8-second range, correct.
And so if Aperture's position is the matching times at the end of the event, going back to the beginning, isn't that even more forgiving than the 8 scientific? Objection.
I'm going to allow it.
Yeah, I would call it a conservative approach to use a range of values.
The opposite of cherry picking, right?
Sure.
Yeah, this witness isn't fighting with you. Stop fighting with him. You lose all your points because you're fighting with him.
Do you have an opinion to a reasonable degree of forensic data certainty
What? You're
about
asking.
whether text stream data provides data reflecting whether a collision actually occurred?
No.
In your opinion, to a reasonable degree of forensic certainty, is the text stream data would not
He just said he didn't have an opinion.
reflect the collision, correct?
That's not what I said. I don't have an opinion.
And you know that there can be collisions or touching between vehicle, and it's not going to appear on the text stream data. You know that, right?
It's possible.
It's possible. Did you know that the defendant's vehicle at 5:07 a.m. on January 29, 2022 bumped into a different car?
Yes.
Do you see that reflected on the text stream data?
I'm thinking back to when I reviewed the raw text stream data, and I don't remember seeing an event from that.
I can't really
I
hear
don't
you.
remember seeing an event from that time in the text stream data.
Well, you don't remember seeing it. It's not there, is it?
I don't think it is. I don't remember seeing it. I don't think there's one.
You're not.
I was going to finish and say I don't have all of the events committed to memory. There's
You're-
19 of them.
I'm sorry.
There's 19 events. I don't have them all committed to memory.
You're not testifying or offering an opinion that there was no collision with this car that night, are you?
No.
Because if you were implying that or suggesting
He's
that
already
or
said no.
insinuating that, that would be misleading, wouldn't it?
He said no multiple
not.
times.
Sustained.
That's argumentative. He said no multiple
I have
times.
no further questions.
Okay.
And cross is done.
You were asked a number of questions.
Yes.
You were asked a number of questions
The big
minutes ago by Mr. Brennan concerning your expertise. I'm just going to grab a pen.
The good points made by Brennan are going to get lost in the way that he makes them. This witness was not fighting with him, and he was hammering home points that were already made.
Specifically, you were asked about your expertise regarding mobile data devices. Mobile devices and their data, correct?
Yes.
And were you being truthful when you indicated that you were not an expert in
Yes.
that field? Were you being truthful when you indicated that you have a certain expertise in EDR data?
Yes.
Were you being truthful when you indicated that you did review Mr. Burgess's data and Mr. Welcher's data as reflected in their
Go
reports and
ask about
PowerPoints?
Burgess's chart.
Yes.
Some more.
Were you being truthful about your credentials?
Yes.
Have you ever lied about your credentials?
No.
You hold a bachelor's degree
Yes.
and you hold a master's degree.
I do.
You ever lied to anybody about that?
No.
Right. So going back to attacking Burgess. However, it's because there was some headway made in cross-examination.
DiSogra, what is the only reason you amended your PowerPoint presentation from its original version
That's the
to
question.
the one that you most recently amended it to?
To include the additional analysis and data points from Mr. Burgess's supplemental report,
So-
the May 8th report.
I'm sorry, I interrupted you. Go
The
ahead.
May 8th report.
I updated
You
my
amended
shit
yours
because they updated
because
their
they
shit.
amended his.
Correct.
I think that's really the only question that mattered. Truly.
You were asked just a second ago about all the text stream events that you noted on Ms. Reed's SUV, correct?
Yes.
Mr. Brennan asked you about a specific text stream event at or around 5:07 in the morning, and whether you had something like that committed to memory, correct?
Yes.
You said, I don't have them all committed to memory, right?
I don't.
What did you say after that? Because there's how many?
It was 19 events prior to 1162-2, 19 other events.
How about after 1162?
There were a number after 1162-2. I don't have the exact count in my head.
What?
How about after 1162, just on January 29th, going into January 30th?
There were other events.
How many?
I don't recall the exact number.
Does 11 sound right?
That it sounds plausible. I recall seeing in the chart. I recall seeing a number of events after.
What?
Chart.
It would. Thank you. Yeah, there are a lot. I would have to really use my finger to count them all.
Count them.
More than
No, count them. Use your fingy.
Total after
Count 'em up.
1162-2.
1, 2, 3, 4.
There
Just do
aren't
it.
date stamps on these because this chart is the raw text stream data, which doesn't have timestamps.
safe to say there are many.
Yes.
May I approach?
Yes.
And again, this goes back to a question that you were asked by Mr. Brennan. I want to follow up on. In no instance were any of those related to a collision, to your knowledge, correct?
Objection.
Sustained.
Were any of those that you reviewed at any time, the lifetime of the vehicle, related to a collision?
None of
said
them were
no.
triggered by a collision.
Thank you. I want to ask you a hypothetical, if I could, based on questioning
that-
by Mr. Brennan.
I think both sides can explain, and both sides are going to explain. The text stream data does not show a collision. And the experts from all sides have said we would not expect it to show a collision for the bump into John O'Keefe's car or for any collision with John O'Keefe. We would not expect to see it. So the fact that it doesn't exist is consistent, but it doesn't mean it didn't happen. Because they wouldn't expect to see either one. Okay. And everybody keeps going back to it, but it goes both ways. Okay.
Surrounding the 12/32/09 lock event. Do you remember him asking you about those questions, about that event?
Yes.
Your analysis was based on the time span. Let me rephrase that. Was your analysis based on Mr. Burgess's and Mr. Welcher's analyses together
Yes.
of a span of time between the 1162-2 check stream event or trigger event and the lock event at 12:32:09.
Objection.
So the question is that what he's considering?
Correct. In other words, was he basing his opinion or analysis on that time frame, at least in part?
So I'll let that question stand.
Thank you.
Yes.
Okay. If you were told that there was another interaction phone event on John O'Keefe's phone at 12:32:16 in the form of steps taken, 36 steps over the course of 83 feet, would that change your analysis or opinion in any way?
Objection.
I'll allow that in that form.
Yes.
In what way?
If the phone event moves from 12:32:09 to 12:32:16, then of the 30 possibilities I had in the chart, all of them would become positive. That would mean that that interaction occurs after the end of the vehicle event every single time. Instead of, it was 25 for 30 in the original analysis, the hypothetical would change it to 30 for 30.
All of them, all 30 of them.
Oh, he's going to ask for a recross on that.
At a point in time, let me rephrase that. All of them would reflect a scenario in which the phone interaction.
So for a minute, jurors, feel free to stand up.
That was the feed, not you. I was taking notes about the phone interactions. Let's back that up a little bit. I think we were pretty close in real time. So we're going to back up a bit to the phone interaction. He's asking, well, they're going to ask for a recross on that because he's asking about the phone steps and whether that's a user interaction with the phone, and we know that it's not. But hold on, this is buffering on me. Give me 1 second. Let's find where we were in time. Because
Trigger event and
hold on.
the lock.
I'm going to try to find, well, we're going to do it together. Where we were, because we were not that far
Your
behind.
expertise. I'm just going to grab a pen.
So we were back here somewhere talking about the steps and the step data. Nope, we were right about where it started to freeze. I wonder if that's why it jumped.
Yeah, I would call it a conservative approach.
All right, let me try to get back to where the steps were.
Range that is provided by.
Oh. Nope, we've gone way too far. Apologies, chat.
In this case, no.
Okay. Is there a timestamp associated with infotainment system?
All right, hold on. I was trying really hard to find the step data and the stream. Oh, the feed buffered, and that's what kicked it forward.
Try the.
You were asked several questions about what you believed Mr. Burgess may have gotten wrong in terms of.
I think we were I don't think we were there. I think we were a little bit back. I was trying to get to where our step information was.
Every single time. Instead of, it was.
Yes, there we are. All right. That was frustrating.
Course of 83 feet.
There.
Would that change your analysis or opinion in any way?
Objection.
I was taking notes when the
I'll
feed
allow
got
that in that
sassy.
Yes.
In what way?
If the phone event moves from 12:32:09 to 12:32:16, then of the 30 possibilities I had in the chart, all of them would become positive. That would mean that that interaction occurs after the end of the vehicle event every single
And
time.
now we're caught back
Instead
up to where we
It
were.
was 25 for 30 in the original analysis. The hypothetical would change it to 30 for 30.
All of them, all 30 of them would occur at a point in
Yeah, I disagree with that premise
All of them
from
would
Jackson.
reflect a scenario in which the phone interaction took place after the trigger event.
That's correct.
Thank you.
Yeah, that I don't agree with that premise, but which
If you were told, to give you another hypothetical, if you
because
were
the
told
phone
that
the
there was
steps
a
are
Doppler state event on the
written
phone,
later.
pocket state event on the phone at 12:33:14, would that impact your opinion in any way?
Objection.
Sustained.
I'm looking at my post-it note
You
with
were
the
asked-
times of the phone.
Several questions about what you believed Mr. Burgess may have gotten wrong in terms of his original report and one of his original analyses dealing with bits and bytes. Do you recall that?
Yes.
Did Mr. Burgess?
Hold on.
Of course.
You need to, you know, we have to turn the fans off.
And I'm not speaking loud enough.
Right.
I'm sorry. I'll raise my voice. I just don't want to.
The court, I imagine the court reporter is having a hard time hearing because of the fans. This became a huge problem last trial, but I also understand that Jackson doesn't want to raise his voice so much that he sounds frustrated or angry, which can be a thing with voice projection, right?
Scream over people, but I will raise my
Right.
voice.
Let's try this for a few minutes.
May I start again?
That question, yes.
Thank you. You were asked about whether or not you believed that Mr. Burgess was incorrect
Yeah, the fans really,
in
really
terms
loud
of
in court.
certain analyses he undertook or reflected in his original report back in January of 2025, correct?
Correct.
As it relates to the bits and bytes, did you find that Mr. Burgess was incorrect or correct about his analysis concerning the size of the data set collected based on bits versus bytes?
He was incorrect.
Explain that to the jurors very briefly.
These are just different units. A bit is a different size than a byte. And so if a size for something is listed in bits, for example, and you look at the data and assume it's in bytes, you will assume it's the wrong size.
Which Mr. Burgess did based on your review of his report, correct?
Correct.
I want to change gears and ask a different question or series of questions about the text stream data versus the infotainment system data, specifically the timestamps associated therewith. Is there a timestamp associated with text stream data?
In this case, no.
Okay. Is there a timestamp associated with infotainment system data?
Yes.
All right. The infotainment system data, well, let me see if I can ask it a different way. Where did the 3-second delay come from? Your analysis of Mr. Burgess's review of the text stream data or his review of the infotainment system data?
The 3 seconds came, well, fundamentally it came from the exemplar testing, where he identified, and he was actually, well, Aperture collectively in that testing identified a difference between when the button was pushed and the time that showed up in the infotainment. But they didn't actually look at, as far as I know, or at least it wasn't provided if they did, how that specifically related to the key on timer itself. But they showed that the button is pushed, there's a 3-second delay, and then the time gets logged.
When that button is pushed for the infotainment system, I'm going to rephrase again, so I'm as clear as I can be. When that button is pushed for the on event, the key on event, is that like a stopwatch? Click, a stopwatch starts running? Timer?
In the VCH system, yes.
Okay. Separate and apart from the VCH system, is there an infotainment system that also has a timer or a clock on it?
Has a clock.
Are those two things independent of one another?
Completely independent.
What were you doing with regard to the 3-second delay as it relates to the key on event and the infotainment system event?
Adjusting
Marry
the
those
clock.
two things together.
Right. I'm making the adjustment, or proposing that adjustment can be made, because the key on timer is going to start generally as soon as the vehicle powers on. But the infotainment, when you go and download the data, it will say, hey, I think I powered on at this time, and it turns out that time is actually 3 seconds off. So if you're going to then apply the infotainment time anywhere else to VCH data, you've got to realign the two, and that's where the 3 seconds comes from. These are independent data sources.
Did Mr. Burgess, to your review of his, insofar as your review of his analysis, his report is concerned, did he align the two vis-a-vis the 3-second delay?
No, he did not.
Thank you. With the court's permission, may we have slide 10 of the PowerPoint of,
Okay.
and that is, we've talked a lot about PowerPoints of Mr. DiSogra's PowerPoint.
Yeah, we don't want to go back to anybody else's
Can you
PowerPoint.
highlight the table on the left?
The
Mr.
bad,
Wolf?
the bad PowerPoints shall not be put on the screen again. No bad PowerPoints.
Did you create this
I
table?
hate them.
No.
Was this table, I don't know if you call it cut and paste or if there's some better engineering term?
This is the table that says infotainment system on the phone
Or
calls.
was it basically pulled from Mr. Burgess's report?
It was. It was
Did
a
you
screen.
type-
It was a screenshot.
Thank you. Screenshot.
Right.
Did you type a single word on this?
I did not. I added
It's
a green
his
box.
chart.
Put a green box around it.
Yes,
You didn't type anything on this.
I did not.
You were
Right.
asked a ton of questions just a few minutes ago
He was asked a ton of
about
questions
whether or
about
not
it. Yes, he was.
the column on the left
So many questions.
and the center column were reflective of an infotainment timestamp versus an iPhone to iPhone timestamp, correct?
That's right.
I hope,
Mr. Brennan asked you a
That this
bunch
is
of
the
questions
end of
about
redirect.
that left column
because this is the point that needs to be made.
being an iPhone timestamp, at least the top 5 rows of it. 1, 2, 3, 4, 5 rows of it. Remember that?
Yes.
Read the name that Mr. Burgess labeled that column.
Infotainment call timestamps.
So what,
Right,
as
it's
an expert, what did
obvious.
you presume
Right.
he, as an expert, was presuming?
Objection.
Sustain.
What did you
Right.
presume that meant to you, just to you?
Call timestamps from the infotainment.
So if
Right.
anything is wrong with your analysis,
It's relying on
would it
them.
be based on Mr. Burgess being wrong in his analysis?
Objection.
Sustain.
No, it's wrong in his labeling. The point's made. Right? The point's made. He did concede that you could take out a few. He was like, sure, take out a
Just a
few.
moment, Your Honor.
Sure.
I'm not fighting you on it. Go ahead.
I don't. And we can pull that down.
And I appreciate that he was like, sure, if you take out a few, you take out a few. So it's a few less. Okay.
What was your entire analysis predicated on? What was it based on? The foundation of it, as you explained your analysis to this jury.
Their data.
The testing by Aperture and the collective reports and PowerPoint presentations by Aperture. That would be an initial report by Mr. Burgess, an initial PowerPoint by Dr. Welcher, and a supplemental report by Mr. Burgess.
Did you change any of their data?
No,
Did you change any of their analyses?
no,
Did you explain their analyses?
yes.
Sustained, ask it to.
Sure. What were you trying to do in terms of your presentation, in your PowerPoint, and your presentation to this jury?
There were a number of different methodologies presented across all of those reports and PowerPoints, and sort of all in different places. So my goal was to bring all of them into one place so we could look at the totality of the data.
You were asked whether the genesis of your analysis relies on knowing the source of
Right.
the calls, correct? You remember being asked that by Mr. Brennan?
Yes.
The actual
Multiple times.
genesis of your entire opinion is based on Mr. Burgess's and Mr. Welcher's analyses, correct?
That's correct.
Okay.
You were also asked why you believed Mr. Burgess did a quote-unquote more detailed report in May versus January of 2025. Do you remember being asked that just a few minutes ago?
Yes.
That called for speculation.
When you presented your analysis, your math, based on Mr. Burgess's January 2025 report, how many of the scenarios indicated, based on his data and his analysis, that the lock event occurred after the texting event?
All of them.
Thank you. That's all I have, Your Honor.
All right, Mr. Brennan.
It was a good end to redirect, I think. But Brennan is going to redirect about the step data, I would
So,
imagine.
Mr. DiSogra,
or recross
this
about the step data.
demonstrates the danger or the difficulty.
Hold on. Start the
It's
question
cross-examination.
differently. Start- Go ahead, Mr. Brennan.
Oh, that's the most I've heard these attorneys snap at each other in open court. Because I think what Jackson said is this is a speech, and he's like, no, it's cross-examination. And now they are directly snapping at one another. Oh, boy.
So, Mr. DiSogra,
We
this
knew it was gonna happen.
demonstrates the danger or the difficulty.
Hold on. Start the
It's
question
cross-examination.
differently. Start- Go ahead, Mr. Brennan.
This demonstrates the difficulty in giving opinions when you don't actually study the data itself. Isn't that fair to say?
What are you referring to with this?
Well, you're giving opinions, but you can't verify any of the data because you're not relying on your study of the data, are you?
I'm relying on expert reports.
You're criticizing somebody's report, but you yourself can't defend data that you haven't actually analyzed and broken down yourself.
I don't think that's true.
When you're looking at, turn on 10, please. When you're looking at someone's report, you're guessing as to what they thought or presumed if you haven't spoken to them. Fair?
I'm relying on what they said.
I would say I'm reading the words that are in front of me and interpreting them for what they say.
When someone plugs their iPhone into a car after it turns on, and the car reads data that's on the iPhone, that data then
Brennan, this is not a
resides
serve.
on the infotainment system, correct?
There's a transfer of data.
And
Yes.
so unless you actually
The jury is looking at a PowerPoint slide with a header on it, and you've spent like 30 minutes arguing that the header doesn't mean what it says. Move on.
do the study yourself, you had no way of knowing if that information, although on the iPhone, on the infotainment system, you had no idea whether it was from an iPhone or from the infotainment. Fair?
That's right. I don't think that's.
And so when you
No.
don't actually do the work yourself, and you just presume or you guess, you could get it wrong, couldn't you?
If I had guessed, yes, but I didn't guess.
I relied on
used
them.
The data in the reports, and I referenced the testing that Aperture did. So I did not make a guess.
1 through 5, and you telling me right now, to a reasonable degree of data certainty, that that information is based on the infotainment clock. Is that what you're saying?
I don't know.
You don't know.
That's what he said it
You
says.
actually did the analysis yourself rather than just Monday morning quarterbacking somebody's report.
Objection.
So I'm going to strike it, ask it differently, Mr.
You
Brennan.
actually did the analysis yourself. You wouldn't have to make a presumption that it would be wrong, correct?
I don't think the analysis was possible in this case because the testing wasn't done in this case.
You don't know if the testing was done or not. You didn't do the testing.
So I need to hear the question.
You don't know.
Brennan fighting over you don't know if the analysis was done when he said he relied on all of your expert reports is wild. He said, I read all of their reports, everything they turned over. Well, you don't know if it was done. So did they not document it anywhere? Because I get the sense that engineers really like to document shit. You don't know that it wasn't done. It's not in any of their reports, though. So I relied on their reports. And if it's not in their reports, then I don't know that it was done because, well, it's not in the report. We've ended up in like a res ipsa loquitur loop at this point with this line of questioning. This is going to have to be the thumbnail on today's summary. It's just going to have to be this. because this is exactly what today has been for me. It's this. This poor witness is just like, I just relied on what they did.
Know if the testing was done or not, did you?
I know it's in the reports. The testing wasn't in the reports.
Did you read Jessica Hyde's report?
No.
Did you read Ian Whiffen's report?
No.
You don't know.
But the jury knows that Ian Whiffen and Jessica Hyde didn't evaluate what was in the car.
If that testing was done, did you?
I don't.
It's a bad line of questioning.
I do not, sir.
And so if you're wrong, your assumptions and product are then wrong.
Part of my conclusions would change. I wouldn't agree that I'm wholesale wrong.
Well, as a scientist, if they're not accurate, that would be wrong, wouldn't it?
They're not wrong, though.
That might be a nuanced answer.
I'm sorry?
I said that might be a nuanced answer. Frankly, I'm not sure how to give you a good answer to that
If
question.
you have the wrong data when you're doing your analysis,
If you have the wrong data when you're doing your analysis, the data comes from your experts. If you have the wrong data, the data from your experts. Sir, you are lost in the forest at the moment.
then the final analysis is going to be wrong if you have using the wrong data. It's that simple.
Yes.
Right? You don't have to be a scientist to figure that out.
Argumentative.
Okay. If we could have Mr. Welcher's 33.
So whose data were you using? Theirs? Okay.
If you could open that up, please. You were asked about whether
For all of you saying, how
The
can he have the
windows-
wrong data when he's relying on their expert data? Brennan's trying to say he's interpreting it wrong because he interpreted it the way it was labeled.
within the time frame of 12/32/09, the last user interaction with the phone. When you look at this data, could you go to the top, please? You see on vehicle speed, the car is moving. You see that? Could you enlarge that a little bit, please? The beginning of that data capture, the car's already moving, correct?
I see vehicle speeds, right, in those first couple of lines, yes.
Yes?
Yes, I see
Yes.
vehicle speed.
If you go to the bottom, at the end, the car is still moving, yes?
I see vehicle speeds there as well.
2361. That would indicate, in
That's
your experience
fair.
with text stream data, the car is still moving, yes?
At the end of the record, there is a vehicle speed, the car is moving. That would be my assumption.
Okay. And so, when you're making your conclusions that something's with or without, you're simply talking about the time of the 10 seconds of data. Yes?
That's fair. Yes.
Yeah, everything that I've done has been referencing the end of event 1162-2, which is exactly how it's been referenced in all of the other reports.
That 10-second window. Yes?
Not even the window, just the end. Everything has been, everything in
about
the
the
Aperture
walls?
reports talks about the end of event 1162-2. So that's what I used across everything.
And when you say end of event, you're referring just to data, not the actual real-life event.
Yeah, absolutely. The end of the recording.
Okay. And so, after that window, 12/32/04
That
to
was me.
12/32/12,
Apologies.
you were asked a question about what might have happened 4 seconds later, 12/32/16. Remember you were asked about that?
Yes.
Did you know at 12:32:16 that John O'Keefe's cell phone moved for the last time? Did you know that?
No.
And between 12:32:12, which is in the 10-second window, and 12:32:16, do you know what John O'Keefe was doing in that 4-second
Oh, I was
period?
just side questing to real time because
Do
I
you know if he was walking?
accidentally
No.
shut
Do
my
you know if he was crawling?
other feed.
No.
Do you know if he was falling?
No.
You don't know.
Yanetti's
I do
up
not know.
next.
Okay?
He's asking for a
12:32:16.
raw direct. It's gonna be
I didn't review the phone data, so I don't know.
it's gonna be like a Gaga direct from here on. It's like because now we're on like all the redirect,
Doing in that 4-second.
and I can't even
period.
hear Jackson.
Do you know if he was walking?
No.
Do you know if he was crawling?
No.
Do you know if he was falling?
No.
I backed up
Don't know.
because I
do
couldn't
not
hear
know.
Jackson at all.
Okay?
I'm gaining this up. It's gonna be loud.
12:32:16. Wasn't just that Mr. O'Keefe's phone was moving, there were steps to it, correct?
I didn't review the phone data, so I don't know.
Did you review anything to indicate that steps were taken over the course of 43 feet?
Objection.
Anything
So
else?
that's sustained.
Asked and answered.
You were asked just a second ago. What about the data? What if it's wrong? Then you'd be wrong, correct?
Generally, yes.
Garbage in, garbage out. Basic scientific postulate, correct?
Generally, yes.
You're relying on whose data?
Mr. Burgess's data and Dr. Welcher's data.
Thank you.
Period.
All right, Mr. DiSogra, you are all set, sir. So you can step down. I'm going to see counsel for a minute. Jurors, feel free to stand up and stretch if you'd like.
And that was the point of the direct. Whose data did you rely on? Well, that would be their data. All right, we are almost to real time. Let me gain this back down because we are very much almost. Are you letting the jury go? You are, aren't you? Let me gain this back up.
Jurors, we did that to have me decide whether I'm going to let you go home now or not, and I'm going to let you go home. So
Jury
that
out.
5 minutes that just means that you get to go home because we know we'll be longer and we don't want to do this to you, okay? So we'll break for the day. I have to give you those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about the case,
That's
please
early.
disregard it and let us know. Additional caution, please be very careful. Continue to be careful with your social media use. We will see you Monday. Monday will be a full day. We'll start right around 9 on Monday morning. So we'll see you then. Have a great week.
Please rise to the jury.
They are still going in court. So I am going to, oh, that was me. They are still going in court. So I'm going to zoom. We are very close to real time. So they take a few minute break and then they go back to sidebar. I'm going to do a quick summary. Don't go anywhere. Court's not done. Jury is out. But when you are in trial, there is a lot of work that needs to happen when the jury is gone. So the jury is out for the day at the end of Mr. DiSogra's testimony. I think Hank Brennan made some good points on cross-examination. However, I have to wonder if those points were lost to the jury because Brennan kept fighting over things that just weren't being contested by the witness. And when you keep fighting over the same point, the witness keeps going, yes, I agree. And then you fight and fight and fight. And the witness goes, yes, I agree. And then you fight and fight and fight. At some point, the jury's just going to go, okay, stop it. And what he was fighting over was the chart from Mr. Burgess that had the infotainment calls from Karen Reed's phone and the calls on John O'Keefe's phone. In Burgess's testimony, he said that he did not consider those first calls that had a timing variance of 1 or 2 because those calls were downloaded into the Lexus infotainment system from Karen Reed's phone after the car was turned on. He only considered the calls when Karen Reed's Lexus was powered on. And the witness agreed, yes, those calls all happened when the Lexus was powered off. The witness said, however, we don't have any testing to know the way that the Lexus imports the information from an iPhone. We don't know if it adjusts it. We don't know if it just takes the time off the iPhone. We don't know. That wasn't tested. It's assumed. So we don't know. And then Brennan went down a whole rabbit hole of, okay, you're assuming. And he goes, no, I'm relying on what they said. They assumed. And he goes, but if you're relying on bad data, then your analysis is bad. Which led to the very, very end. The last question from Alan Jackson was, whose data did you rely on? Well, Burgess and Welcher's. I don't understand why Brennan went so far into, well, that chart says calls from infotainment system. You assumed they were from the infotainment system, but you were wrong. The witness is like, well, it says it on the thing. And it's not noted anywhere else that it's not that, but it was in Burgess's testimony. And at the end, the witness said the analysis wouldn't be wrong. You would just take out those data points. So if you take out those data points, it's what, 4 or 5 calls? Okay, so you take out those data points. So instead of 30 points, you have 25 or 26 points. Okay. The witness was like, okay, then you take them out. But it was wild watching Brennan continue to fight on, but you don't know what that really says when it's so clearly labeled. Whose fault is it if the labeling is unclear? This expert or not? But we see what Brennan's approach is going to be with the defense experts. You didn't download the data yourself. You didn't do the analysis yourself. Okay. Earlier on, before lunch, Brennan made, I thought, a good amount of headway showing that there were things that Burgess connected in that were helpful. And then after lunch was sitting there going, but you don't even understand this chart. Well, the jury and all of us can see how the chart's labeled. So if the confusion is there, whose fault is it that it's confusing? And I don't think it's this expert who I thought was very clear on what he evaluated and what he didn't evaluate. And Brennan made some very good points with this expert that I think will probably get lost in all of the fighting over the labeling of that chart, because the fighting over the labeling of that chart just is so overdone for me when the chart clearly says what it says. It could have been 2 questions. Well, you don't know why Mr. Burgess did not use those numbers. No, I don't know why he didn't use it. Fine. Burgess's testimony stands on its own. But he continued to go in on it. And the point that was lost was that this expert very much agreed that the point in time closest to the key cycle, 1162.2, was the 3-point turn maneuver. And that is the more reliable time to sync the clocks to. And that is an incredibly good point for the Commonwealth that's buried in the middle of a bunch of pissing over what the thing is labeled. And I think it's going to get completely lost over the fighting of, yeah, but you relied on what my expert says. Because in the middle of it, the expert agreed. Yes, the best points of data are the closest in time to the 1162.2 event, and those would be the most reliable place to apportion any variance in time. And that's what the Commonwealth experts did. But because Brennan went so far down the rabbit hole of, but your data's wrong, when he relied on their experts, I think it gets lost. Because he's fighting over his expert data. And this witness agreed with him a lot. And he got, I think, lost in the sauce wanting to fight with the expert. Because ultimately, I think this expert largely supported what the Commonwealth expert says. But I think the impression that's left at the end of it is that this expert says, well, yeah, if the data's bad, I can't rely on it. And Brennan harped on it so much that maybe the jury's now going, oh, maybe we can't rely on any of it. Which was not my takeaway of the defense's expert saying, look, there's 30 data points. And then we narrowed those back down to, yeah, these are the ones closer in time. But the impression that's left at the end of it is, well, are the Commonwealth's experts wrong? And I think that's because of the way Brennan wanted to go in and fight. Instead of saying, oh, so you agree with me. You agree with these experts. You agree that this all happened, that 11/62/2 happened on January 29th at whatever the time was after midnight. Oh, you agree that this happened. Oh, you agreed. There were so many points where he agreed. So it's wild to me that when the Commonwealth was making headway to support their witnesses, that they chose to fight with this witness instead of continuing to say, so you agree with all these things. It, I think, will have the opposite impact of what Brennan was hoping to accomplish because of the way he went about it. And I imagine the defense was probably frustrated during cross that there were times where this witness agreed and supported what the Commonwealth witnesses said and said, yeah, closest in time, use the 3-point turn to narrow down the clock variance. It seems that all of the experts agree that that is the appropriate time for the clock variance. Or the jury's going to walk away with, okay, so everybody's relying on bad data, throw it all out. Which I don't think is what anybody wants, but it might be the result. But the jury's out and court's not done for the day, so let's get back to court, shall we? It's really wild to watch, right? Let's see what's happening now that the jury is out, shall we? Let's find out why my feed just decided to yeet into oblivion. Get back in here, court feed. We have court to resume. There is court to resume.
So I'm going to need her at a microphone. Do you have one on council table there?
We do not.
So the podium, or one of those back where Eugenia is. Thank you. No, there's a microphone a little closer. We're just follow the.
Thank you so much.
Hi, good afternoon.
Hello.
Could you tell me your name, please?
Kelly Dever.
And Ms. Dever, you've been summoned here. I think I saw you earlier. You've been here all day.
Yes.
All right. So we're not going to reach you today, unfortunately, but you were summoned to be here.
Yes.
All right. So that summons is still good until we reach you. So you're going to have to come back Monday morning. Okay.
Yes, ma'am.
Do you agree to do so?
Yes, ma'am.
Okay. Thank you very much. We'll see you Monday morning. Be here before 9. Okay.
Will do.
All right. Thank you very much.
Thank you, Your Honor.
So the witness was ordered back.
Go ahead, Mr. Alessi.
Yanetti.
Oh, geez, Yanetti.
She said Alessi as Yanetti was walking up.
Big compliment, Your Honor. Thank you.
And then the court said, oh, geez, Yanetti. They just ordered the witness back. The witness was subpoenaed and summoned to come to court today. They didn't get to him. They ordered them back, so there's still authority. So we will find out on Monday. Let's continue on. She said, go ahead, Mr. Alessi.
Go ahead, Mr. Alessi.
Yanetti.
Oh, geez, Yanetti.
He said, I'm Yanetti.
That was a big compliment, Your Honor. Thank you. Good afternoon, sir. Would you please state your name and spell your last name?
Jonathan Diamandis, Diamandis.
You've also been
Jonathan Diamandis is going to be voir-dired. If any of you are watching ahead in real time and spoil anything that is coming, I'm going to yeet you immediately from the chat. Immediately. Normally the mods are more patient. I am less. So let us get to this voir-dire.
been here all day.
Yes,
Sorry for making you wait.
no problem.
Do you know former State Trooper Michael Proctor?
I do.
How do you know him?
I've known him since middle school, probably the 6th grade.
Ah, were you in the group text? Are you in Proctor's group text? Are you in Proctor's group text? Do you know Michael Proctor? I've known him since the 6th grade. Are you in the group text? Are you in the group text? Oh boy, Miguelina, we should probably let the text crew or the app crew know that one of Michael Proctor's friends is being voir dired. Oh boy. Back that up and I'm going to gain the audio up a little bit. We're going to start over so everybody can process what's happening. Everyone's going to process what's happening.
Wait.
No problem.
Do you know former State Trooper Michael Proctor?
I do.
How do you know him?
I've known him since middle school, probably the 6th grade.
Grew up with him, essentially?
Grew up with him, been friends for 30 years.
Okay, and if you just keep your voice up,
Sure, yeah.
I'm sure other people can hear you, but this
So
old guy.
can we turn off the fans and the air conditioning? Are they all off? We're just going to do that, sir, so that we can get through this a little bit.
Absolutely, sure.
Much better, thank you. So you say you've known him since middle school, elementary school?
Yes.
Graduate high school with him?
Yes.
And are you...
Sir, why do you kind of look like Michael Bublé? I'm very confused. But aside from that, we saw last week, maybe the week before, that the defense had filed a motion saying that they were supplementing their witness list for foundation. And so now we're doing a voir dire. Why? Well, I imagine a lot of this was not turned over. So we need to do a voir dire because it was not turned over. But then we get to see what's happening. So I'm not mad about it.
friends after high school as well?
Yes,
Do you have his cell phone number in your phone?
I do.
Oh,
Have you
boy.
texted with him over the years?
I have.
Oh, boy.
In fact, were you on a group text chain with him
boy.
that lasted a number of years?
Yes.
I would like to show you a document, sir, and I'm going to ask you to read it to yourself, familiarize yourself with it, and then when you're done, look up at me. Okay?
Okay.
May I approach?
Yes.
Would you like this marked for identification first, Your Honor?
Yes.
He's marking for identification the group text. I assume it's the one we saw last trial. Could be different. Don't know. And we are voir diring Proctor's friend, who was on what I suspect is the group text.
Exhibit N for identification.
And now I'll give it back to you. Yes, thank you.
Thank you.
The fan in the background is so difficult. It's just, I'm gaining it back down a little bit. It was so hard to hear. Y'all, I'm going to let the voir dire play out before we chat about it. I am very curious to see what the defense is going to ask. Very curious. And then we will chat about it. But I want to see what they get into first, and I want to see what Brennan asks about first. He's reading through pages of texts. I imagine part of why they're doing this is because these are witnesses they want to use to lay foundation. And so you have to say, yes, I know what this is. Yes, I recognize these phone numbers. You have to actually have a foundation for it. And he's just reading page by page. He's just going page by page by page with all the text messages. I'm very curious how many text messages he's reading. Oh, there were pictures or memes. I can't say they're necessarily pictures, but pages of group chat. I know all of us want the tea. I'm hoping they're going to ask about it. He's definitely shaking his head. I'm going to put this at 1.25 until they start talking, though. Is he reading every single text? He might be.
I think he's all set, Mr. Union.
Thank you.
All
Lauren.
right, we're going to go back to normal.
Sir, have you reviewed that entire document?
Yes.
Does that look familiar to you?
Yes.
What do you recognize it to be?
It looks to be a text chain with a group of my friends that I grew up with.
Okay. And so would all of those friends have been people that you went to high school with?
Not all the same high school, but the same time. Some of us went to different schools.
And you were friends during that era?
Yes.
And you've remained friends for how many years since then?
I mean, we've been friends for 30 plus years, probably.
Do you know precisely when that text chain started?
I do not know when the text chain started.
Months, years?
Years. Definitely years.
And that's a portion, in other words, there's a start
Right, when
time
they all
and
got
an
cell
end time
phones.
to that. But the text chain started before the start time that's listed on that document?
That's correct.
Now, I'd like to ask you about 5 different categories of information that allow you to identify the text chain. First of all, directing your attention to page 1. That is an unredacted version of this. Do you see your phone number on page 1?
I do.
And is that accurate in terms of your phone number?
It is.
Do you have a passcode on your phone?
On my phone, yes, I do.
All right, and have you had that for years?
Yes.
So as of January of 2022, you would have had a passcode to get into your phone, correct?
Correct.
With regard to the typing of text messages, you didn't appear to be too active on this thread, is that correct?
Not from what I see here.
Did you see one entry that you actually did text?
Yes, one.
Okay, and I think these page numbers, they're all numbered. Could you direct us to the page where you actually chimed in? And if I suggested to you, it might be 4 from the end.
One text and all those pages of texts.
And you don't have to read the actual text, sir. I just want to...
Sure. I'm just trying to locate it. Yes, I see it.
Okay, and the time of that, a date and time of that text as it's reflected on this document?
February 2nd, 2022, 12:38 p.m.
Okay. And what you
So I
type...
have a different call.
Oh, I'm sorry. It's, for the record, it's on page...
What's the bottom page number? So what are the last 2?
The court's like, whatever, Yannetti, I'm going to talk to the witness. And he's like, here, Your Honor.
And for the record, reading what is typed there, does that sound consistent with something you might chime in a text message, a text chain of this sort?
I mean, it could be. I have no memory of actually typing it, but
Sure.
that's not something. I mean, it could have been something that I would say. Yeah.
At the very last line of that text, do you mention somebody's nickname?
Yes.
And what nickname is that?
Chip.
And whom do you know as Chip?
Michael Proctor.
Now, going back to the first page, there are a number of other phone numbers there. Have you checked your phone prior to taking the stand today to match those phone numbers with other friends of yours?
Yes.
And if you could, and hopefully you remember them all, can you list by first name only your friends who are included in this text chain?
Sure.
So, yeah. So let's not, if he recognizes it, I don't want to put names out.
Oh,
there.
I don't either, Judge. That's why I was saying first names. But if that's sufficient that he recognizes...
Why don't you refer to the last 2 digits in the phone?
Sure.
I like that
Is
less.
that acceptable, Mr. Brennan?
Do you recognize everyone in the text chain? Yes. I think you leave it at that. Do you recognize all of the numbers of who's in the text chain? And I think you leave it there.
It is.
Okay.
Okay.
And Brennan said that's
You
leave
see,
it be.
I'll list the last 2 digits of the phone numbers that don't have a name associated with them, okay?
Okay.
If I may just have a moment?
Yes.
Yeah, of course. Okay, starting with the phone number that ends in 51. After you checked your contacts, is that a friend of yours?
Yes, it is.
Who was on the text chain?
Correct.
With regard to the phone number that ends in 68, same question. Is that a friend of yours who was on the text chain?
Correct.
And with regard to 45, which is the next one, again, a friend of yours who was on the text chain?
That's me.
Oh, I'm sorry, that is you,
Yeah.
of course. With regard to 95, is that a friend of yours who was on the text chain?
Yes, it is.
And with regard to 93, same question, friend of yours on the text chain?
Yes.
And then there are 3 numbers there, one that ends in 11, one that ends in 46, and one that ends in 82. Do you see that those particular numbers have a nickname associated with them?
Yes.
Those nicknames, do you recognize them as being also friends of yours who are on the text chain?
I do.
And then finally, there is somebody listed as local user. We'll get back to that one.
Okay.
With regard to the other ones that you've just identified, sir, have you texted back and forth with them on those phone numbers over the years?
Yes.
And
Right,
also
this
with
is
regard
foundation.
to this particular text thread?
Yes.
All right. Now, I'd also ask you, with regard to the content of these messages and who said what, and particularly focusing on the one that's identified as local user.
He's just like,
Having read
what
that
do
text
you
chain,
want?
were you able to determine who local user
probably
is?
Proctor.
Yes.
And who is that?
Michael Proctor.
And was that by the content of the messages that Michael Proctor typed that you recognized it?
Yes.
Yep.
And with regard to whether this is a complete, accurate record of what it purports to be, what is your testimony in that regard?
I believe this to be a record of our text chain for this period of time.
Appears to be accurate and complete.
It does.
If I may have a
It's
moment, Your Honor.
foundation. I saw the question, would this witness have been subpoenaed? Yes, by the defense. So yes, he would have been subpoenaed and arrive in court subject to that subpoena as a foundational witness for
Does
this document.
the text message chain that you read fairly and accurately represent the circumstances of the conversation that was going on?
Yes.
Nothing further.
Mr. Brennan?
Good morning.
Morning. Good afternoon.
Morning.
Do you have an independent memory of any of the text conversations in the package that you reviewed?
I do not have a memory of this happening.
Thank you.
All right, so sir, I'm going to
All
ask
right.
you to, you're all set.
Okay.
I'm going to ask you to step down.
Okay. Thank you.
Your Honor, given that
Yes, Dr. B?
unfortunately this witness was not reached by the jury today, I would like him recognized as well.
He has counsel here with him, right? Does he have counsel here with him? All right, sir, you'll make sure your client is here when we need him?
I will do so, Your Honor.
All right, thank you.
My name is Thomas Campbell. My office is in Boston.
And I'll speak with Mr. Campbell in terms of an appropriate time of day. He's been very cooperative.
All right. So, sir, you can leave.
Thank you.
All right, we
and,
have a
thank you, Mr.
next
Campbell.
witness.
We'll see you. We'll let you know when we need you back. It's probably going to be Monday first thing.
Understood.
Thank you.
Sir, watch your step coming down.
All right. We'll hear you, Mr. Yannetti.
So, Your Honor, my understanding is there's an objection, so I'd rather respond to the objection.
I want to hear you as to why this is admissible. Why this is admissible.
Okay, so we went through the first friend of Proctor saying, I recognize this text thread. I recognize these numbers. I recognize that as Michael Proctor, and they're trying to lay foundation for this text thread. There are numerous other individuals on that text thread who were also subpoenaed. So Yannetti is going to make an argument about this being admissible, and I am curious to see what they are trying to do with that. So the other witness who was there will be back Monday, but I'm interested to hear the argument. So we're going to hear the argument first.
So, Your Honor, with regard, I assume we're just dealing with authenticity at this point?
No, we're dealing with both. You're the proponent of the testimony, so let's deal with both.
Okay.
Okay, so we're dealing with admissibility, authenticity, relevancy, all of it. Okay.
All right. So, regarding
How is this
authenticity,
coming
Your
in?
Honor, there are several ways that are either independent or connected with each other by which or through which a party can authenticate text messages. The majority of the case law out there are defendants having appealed judges' decisions to admit text messages offered by the Commonwealth, and the majority of the case law that exists affirm judges' allowance of text messages into evidence. The Commonwealth filed a memorandum in opposition to these text messages being admitted, and not one of the cases cited by the Commonwealth apply here or are appropriate. The case of Commonwealth versus Purdy, in that case, the Commonwealth introduced text messages from computers seized at a massage parlor. The defendant objected that there was no evidence that he had authored any of the, these actually were emails, not text messages, any of the emails that were admitted into evidence. Nobody saw him do it. Nobody saw him type it. And nobody discussed any of the emails with him. But the SJC cited a long-standing rule, including Rule of Evidence 901B1, evidence may be authenticated by direct or circumstantial evidence. And the circumstantial evidence is essentially what we covered here in court today: the appearance of the electronic communications, the content, the substance, internal patterns, or other distinctive characteristics. Commonwealth versus Welch, it was a murder case where a boyfriend killed his girlfriend, was charged with killing his girlfriend, was convicted. The Commonwealth sought to introduce text messages between them, and various text messages from the victim's cell phone were admitted into evidence because, for one reason, they referenced the defendant's distinctive nickname. And in this case, we have a text chain with 3 nicknames, all of whom the witness recognized as being his friends. We have more to
But he says he doesn't remember them independently, which is a problem.
Than in any case I have seen, and also more than in any case the Commonwealth has
Where
cited.
the texts have come from
In this case,
is
we
part of
have
it.
an identification of every phone number pursuant to the last 2 digits. We have an identification of Michael Proctor's message relating to the contents. We have evidence of the witness's cell phone requiring a passcode, meaning that in order for his phone to be active in this chain, he would have had to have unlocked the phone with the passcode, and he testified that what was in the content of the message that he identified as being his
He didn't
is
say that.
consistent with something that
He said it
would
was
have said.
consistent,
And
yes.
not only that, but he adds a fourth nickname, that being Chip, that being Michael Proctor. The Commonwealth, with regard to Commonwealth versus Welch, which is again cited in their memorandum, this opposition, Your Honor, they state what appear to be rock solid black and white legal principles, but when you scratch below the surface and you actually read the case stands for nothing in terms of what they've represented it to be.
Okay.
They stated that in
That's
Welch,
unhelpful.
the court must find that each and every communication was authored by the individual member of the group. That's just plain false. The case doesn't say that at all. It's nowhere in that case. And in fact, the messages were let in,
Interesting.
again, because of the circumstances and the content of the messages. Commonwealth versus Raposa, another case that they cite. The defense sought to call a neighbor to testify that he had seen the victim alive after the defendant had confessed to having shot him, another murder case. The problem was that the neighbor denied making the statement, so the defense wanted to call the neighbor for the sole purpose of impeaching him with his prior statement that he supposedly made to the police and use that statement as substantive evidence. So in that case, the defendant wanted to use an out-of-court statement for its truth. It was rank hearsay. That case had nothing to do with text messages or statements used to show state of mind or electronic communications. But somehow it makes its way into the Commonwealth's memorandum. Commonwealth versus Rajiv R., which is the second to last case that they cite, that dealt with a search warrant done at a juvenile's home. The police officer in that case was allowed to testify to what he was seeking, which was the goal of the search warrant, a firearm allegedly in the juvenile's possession. And he was also allowed to testify to what the juvenile's mother did during the execution of the search warrant, which is she directed the police to the juvenile's bedroom.
Okay.
The Commonwealth cited that
But that
case
would be
to say
for the
you can't
truth.
use hearsay when trying to prove a Bowden
Possession?
defense or present a Bowden defense. That case had nothing to do with Bowden.
It sounds like possession.
The evidence was admitted to explain what the police were doing in the home. So it's a situation where, there are times when, the police stop somebody on the street or the police get a search warrant and then they show up at a home. And rather than just have them magically appear at the home with the warrant, the police are allowed to give some circumstances as to how they got there. Nothing to do with Bowden. It's just giving the jury a fuller picture. Yet it was represented to you by the Commonwealth that, geez, this is a Bowden issue and you can't use hearsay to present a Bowden defense. Commonwealth versus Sullivan, exact same situation. Testimony was admitted about DNA on evidence matching the defendant's DNA from a national database. The Commonwealth cites three principles. It's almost like they're setting a standard down that the court is supposed to follow with three factors. But again, none of the three principles that the Commonwealth cites is found in Sullivan at all. They're not even mentioned in the case. They're simply made up and put in a memo to ask this court to do something that the case does not support. And again, it has nothing to do with Bowden. So now we come to the arguments about the fact that the Commonwealth is claiming that these statements are hearsay. They're not. These statements contain insults of my client. I'll be kind and just mention the word.
We know what they say.
I read them.
Yes.
We know what they
Okay.
say.
Well, Your Honor, if you're going to allow this into evidence, I'll stop talking. Otherwise, I have to make my argument.
I understand what you mean by insults.
Okay. So I won't even mention them.
So what are they being offered for?
The Commonwealth is essentially arguing that we're offering these text messages to show that the insults were true.
Which is not
That's
the
a silly
case.
argument. Obviously,
So it's
they're
not hearsay because
Hearsay has
they're not being
three
offered for the truth.
components. These are all statements out of court. None of them are offered for the truth of the matter asserted. None of them. Even the statement when Michael Proctor says that the homeowner's not going to catch any grief because he's a Boston cop.
Not offering it for the
We
truth.
don't know if that's true or not true.
We're not offering it for
It's
the truth.
offered to show that Michael Proctor believes it's true. He's the lead
state of
investigator in
mind.
the case. He has input into the case. He can decide who's investigated or not investigated. At least that's our argument. It's all consistent with our defense. It's offered to show his state of mind. Everything that he says is offered to show his state of mind and to show his bias. He, as the lead investigator, his bias in what he does or doesn't do. And in fact, Mr. Brennan said at sidebar earlier when we started this conversation that Bowden deals with what was done or what was not done. We're entitled to explore what was not done and not done, and we're entitled to explore why. We have evidence of why. We have Michael Proctor's words about why he did or didn't interview people separately, why he waited, for instance, a year and a half to interview a plow driver who was out there on January 29th, why he treated some people with kid gloves and other people with brass knuckles. He's stating it in these text messages. She's going to go down for this. We're going to pin it on the girl. We're going to make sure that there are some serious charges. She's effed. Those are what he says about, those are the statements he makes about Karen Reed in the infancy of this investigation. And to the contrary, is anything going to happen to Brian Albert?
Nope.
Nope. He's a Boston cop too. These are all statements about Michael Proctor's
Thanks,
state
Yannetti,
of
for giving
mind.
us another nope.
The prosecutor and I have been over the statements. I realize he's objecting to the admission of these statements. I don't think he has a legal argument that passes muster to do that, but should the court allow them in, we're agreed on everything except for 3 entries, which I think we could deal with pretty quickly. And unless the court has questions, I'd rest on that.
No, but I'd appreciate a copy of whatever you've agreed upon.
Okay.
So it's been a long day for staff, so I don't need to sit here and go through each one. Just get me a copy of what you've agreed to.
Okay. So this is the only marked copy. I'm happy to hand it to the court.
And you can take care of it and email it in.
We'll do that. Thank you, Ron.
She's
So,
scan
Mr.
it.
Brennan, I'd like to hear you on admissibility. I haven't decided admissibility, and I'll hear you on authentication.
All right, we're going to hear from the prosecutor on both admissibility and authentication. The only reason this would be an issue is if they do not call Proctor. We're not arguing this if they call Proctor.
On the first
If they
issue
call Proctor-
of authenticity,
Well, if they call Proctor, he can be confronted with them and explain them. If they don't call Proctor, it becomes, well, more of a conversation.
this witness has no memory of any of the text messages. I think it's fair to conclude he's on the text message string. He recognizes the people on it, but there is no authenticity if he doesn't recognize them. The person that could best authenticate these text messages is Michael Proctor. This witness does nothing as far as identifying the individual text messages and whether they're reliable, whether there's been any additions, deletions, whether in sum and substance this is part of the conversation. Notably, I think, according to the questioning by Attorney Yannetti, he's made one comment at the end of the string that really has nothing whatsoever to do with the text messages that are at issue. So authenticity, I don't believe this witness reaches that conclusion for them. Regarding admissibility, I do not dispute that in the right context, these text messages are admissible. If there is an investigator in a case that makes derogatory remarks about an accused, I can't say that doesn't go to bias, nor do I reject the idea that it shows an unfairness or a motivation. But really, you need to put that in context, and I think Attorney Yannetti highlighted that. He says that this is not hearsay, it's how he thought or whether it affected a particular part of the
He
investigation.
said state of mind.
It may have, it may not have. Even if he denies that it affected his investigation, it's still an appropriate question to ask just because that type of negative commentary, inappropriate commentary was made. But to explore the state of mind and put it in context, you need to ask the person that you're accusing of having the bias. Because perhaps it did affect the bias. Perhaps the person was very biased and made decisions based on that animus. Or perhaps the person made negative comments but had nothing whatsoever to do with the investigation. It is surmised to say because these comments were made, a witness was not investigated, or there was some other amorphous, undefined ill that happened. That's the whole reason why the witness who made the comments should be confronted with the comments they made so the jury can fairly assess, is this relevant, is it material, and what is the value of it? I am not opposed to the admission of bias against a witness, especially a police officer, but it should be against that witness because they need to have the opportunity to admit, deny, define, accept, and explain. By putting these messages in with sidestepping, calling Mr. Proctor, they are trying to gain the advantage of putting information in front of the jury that has no context, suggesting it has a value that has not been defined, and then, as Mr. Yannetti just did, making an argument that because the comment was merely made, that therefore there was a consequence, and specify a consequence where there's no factual basis to conclude. Because he made a derogatory comment, he didn't investigate or speak to a plow driver for a year and a half. That defeats the purpose of defining the value for which this is being omitted. I do have some issue that it's really not under the context of Bowden, because this doesn't have to do with the adequacy of a police investigation. It has to do with bias. And that
Doesn't
purely
bias go
is
to the
state
adequacy?
of mind of the person who made the comment.
It does go to state of mind.
I would not get in the way of confronting the witness about their bias if they were called to the stand. But to put it in this way invites speculation, it invites manipulation, and it invites a party on either side to portray this in a way that is not factually viable. It will be distracting, confusing for the jury, and it could be unfair for either side because it will lead to arguments about what it means without a factual basis. And so my position is I don't necessarily disagree that it's relevant, but it should come through Michael Proctor. And if the defense wants the value, they should call Michael Proctor.
Okay. Mr. Yannetti, do you want to respond?
I know we're the hour's late, and I won't belabor the points. I would state the following very as succinctly as I can, which is, yes, it goes to bias, but it also goes to the adequacy of the evaluation.
I don't disagree with him.
The two concepts are intertwined. If you're biased or exhibit bias, the defense should be able to argue that the investigation was not adequate. I would note Mr. Brennan is not sitting at defense counsel table in this case.
True.
We appreciate the offer to help us with strategy about which witness we should call, but that's solely the province of the defense to determine.
Oh, Yannetti, I've missed some of your arguments, sir. It's more of a velvet snark, right? It's Yannetti coming through at the end of the day with some velvet wrapped snark at Hank Brennan. I'm not mad about it. I'm not. The jury's out. It's not heavy handed. That's funny. I'm not mad. I'll allow it. This is why I'm not a judge, because your rulings can't be on vibes and whether or not you're amused. But mine are at the moment. I'll allow it. Go on, Yannetti. I rewind. We'll let you do it again.
The offer to help us with strategy about which witness we should call, but that's solely the province of the defense to determine which witness we want to use to authenticate and admit text messages. That's our choice. And we should not be deprived of that choice because Mr. Brennan thinks there's a better witness that should have introduced the text messages. There is no rule. There's no best witness rule in this case. I believe my co-counsel has already made that argument in another circumstance. His arguments, Mr. Brennan's arguments, go to the weight, not the admissibility. He is fully entitled to cross-examine this witness about all of the points that he raises. And in conclusion, Your Honor,
No, he would ask that witness about Proctor's state of mind, and it would be speculation. He can't actually, though. No, that he can't do.
Claims that we have not called Michael Proctor. I think that's the whole impetus for this objection, so that we will call a witness that they do not have confidence in to call themselves. It's unheard of in a murder case that you don't call the lead investigator, but that's what's happened in this case. We should not be forced to call Michael Proctor so that Mr. Brennan can then cross-examine him and lead him through basically his entire closing argument. He is entitled to call Mr. Proctor in rebuttal. He has every right to call Mr. Proctor
We are at a
again.
blinking contest.
I would rest on that. Thank you.
We are at a blinking contest. I said this, I don't know when I said it, but I said it during this case. Are we going to end up in a you blink first with regard to who calls Proctor? And that's exactly where we're at. Who's gonna blink? All right.
Okay. And just the very last thing, there's Commonwealth's motion for reciprocal discovery. Is there any objection to that?
Yes. It's not in compliance with Rule 14.
Okay.
We don't have any written communications with Ms. Dever, and they've asked for all oral communications to be reduced to writing, to be turned over. That's not in keeping with Rule 14.
All right, so you're saying two different things. So you don't, this information doesn't exist because she has not had communications with you, right?
Written communications do not exist. I'm not saying two different things. Written communications do not exist. They also ask secondarily for all oral communications to be reduced to writing. And we have no obligation to do that. We have no intention.
All right, so I'll get a decision out on that before 4:30, and I'm going to do a little more research on the text messages. Want to be heard, Mr. Brennan?
I thought you were standing up, Your Honor. No.
Oh, no, okay. All right, I'll see everybody Monday morning.
Thank you.
For the court, please.
And with that, we are out at the end of day 24. A lot of you had a question about the other witness that was excused, so I'm going to back up. Dr. B came in and asked me several things, so I will back up and we will look at that one more time when Dr. B walked in before I do our summary for today. But then we will do a summary, and then unfortunately I'm going to have to bounce. I'm not going to have a lot of time for questions today because Dr. B walked in and was like, "Are you almost done? Because I need you." All right, let's see what
All right, thank you.
that last part was.
My name is Thomas Campbell.
Just, you're all set.
Okay.
I ask you to step down.
Okay, thank you.
Your Honor, given that unfortunately this witness was not reached by the jury today, I would like him recognized as well.
He has counsel here with him, right? Does he have counsel here with him? All right, sir, you'll make sure your client is here
That
when
was
we
it.
need him?
I will
Yeah,
do so.
your client will be
Thank
back.
you.
My name is Thomas Campbell. My office
Right.
is in
Okay.
Boston.
Ordered back.
And I'll speak with Mr. Campbell in terms of an appropriate time.
Perfect.
He's been very cooperative.
All right. So, sir, you can leave,
Thank
Okay.
you.
right?
So,
And,
yeah.
Thank you, Mr.
Counsel for the
Campbell.
witness.
See you. We'll let you.
Yeah, I'm not reading anything into that. If you get called as a witness, in this case because you're connected to Proctor, the first thing I would say to you, if I liked you, was get an attorney. Get an attorney and do not deal with anyone directly. There's a federal investigation. There's a second time retrial. I would 100% say if anything's going to subpoena, get a lawyer. I 100% would. There does not mean there's anything wrong, anything up. It is 100%. There is too much shit swirling around Proctor to not have a lawyer to make sure that people aren't A, harassing you, B, asking you for things that you aren't supposed to give them, and C, violating your rights that you have. 100% ask a lawyer. 100% ask a lawyer. Lucy said, even if they have nothing to do with this, by the fact that they were subpoenaed and they know Proctor, they have something to do with this. There's nothing nefarious with that. They were on a text thread, which makes them tangentially relevant because they were on a text thread. 100% get a lawyer. Nothing, it doesn't mean you did anything wrong. It doesn't mean you have anything to hide. It doesn't mean that you did anything at all other than exist on a text thread, which a lot of you do. A lot of you exist on a text thread. If somebody in that text thread went off the rails, I would tell you the same thing. So your friend from when you were 6 years old went off the rails and you're on a text thread with them and they said something tangentially about it and they're going to end up in trial in a federal investigation, call a lawyer. Call a lawyer. Call a lawyer. That is it. Doesn't mean that you've done anything wrong, but you're going to be pulled in. And if you are pulled into court process, even if you don't need to have a lawyer in court with you, call and consult with a lawyer. That's different if you're just driving down the street and you see a car accident and you pull over and say, hey, I saw what happened. It was this, this, this. That's different. But when people are starting to get into phones and getting into your cell phone, if anybody wants to get into your cell phone, call an attorney. Call an attorney. Also, I hate group texts. I do. People put me in group texts and I'm like, Nope. So with this, you absolutely would. I have no shade for anyone. And I'm sure there will be wild speculation. Protecting your rights does not mean that you've done anything wrong. However, take a look. For those of you that think that Karen reads, how many of you think that Karen reads, and then we'll do a summary. How many of you think that Karen reads clips that were interviewed were taken out of context by the prosecution and put in a light that does not accurately reflect what she was saying? Just put a 1 in the chat if you think that the prosecution took Karen Reed's interviews with the media out of context and portrayed them in a way that does not accurately represent them. Right, there are like 50,000 of you putting 1 in the chat. Okay, imagine if that's a text on your cell phone that you didn't have to give to someone. That's why you get a lawyer. That's why you get a lawyer. 100%. Imagine that that's your group text. Imagine that that's your group chat. Imagine that that's a meme that you sent to your friend. Right. And imagine you never had to turn it over. But you didn't know that because you didn't ask somebody. That's why you get a lawyer. That's why you ask someone. That's why you find someone to ask. Because if you don't have to, you don't. Now, I also have to put on the caveat, asterisk, I'm a former prosecutor. So the more information that people are going to put on out there, the prosecution's going to use it. 100% the prosecution's going to use it. The more information you have on Facebook, the memes you sent, all of it, the prosecution's going to use it. And likely in the light most favorable to their case. Unless it is completely obvious that that's not how it's meant. It's not going to be used in the light most favorable to you. It's not going to be used in the light most generous to you. No. So hopefully that example helps. Let's do a summary of today. And then I'm going to have to bounce. So at the end of today, we had a voir dire of one of Michael Proctor's friends. The defense had filed a motion maybe last week, maybe the week before. The days are all running together. The defense had brought a motion which I suspected included some of the people who might have been on Proctor's text thread. And they wanted to call these witnesses to authenticate the text threads or the text chain of Michael Proctor. What does that mean? It means to bring a document into evidence and say, this is what it purports to be. These are texts. These are texts from Michael Proctor. To prove that those are texts from Michael Proctor, somebody has to say, yes, these are texts from Michael Proctor. And the natural next question is, so bring in Michael Proctor. seems the defense is trying to avoid bringing in Michael Proctor because they said in their argument at the end of the voir dire, if the prosecution wants to call Michael Proctor on rebuttal, then they can. It seems from the argument we've seen today, the defense wants to authenticate those texts and bring them in so they can argue them without calling Michael Proctor, which I'm going to have to think about a bit more because they are trying to bring in evidence to Michael Proctor's state of mind, but they are not barred from calling Proctor as a witness. I'm going to have to think about that and research it a bit. It's different when it comes to like Karen Reed's interviews. The Commonwealth cannot call Karen Reed. She's an unavailable witness. So they can bring in other things for state of mind. But when it comes to Proctor, he's an available witness to be called. I don't know if you can just bring in the texts to go to state of mind without calling Proctor. So I'm going to need to think about it as well. But the defense is arguing that they can authenticate the text and say, hey, this is the text thread. You can authenticate these texts through the friend. And the friend can say, yeah, this is a text thread. Yeah, that's Chip. That's Proctor's phone number. These are Proctor's texts. But that friend only had one text in the thread and said he doesn't remember it. He said, we've had this group text running for years. These are people I've known since like, what, 5th, 6th grade. This is a friend group that is ongoing 30 years of a friend group. And so, yeah, I don't remember that exact text, but yeah, I know these numbers on the text. Yeah, I recognize them. This is the friend group that's on this text. And the Commonwealth is arguing, if you want to bring in Michael Proctor's texts, you need to bring in Michael Proctor. Yannetti is arguing these texts are not hearsay. They're not being offered for the truth of the matter asserted because they're being offered to state of mind and bias, and they're authenticated by the friend. And Yannetti argued, and I disagreed with his argument on this point, Yannetti argued, if the prosecution wants to cross-examine the witness about what was meant by those texts, he can. He can't. He can't. You can't cross-examine the friend as to what Proctor meant by the texts. It's speculative. The only person who can be asked about what Michael Proctor meant by the text is Proctor. Now, the friend can be asked, what did you mean by your text? But you cannot cross-examine the friend as to what Michael Proctor said in the texts. And Yannetti argued these are not being offered for the truth of the matter asserted. They're not being offered to prove true what Proctor said. They're being offered to show what he was thinking. And then they can argue that for their Bowden defense, that this shows his state of mind in this investigation, why he investigated some, why he didn't investigate others, why he, said, oh no, the girl's fucked. Oh, but isn't the homeowner a Boston cop too? Isn't he going to catch some shit? Nope. That's what the defense wants to put in, it seems, without calling Proctor. And again, I don't know if the court's going to allow it because no one can then be cross-examined about Proctor's state of mind because they're just texts. But I want to look at what the cases say in Massachusetts too. This is going to go over the weekend. The court's not going to give a ruling on it. And again, Brennan did the same argument that we saw from him before. I'm not trying to block these texts. But if you want to put the text in, you got to call Proctor. And the prosecution might be right on that because you can't cross-examine the paper. And it's interesting to me that the defense is looking for a way to bring the text in without bringing in Proctor. Because Proctor is a whole bag of worms, just an entire bag of worms. I'm interested to see what the judge is going to do with this. I am going to look at this a bit more. We will have an answer on Monday. We had another witness that was ordered back. We will see what that witness has to say when they are called in. It seems on Monday. And we are off and away into the defense's case in chief. Just the one witness today with another witness ordered back. And now getting into maybe the defense trying to see if they can't, or that's not the right phrase. The defense is exploring whether or not they can get Proctor's texts in without bringing Proctor in. But if they do that, well, it's going to be interesting to see how that all plays out. We will have to wait and see. All right. y'all.
To know when we need you back. It's probably
Let's see. That was the rule. Court is done for the day. The court told everyone she would see them on Monday. She's going to have a ruling on turning over statements by the end of the day, chat, just for clarity. Ruling on turning over statements from that first witness that was ordered back, not about that second witness. It was about the first witness. That ruling is going to be faster. So we're at the end of the day. I apologize that I have to jam so close at the end of the day, but a lot of you are asking, why wouldn't the defense want to call Proctor? I don't know what the strategy is here. Maybe to not let him explain. Maybe to not open up the can of worms. But it seems that the defense is looking for an opportunity to bring in the text without bringing in Proctor. And Mega Waffles and a lot of you said, it sounds like Brennan is daring the defense to call Proctor, which makes me think the defense doesn't want to. Yeah. Proctor's a fucking can of worms for everybody. I think he's a worse can of worms for the prosecution, but that's just me. You let me know what you think about who he's a worse can of worms for. I think he's a worse can of worms for the Commonwealth. Because I think the jury's going to be like, huh, you're here now. But bringing in the text messages for state of mind when the witness is available is going to be an issue, because I heard nothing about them saying that the witness was unavailable. Nothing. And with Proctor, you could keep the direct fairly limited, I would think. But we are now in a staring contest to see who's going to blink first and who's going to call Proctor, if anyone. Oh God, we're at a proper use of what, if any. Whom, if anyone, is going to call Michael Proctor? And it's interesting to see that the defense is giving themselves options. I think the defense is fully aware that they may have to call Michael Proctor, and they are seeing if this is another avenue for them. Curious. It's curious. Chat, thank you for hanging with me today. Thank you for being here. Thank you for being law nerds. I will keep you up to date depending on my birds are chirpy. Yes, they are. My window's open. I will keep you up to date on what we were doing, but I need to go check in with Dr. B. So members, I will let you know in the member spaces when we are recording podcast. It's just going to depend on, well, family things. So I will talk to you soon. I will let you know in the member spaces, and I will see you guys in court on Monday. Don't forget to get the Law Nerd app, members. We are going to be recording a podcast at some point. I just don't know when that is yet. So I will see you soon. Take care, you guys. Have a good weekend. Stay safe, and I will see you soon. Let me grab our outro and say goodbye, and then go check in with Dr. B. All right, everybody. I'll see you in court on Monday. Thanks for joining me on this stream. If you don't want to miss a moment in court, you need the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android where I can keep you in the loop with everything happening in court and, of course, when the jury has a verdict. So if you don't want to miss a moment of this trial coverage, make sure you get the Law Nerd app. Thank you for being here, and thank you for being a Law Nerd.